Introduction. Thank you for choosing Kaplan for your educational needs, and welcome to the Series 63 License Exam Manual LEM. We understand that you are trusting us to help you advance in your securities industry career. We have written this manual and any supplemental resources you may have purchased by first collecting and clarifying exam-related content. Exam content is provided for you in an adult learning framework that provides the tools you need to pass your exam on the first try. Some of these special tools include exam-focused questions and content to maximize exam preparation, an interactive design that integrates content with questions to increase retention, and integrated Securities Pro TM HuBank exam preparation tools to sharpen test-taking skills. Please take the time to read this introduction. It will provide you with some information and insight that will likely prove helpful as the study process unfolds. Why do I need to pass the Series 63 exam? State securities laws require most individuals to pass a qualification exam to sell securities in their states. Almost all states require individuals to pass the Series 63 exam as a condition of state registration. The North American Securities Administrators Association, NASA, created the Series 63 Uniform Securities Agent Law Examination to meet that requirement. Are there any prerequisites? Although there are no prerequisites for Series 63, most students will also be taking a FINRA exam that must be completed in addition to the Series 63 before an individual can become registered with a state. You may take either exam first. We recommend taking the FINRA exam first, but must complete both satisfactorily before you are fully licensed. What is the Series 63 exam like? The exam is delivered on a computer. The session begins with a tutorial on how to take the exam. The Uniform Securities Agent Law Examination consists of 6 to 5 multiple-choice questions. The questions are prepared by the North American Securities Administrators Association, NASA. Applicants are allowed 7 to 5 minutes to complete the test. Of the 6 to 5 questions on the exam, 60 will count toward the final score. The remaining 5 questions are being tested for possible inclusion in the test bank for future use. These questions may appear anywhere in the exam and are not identified. What score must I achieve to pass? You need a score of at least 72%, 43 of 60 correct, to pass the Series 63 exam and become eligible for registration as a securities agent. After your exam, you will receive either a notification that you passed, but no score, or a failing score with a printout that identifies your performance in each function area. What topics will I see on the exam? As far as exam coverage is concerned, the official title of the exam tells the story. This is the Uniform Securities Agent State Law Examination. Almost every question will deal with some aspect of state securities laws and practices prohibited or required by those laws. There are only a few questions about securities products, but you will need to know enough about them to understand their suitability for different clients. The questions you will see on the Series 63 exam do not appear in any particular order. The computer is programmed to select a new, random set of questions for each exam taker according to the preset topic weighting of the exam. Each Series 63 candidate will see the same number of questions on each topic, but will see a different mix of questions. The Series 63 exam is divided into the following 2 major categories. Category 1, State Securities Acts and Related Rules and Regulations, 36 questions, 60% of the exam. Category 2, Ethical Practices and Fiduciary Obligations, 24 questions, 40% of the exam. How is this course structured? As educators, we are presenting the material in the optimal sequence to ensure your best comprehension. That means dividing NASA's large categories into smaller, easier-to-digest pieces. The course consists of 8 units, each devoted to a particular area of study covering content that you will need to know to pass your exam. Each unit consists of one or more lessons. Each lesson corresponds to specifically identified tested content. These lessons are further divided into learning objectives, enabling the student to absorb the content in an easy-to-handle portion. For students attending one of our classes, live or online, the class lecture will follow the sequence of these units. The license exam manual consists of 8 units, each devoted to a particular area of study that you will need to know to pass the Series 63. Each unit is divided into study sections devoted to more specific areas with which you need to become familiar. The Series 63 License Exam Manual addresses the following topics. Unit 1, Definitions under the Uniform Securities Act, Category 1. Unit 2, Regulation of broker-dealers and their agents under the Uniform Securities Act, Category 1. Unit 3, Regulation of investment advisors and their representatives under the Uniform Securities Act, Category 1. Unit 4, Securities and their issuers, registration and exemptions, Category 1. Unit 5, Remedies and administrative provisions, Category 1. Unit 6, Communications with customers and prospects, Category 2. Unit 7, Ethical practices and obligations, Category 2. Unit 8, Customer protection, Category 2. Please note, the first 5 units approximate the topical coverage in NASA's Category 1 and the final 3 units do the same for Category 2. Your primary study tools are the Series 63 License Exam Manual, LEM, your textbook for the course, and the Securities Pro TMQ Bank. Your study calendar is the recipe for success that shows you what ingredients to use and when to use them. It will also describe the use of the other study tools you may have in your package, including the class. Best practices: using the study calendar. On your dashboard, you will have a study calendar that you can customize to your personal schedule. The study calendar helps you plan your use of all the other study tools you may have in your package, including the class. Set up your study calendar so that you will know what to do each day. The calendar gives you step-by-step details to optimize your learning experience. Think of it as a roadmap. If you don't take any detours or shortcuts, you will arrive safely at your destination, a passing score. Using the LEM. The License Exam Manual, LEM, is your textbook for this course. Reading the LEM carefully will help you succeed. Reading material several times may be useful. Sometimes out of necessity, a term or phrase is used prior to its formal introduction in the course. If needed, you can consult the glossary for the definition or the index to locate a more complete discussion. You also may have access to a PDF copy of the LEM. If so, we strongly recommend that you download it because you can use the search function, Ctrl+F, to find specific terms quickly. In addition to the regular text, the LEM also has some unique features designed to help with quick understanding of the material. When additional emphasis is valuable to your comprehension, the following distinctions are made. Take note. Each take note provides special information designed to amplify important points. Test topic alert. Each test topic alert highlights content that is likely to appear on the exam. Example. Examples provide practical applications that convert theory into understanding. These are quick, interactive, real-world illustrations of what you just read. Examples ensure that you understand and retain the material. Practice question. Within each learning objective, LO, there may be one or more practice questions. We've designed these questions to give you a view of how the topic being discussed might be presented on the exam. Knowledge check. Upon completing a lesson, there is an opportunity for you to measure your comprehension. These short tests reinforce the essential material covered in that lesson. Complete the knowledge check and review explanations for all questions, whether you answered them right or wrong. Additional study resources. To accompany and supplement your LEM, your study package may contain additional study resources. Be sure to spend some time on your dashboard, view the best practices video and PDF, and understand all that is available to help you study. Using the Securities Pro Q Bank. Coordinating with the LEM, the Securities Pro Q Bank includes a large number of questions that are similar in style and content to those you will encounter on the exam. You may use the Q Bank to generate exams for a specific unit or combination of units. The study calendar will prompt you to do this. Carefully review all rationales. Use the LO number to locate additional or related information on the question's topic in your LEM. If needed, do an additional test of the suggested length on any topic on which you score under 60%. Do not become too overwhelmed or bogged down in any one unit. You don't want to lose sight of the finish line because you're having trouble with one hurdle. Keep moving forward. It's a steady pace that wins the race. View rationales after each question initially and spend time studying each rationale to learn the concepts. Later, you will want to create simulated exams in which scores and rationales should be viewed at the end of each exam. Perfection is not the goal during the reading phase. While scores in the mid to high 60s are good initially, aiming for at least 72% is best. You will also use the Q Bank to create assigned weighted simulated exams that mimic the proportional composition of the real exam. The study calendar specifies the ideal number of tests, but there is no upper limit on how many you can create. One thing you should know about the Securities Pro Q Bank is that the answer choices are scrambled each time you take a test. That is, if the first time you saw a specific question, the correct answer was choice A, that statement might be choice D the next time. Please keep this in mind if you need to contact us regarding that question. Using fixed exams, checkpoint and midterm exams. Each unit is followed by a checkpoint exam, and at the approximate midpoint of your studies, there is a midterm exam. These are fixed, unchanging exams. That is, unlike Q Bank exams that include randomly selected questions, the checkpoints and midterm are the same for everyone. They are designed to check your progress before advancing to the next unit. Challenging questions have been specifically selected based on their topical coverage, and they tend to match the average difficulty of the real exam. Because they are fixed, unchanging exams, they may be taken only once, but can be reviewed as often as desired. Be sure to take these when prompted by your study calendar. If you do not pass a checkpoint exam, we recommend you create a Q Bank exam of the same length using questions from that unit. Regardless of your score on this additional test, move on to the next unit. Practice and mastery exams. You may also have a fixed practice and mastery exam. These exams are designed to closely replicate the true exam experience, both in terms of the degree of difficulty and topical coverage. They provide a score and diagnostic feedback, but you will not be given access to or be able to obtain from Kaplan correct answers or question explanations. The practice and mastery exams are sound indicators of potential actual exam scores. The better you do on these exams, the more likely you are to pass your actual exam. These exams may be taken just once and must be completed in one sitting. Note: after completing the practice and mastery exams, be sure to review your performance tracker so you can identify areas of weakness. You can then create custom quizzes focused on topics as needed. Also, review your LEM for additional help. We recommend taking the practice exam shortly after a scheduled class and the mastery exam 2 to 3 days before your exam date as indicated in your study calendar. Using the video library. You may also have access to various topics from our video library. These short, engaging videos cover key topics from your manual. If you have access to our video library, please review the topics as you complete your assignments in the study calendar. Because many of the videos are not exam-specific, you may encounter material that is not covered in your license exam manual. Just skip ahead until the slide shows something familiar. Exam Tips and Content Updates link. Don't forget to regularly check the Exam Tips and Content Updates icon located on your dashboard. Information about rule and regulation changes and new information regarding your exam will be posted there. The Corrections icon on your dashboard provides information about corrections to any errors in the text. Try as we may, errors are difficult to avoid in a text this large. How much time should I spend studying? Plan to spend approximately 40-50 hours following the study calendar. Spread your study time over the month before the date on which you are scheduled to take the Series 63 exam. Your actual time may vary depending on your reading rate, comprehension, professional background, and study environment. How well can I expect to do? The NASUD exams are not easy. You must display considerable understanding and knowledge of the topics presented in this course to pass the exam and qualify for registration. We carefully designed the questions in our QBank to simulate the actual exam. The wording of QBank and actual exam questions might be somewhat different, but if you understand the subject matter, you will be able to find the correct response when you sit for the test. Another important point is that our QBank questions are constantly updated to stay current with rule changes and, to the extent possible, with new topics as they are added to the Series 63 exam. New topics added to the QBank might not be covered in our LEM. In these cases, a thorough rationale follows the question to help you capture and retain the information you need. We identify those questions with the following notation following the explanation. This question deals with material not covered in your LEM, but it relates to recent rule changes and or student feedback. Because complex questions require you to link different concepts together to arrive at a correct answer, dealing with questions not directly addressed in the LEM will help develop that skill. If you study diligently, complete all sections of the course, and score consistently over 82% on the simulated exams, you should be well prepared to pass the exam. However, it is important for you to realize that merely knowing the answers to our questions will not enable you to pass unless you understand the essence of the information behind the question. Test-taking tips. Passing the exam depends not only on how well you learn the subject matter, but also on how well you take exams. You can develop your test-taking skills and improve your score by learning a few test-taking techniques. Read the full question. Avoid jumping to conclusions by watching for hedge clauses. Interpret the unfamiliar question. Look for key words and phrases. Identify the intent of the question. Memorize key points. Use a calculator. Avoid changing answers. Pace yourself. Each of these techniques is explained below. Read the full question. You cannot expect to answer a question correctly if you do not know what it is asking. If you see a question that seems familiar and easy, you might anticipate the answer, mark it, and move on before you finish reading it. This is a serious mistake. Be sure to read the full question before answering it. Mistakes are often made when assuming too much or too little. Avoid jumping to conclusions by watching for hedge clauses. The questions on NASUD exams are often embellished with deceptive distractors as choices. To avoid being misled by seemingly obvious answers, make it a practice to read each question and each answer twice before selecting your choice. Doing so will provide you with a much better chance of doing well on the exam. Watch out for hedge clauses embedded in the question. Examples of hedge clauses include the terms if, not, all, none, and except. In the case of if statements, the question can be answered correctly only by taking into account the qualifier. If you ignore the qualifier, you will not answer correctly. Qualifiers are sometimes combined in a question. Some pairs that you will frequently see together are all except and none except. In general, when a question starts with all or none and ends with except, you are looking for an answer that is opposite to what the question appears to be asking. Interpret the unfamiliar question. Do not be surprised if some questions on the exam seem unfamiliar at first. If you have studied your material, you will have the information to answer all the questions correctly. The challenge may be a matter of understanding what the question is asking. Very often, questions present information indirectly. You may have to interpret the meaning of certain elements before you can answer the question. Be aware that the exam will approach a concept from different angles. Look for key words and phrases. Look for words that are tip-offs to the situation presented. For example, if you see the word prospectus in the question, you know the question is about a new issue. Sometimes a question will even supply you with the answer if you can recognize the key words it contains. Few questions provide blatant clues, but many do offer key words that can guide you to selecting the correct answer if you pay attention. Be sure to read all instructional phrases carefully. Take time to identify the key words to answer this type of question correctly. Identify the intent of the question. Many questions on NASA exams supply so much information that you lose track of what is being asked. This is often the case in story problems. Learn to separate the story from the question. Take the time to identify what the question is asking. Of course, your ability to do so assumes you have studied sufficiently. There is no method for correctly answering questions if you don't know the material. Memorize key points. Reasoning and logic will help you answer many questions, but you will have to memorize a good deal of information. Some memorization will be automatic as you go over the material and answer questions. Some you will simply have to do systematically. Use a calculator. It is unlikely you will be required to do any calculations on the Series 63 exam. Any math required to answer a question will be simple math. Add, subtract, multiply, and divide. We recommend using a calculator for math. You may ask for a calculator or ask if you can use your own. If using your own, only simple math functions are allowed. Add, subtract, multiply, and divide. Avoid changing answers. If you are unsure of an answer, your first hunch is the one most likely to be correct. Do not change answers on the exam without good reason. In general, change an answer only if you discover that you did not read the question correctly or find new or additional helpful information in another question. Pace yourself. Some people will finish the exam early and some do not have time to finish all the questions. Watch the time remaining carefully. It will be displayed on your computer screen, and pace yourself through the exam. In most cases, the questions are delivered on a bell curve of difficulty. That means the test starts and ends with easy questions. The middle 50% or so of the test contains more difficult questions than the first and last 25%. Do not waste time by dwelling on a question if you simply do not know the answer. Make the best guess you can, mark the question for record for review, and return to the question if time allows. Make sure that you have time to read all the questions so that you can record the answers you do know. The exam. How do I enroll in the exam? To obtain an admission ticket to a NASA exam, you or your firm must file an application form and processing fees with FINRA. To take the exam, you should make an appointment with a prometric testing center as far in advance as possible of the date on which you would like to take the exam. Prometric Testing Centers is the provider of proctoring for FINRA-administered exams. You may schedule your appointment 24 hours a day, 7 days a week on the website. You may also reschedule or cancel your exam, locate a test center, and get a printed confirmation of your appointment. What should I take to the exam? Take one form of government-issued personal identification with your signature and photograph as issued by a government agency. No personal items, food, or drinks, including coffee and water, are permitted inside the testing room. Personal items include, but are not limited to, pens, pagers, cell phones, watches, hats, non-medical electronic devices, outerwear, purses, and wallets. Personal items must be kept in your assigned locker or returned to your car before the start of your exam. As the testing vendor is not responsible for any personal items, They encourage you to bring only your identification into the center. If you need additional note boards or pens, please alert your proctor. The note boards and pens must be returned at the end of your exam or continuing education session. Additional trial questions. During your exam, you will see 5 extra trial questions. These are potential future exam bank questions being tested during the course of the exam. These questions are not included in your final score. Exam results and reports. At the end of the exam, you will receive immediate notice on your success or failure. If your attempt was not successful, the feedback will let you know and your score will be displayed. Those passing the exam are not provided a score. The next business day after your exam, your results will be mailed to your firm and to the SRO and State Securities Commission specified on your application. Series 63 License Exam Manual 9th Edition. At press time, this edition contains the most complete and accurate information currently available. Owing to the nature of license examinations, however, information may have been added recently to the actual test that does not appear in this edition. Please contact the publisher to verify that you have the most current edition. This publication is designed to provide accurate and authoritative information in regard to the subject matter covered. It is sold with the understanding that the publisher is not engaged in rendering legal, accounting, or other professional services. If legal advice or other expert assistance is required, the services of a competent professional should be sought. Copyright 2021 Kaplan, Inc. The text of this publication, or any part thereof, may not be reproduced in any manner whatsoever without written permission from the publisher.
Unit 1. Definitions under the Uniform Securities Act. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 1A. Classify the terms used in this course. Introduction. Back in the day when ball players did not have their names on the back of their jerseys and there was no jumbotron with close-ups, one of the required purchases was a program or scorecard. As the hawkers would shout, "Get your scorecard," you can't tell the players without a scorecard. Similarly, if you do not know the language of the exam, the text will not make much sense. This is particularly true for the Series 63 exam because of its concentration on state securities law with its specialized vocabulary. That is why we start the course with a number of definitions. Lesson 1.1. Learning the terminology. Learning Objective 1A. Classify the terms used in this course. The Uniform Securities Act of 1956, USA. With the enactment of numerous state securities laws, commonly referred to as blue sky laws, the need for uniformity in securities laws among the states arose. In 1956, the National Conference of Commissioners on Uniform State Laws, NCCUSL, a national organization of lawyers devoted to unifying state laws, drafted the original Uniform Securities Act, USA, as model legislation for the separate states to adopt. As model legislation, the USA is not actual legislation. The USA is a template or guide that each state uses in drafting its securities legislation. The securities laws of most states follow the USA very closely, and, in many cases, almost exactly. Test topic alert. The exam will test your knowledge of the Uniform Securities Act, not the specifics of your state's securities legislation. The USA is periodically updated to adjust to developments in the securities markets through the passage of model rules. You will be tested on the 1956 version of the USA used by the North American Securities Administrators Association, NASA, the advisory body of state securities regulators responsible for the content of the exam. The Series 63 exam requires that you not only know what the USA says but also are able to apply the law to concrete situations. General knowledge of the law is not enough to pass the exam. You will be asked to apply the law to situations that may arise in the course of business. Administrator. Although some states may use other terms to describe this position, the exam will only use the word administrator to refer to the office or agency that has the complete responsibility for administering the securities laws of the state. Therefore, the administrator has jurisdiction over virtually all securities activity that emanates from his state, as well as that which is received in his state. The administrator has jurisdiction over the registration of securities professionals and securities. He has the power to make rules and issue orders. He can deny, suspend, or revoke registrations. Yes, there are some limitations on the administrator's powers, which will be covered in this unit and Unit 5. But overall, this is one very powerful person. When it comes to legal issues, terminology is critical. For example, there are some terms that pertain to the administrator that can become quite confusing. Let's try to explain them here, and they will make more sense as you go through this manual. Cease and desist order. A cease and desist order is used by the administrator whenever it appears that any registered person has engaged, or is about to engage, in any act or practice constituting a violation of any provision of the Uniform Securities Act or any rule or order thereunder. The administrator may issue a cease and desist order, with or without a prior hearing, against the person or persons engaged in the prohibited activities, directing them to cease and desist from further illegal activity. Note that this only applies to registered persons, not securities. Stop order. A stop order is used to deny effectiveness to, or suspend or revoke the effectiveness of, any registration statement. This applies only to securities, not professionals such as broker-dealers, agents, investment advisors, and investment advisor representatives. Summary order, acting summarily. The dictionary defines summarily as acting without prior notice. This is one of the powers of the administrator with regard to registration of both persons and securities. There are 3 specific cases where this power applies in the USA. Postponing or suspending the registration of any securities professional pending a final determination of proceeding related to a problem. Postponing or suspending the registration of a security pending a final determination of a proceeding relating to a problem. Denying or revoking a specific security or transaction exemption. In each of these cases, upon the entry of the order, the administrator must promptly notify all interested parties that it has been entered, the reasons for the order, and that within 15 days after the receipt of a written request, a hearing will be granted. Final orders. Regardless of whether we are referring to persons, exemptions, or registration, other than in the case of a summary order, no final order may be entered without appropriate prior notice to the interested parties, the opportunity for a hearing, and written findings of fact and conclusions of law. Blue sky laws. The common term used to refer to state securities laws is blue sky laws. The term comes from a case heard in Kansas in 1911 that led to the creation of the first set of securities regulations in the country. Person. The term person means any individual, sometimes known as a natural person or a legal person. Examples of a legal person are a corporation, partnership, association, trust, an unincorporated organization, a government, or a political subdivision of a government. This is a very broad definition. Test topic alert. Although a wide variety of entities may be defined as persons on the exam, there are only 3 non-persons. Those are minors, anyone unable to enter into contracts under the laws of the state; deceased individuals, but their estate would be a person; and individuals legally declared mentally incompetent. Broker-dealer. The term broker-dealer means any person, see above, engaged in the business of effecting transactions in securities for the account of others, or for its own account. When acting on behalf of others, they are acting as brokers. When acting on behalf of themselves, they are acting as dealers. For exam purposes, it is critical to remember that the primary function of a broker-dealer is making securities transactions. There are other types of investments, such as real estate and commodities, but those are not securities and do not apply to broker-dealers. Unless stated otherwise, all broker-dealers register, with both the SEC and the State S. This term is sometimes abbreviated to BD on the exam. Agent. Agent means any individual who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. You must know that these are always individuals, natural persons, and their function is to be involved in securities sales or supervise those who do. Those who perform clerical or ministerial functions are excluded from the definition. On FINRA exams, agents are referred to as registered representatives. In most cases, these individuals represent broker-dealers, but there can be instances when the individual is selling securities on behalf of the issuer of those securities. Investment advisor. The term investment advisor means any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or as to the advisability of investing in, purchasing, or selling securities, or who, for compensation, and as part of a regular business, issues or promulgates analyses or reports concerning securities. Under the National Securities Markets Improvement Act of 1996, NSMIA, investment advisors are registered with either the SEC, Federal Covered Advisors, or the state registered, but never both. You may see the abbreviation IA on your exam. Investment Advisor Representative. An investment advisor representative is any individual who represents an investment advisor performing duties related to the giving of or soliciting for advisory services. You must know that these are always individuals, natural persons. You may see the abbreviation IR on your exam. Associated Person. An associated person of a broker-dealer or investment advisor is any partner, officer, or director of the broker-dealer or investment advisor, or any individual performing similar functions, including any employees of the broker-dealer or investment advisor. However, any person associated with a broker-dealer or investment advisor whose functions are solely clerical or ministerial is not included in the meaning of the term. Issuer. The term issuer means any person who issues or proposes to issue any security. Issuers primarily include corporations and governments. In an issuer transaction, the issuer of the security receives the proceeds of a securities offering. Non-issuer. The term non-issuer means not directly or indirectly for the benefit of the issuer. Simply stated, a non-issuer transaction is one where the issuer does not receive the money because the seller of the security is someone other than the issuer. This is your basic, everyday trading on the stock markets. Security. The definition of security is quite broad and includes not only those items one normally thinks of as securities, e.g. stocks, bonds, debentures, promissory notes, mutual funds, variable insurance products, annuities, or life insurance, but also includes a number of unusual items, such as an investment contract and a pre-organization certificate. We will cover securities in greater detail in Unit 4. Exempt security. First, you must understand the meaning of the term exempt. When something is exempt, it means that it is excused from certain requirements. When a security is exempt under the USA, it does not have to be registered in order to be sold, and there are no requirements to file advertising about the security with the administrator. You will see more in Unit 4. Exempt transaction. Under the USA, an exempt transaction is one in which the nature of the sale is such that registration with the administrator and filing of advertising material is not required in order for that transaction to take place. The key to differentiate between an exempt security and an exempt transaction is that the latter involves an action, such as a sale or a purchase. More about this will follow in Unit 4. Form AD. Form ADV is the official form used by investment advisors to register. It is used to register on the federal level or on the state level. Form BD. Form BD is the official form used by broker-dealers to register. It is used to register on the federal and state level. Form U4. Form U4 is the official form most often used for agents and IARs to apply for registration. Guaranteed security. The term guaranteed security means guaranteed as to payment of principal, interest, or dividends, but not capital gains. When used on the exam, it refers to a security with a guarantee from a third party other than the issuer of the security. Offer or offer to sell. The terms offer and offer to sell include every attempt or offer to dispose of or solicitation of an offer to buy a security or interest in a security for value. The offerer is the person attempting to make the sale to the offeree. Sale or sell. The term sale or sell includes every contract of sale of contract to sell or disposition of a security or interest in a security for value. In other words, the offer is the attempt, the sale is when it is successful. Discretion. A securities professional has investment discretion when they have, with respect to a customer's account, the sole or shared authority to determine any one or all of the following: whether to buy or sell the action, the quantity to buy or sell, the amount, or the specific security to buy or sell, the asset. As you will notice throughout the course, continuous mention is made of the need for careful monitoring of the activity in these accounts. As you will learn, determining the price or the time of execution does not meet the definition of discretion. Fiduciary. A fiduciary is a person in whom another has placed the trust and confidence to manage and protect property or money. It is a relationship where one person has an obligation to act for another's benefit. Examples are trustees, guardians, and in most cases, investment advisors. Fraud. The term fraud means an intentional effort to deceive someone for profit. This is not limited to common law deceit. Fraudulent activity can lead to criminal charges. Statutory disqualification. Statutory disqualification is a status that denotes that the individual may be subject to disqualification under the Uniform Securities Act and / or parallel provisions in the Securities Exchange Act of 1934. Some events that may cause an individual to be subject to statutory disqualification include an SEC or SRO bar from association with a broker-dealer, all felony convictions, and certain misdemeanor convictions within the last 10 years, certain investment-related temporary or permanent injunctions, as well as a variety of other investment-related legal or regulatory actions / sanctions. Stock exchange. A stock exchange is a membership organization regulated by the Securities and Exchange Commission, SEC, where members use the facilities to buy and sell stocks and bonds listed for trading on that exchange. These are called listed securities, and prices are determined by auction. Over-the-counter (OC) market. An over-the-counter market is a market for securities that are traded other than on a national securities exchange. These are known as unlisted securities. The over-the-counter market is characterized most particularly by a system of dealers that offer and sell securities where prices are negotiated. SRO. SRO is the abbreviation for Self-Regulatory Organization. The most prominent of these is the Financial Industry Regulatory Authority, FINRA, but there are others, such as the Municipal Securities Rulemaking Board, MSRB, the Chicago Board Options Exchange, CBOE, and the Investment Industry Regulatory Organization of Canada, IIROC, which is the Canadian equivalent of FINRA. Solicitor. The term solicitor means any individual who, for compensation, acts on behalf of an investment advisor in referring potential clients. In most cases, solicitors must be registered as investment advisor representatives. De minimis. De minimis is a term taken from the Latin meaning about minimal things. It appears in this course when we describe an exemption available to investment advisors and their representatives. It applies when there is no place of business in a state, and the number of retail investors is a small number, 5 or fewer on the exam. Accredited investor. The term accredited investor is found in Rule 501 of the Federal Securities Act of 1933. It refers to a person who is not counted when computing the number of investors purchasing a private placement under Regulation D of that Act. Because it is a federal term and not one found in the Uniform Securities Act on this exam, NASA frequently uses it to confuse you, as you will see when you go through Q-Bank questions. Qualified client. The term qualified client is used to describe an individual or company meeting the minimum financial requirements to enter into a performance-based compensation contract with an investment advisor. More on this in Learning Objective 6E, Qualified Purchaser. The term qualified purchaser means an individual or a family business that has over $5 million in investments, or an individual/entity that invests over $25 million on their own account or on others' behalf. Registrant. The term registrant is used in legal circles to refer to those securities professionals, BDs, IAs, agents, and IARs, or securities issuers who are in the process of registering or who have registered with the administrator. Institution. The term institution would include banks, trust companies, savings institutions, savings and loan associations, insurance companies, investment companies, employee benefit plans with assets of not less than $1 million, and governmental agencies or instrumentalities. The USA generally affords less protection to these investors, owing to their greater investment sophistication. National Securities Markets Improvement Act of 1996, NISMIA. Congress enacted the NISMIA in 1996 to promote efficiency in capital formation in the financial markets. In effect, the Act generally preempts states' blue sky laws, eliminating the dual system of state and federal registration of certain securities and investment advisors. State. The term state means any of the 50 states, any territory or possession of the United States, such as American Samoa and Guam, the District of Columbia, and Puerto Rico. Surety bond. A surety bond involves 3 parties. First is the securities professional who needs to be bonded. The second is the administrator who sets the bonding requirement. The third is the bonding company issuing the bond. The bond guarantees the securities professional will adhere to the law. The bond is there to cover the losses if the securities professional acts criminally. Examples would be theft, embezzlement, and forgery. Retail client. Terminology is very important on this exam. A few questions use the term retail client instead of non-institutional client. Look for it and remember that retail clients need far more protection than institutional ones. You need to know that individuals who meet the standard of accredited investor are still retail, rather than institutional clients. Holding company. A holding company is defined as a company whose primary business is holding a controlling interest in the securities of other companies. It is that element of control that differentiates holding companies from investment companies. The most common example on the exam is the bank holding company. A bank holding generally controls one or more banks and may also have subsidiaries registered as broker-dealers and investment advisors. Exclusion from a definition. Exclusion means excluded from or not included in a definition. For the purposes of the Uniform Securities Act, if a person is excluded from the definition of an agent, that person is not subject to provisions of state law that refer to agents. In the next several units, we will learn when this particular exclusion applies to broker-dealers and their agents, as well as investment advisors and their representatives. Exemption from registration under the Uniform Securities Act. Exemption in the Uniform Securities Act means not being subject to a registration provision of the Act. The most common example is when a security, although meeting the definition of a security under the USA, is exempt from the registration requirements of the Act. Wrap fee program. A wrap fee program is a program under which any client is charged a specified fee or fees, not based directly on transactions in the client's account, for investment advisory services, which may include portfolio management or advice concerning the selection of other advisors, and execution of client transactions. Under a typical wrap fee program, a client will pay the sponsor a single fee, typically a percentage of the client's total assets held within the account, for management, brokerage commissions, custody, and other services provided under the program. Broker-dealers offering wrap fee programs must also be registered as investment advisors. Knowledge Check 1.1. Question 1. What is the official designation of the person or agency that enforces the USA in each state? A. Administrator. B. Transfer agent. C. Registrar. D. Issuer. The correct answer is A, although some states use other terms. The only one on the exam for this office is administrator. Question 2. Under the Uniform Securities Act, the term person would include all of the following except A. An unincorporated association. B. A child prodigy, gifted in math, in the custody of his parents, for whom his parents opened an account at a major securities firm. C. A political subdivision. D. An individual. The correct answer is B. The term person is extremely broad. Excluded from the term would be a minor, a deceased individual, and one who has legally been determined incompetent. Question 3. The administrator could issue all of the following orders except A. A cease and desist order. B. A court order. C. A stop order. D. A summary order. The correct answer is B. The only issuer of court orders is a court. The administrator may apply to the court for the order, but it is only the court who can issue it. Question 4. A corporation that purchases stock in another corporation for the purpose of exercising management control is A. A business development company. B. An investment company. C. A holding company. D. A management company. The correct answer is C. The investment philosophy of a holding company is to purchase ownership interest in other companies for the purpose of controlling them. They are specifically excluded from the definition of an investment company. Unit 2. Regulation of broker-dealers and their agents under the Uniform Securities Act. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 2A. Define a broker-dealer. Learning Objective 2B. Identify exclusions and exemptions from the definition of broker-dealer under the Uniform Securities Act. Learning Objective 2C. Classify the initial and post-registration requirements of the Uniform Securities Act applying to broker-dealers. Learning Objective 2D. Recognize the requirement for broker-dealers to properly supervise their agents. Learning Objective 2E. Define an agent. Learning Objective 2F. Identify exclusions and exemptions for the definition of agent under the Uniform Securities Act. Learning Objective 2G. Classify the initial and post-registration requirements of the Uniform Securities Act applying to agents. Introduction. As one would expect, an exam qualifying an individual to serve as an agent of a broker-dealer would concentrate its attention on those two roles. It is important to understand the difference between these two securities professionals. The broker-dealer is the business unit. Typically, it is organized as a corporation, but could also be a partnership, a limited liability company, LLC, or even a sole proprietorship. Agents are the individuals who represent these broker-dealers in the conduct of the business. As we will learn later in the unit, agents can also represent issuers of securities. However, unless something in the question indicates otherwise, always assume it is referring to an agent of a broker-dealer. The Series 63 exam will include 18 questions on the material presented in this unit. Lesson 2.1. Who is and who is not a broker-dealer? Learning Objective 2A. Define a broker-dealer. A broker-dealer is defined in the Uniform Securities Act as any person. Think back to the broad definition we gave you a few pages ago, engaged in the business of effecting transactions in securities for the accounts of others or for its own account. Any person, e.g., a securities firm, even in the rare case of one organized as a sole proprietorship, with an established place of business, an office, in the state that is in the business of buying and selling securities for the accounts of others, customers, or for its own proprietary account is a broker-dealer and must register in the state as such. In other words, broker-dealers are firms for which agents, registered representatives, work. They are firms that engage in securities transactions, such as sales and trading. When acting on behalf of their customers, that is, buying and selling securities for their clients' accounts, broker-dealers act in an agency capacity. When broker-dealers buy and sell securities for their own accounts, called proprietary accounts, they act in a principal capacity as dealers. Another function of broker-dealers is the underwriting of new issues, the practice known as investment banking. Broker-dealers are regulated by the states and the Securities Exchange Commission, SEC, of the United States. We will describe the state registration requirements for broker-dealers in Lesson 2.2. Take note. Individuals who buy and sell securities for their own accounts are not broker-dealers because they are engaged in personal investment activity, not the business of buying and selling securities for others. They are individual investors, not securities dealers. Test Topic Alert. One of the roles of a broker-dealer is underwriting, distributing shares of new securities for issuers. When they do that, they generally earn a spread, the difference between the public offering price and what they pay the issuer, or receive a commission on the sales, which they then use to pay their agents who actually made the sales to the clients. Learning Objective 2B. Identify exclusions and exemptions from the definition of broker-dealer under the Uniform Securities Act. Exclusions from the definition of broker-dealer. Broker-dealers are firms that buy and sell securities for others or themselves as a business. There are, however, many persons, legal and natural, who effect securities transactions but are excluded from the definition of broker-dealer for purposes of state regulation. Persons not included in the definition of broker-dealer are agents, they work for broker-dealers; issuers, they issue the securities, stocks, or bonds that broker-dealers buy and sell; and banks, savings institutions, and trust companies. They are not engaged in broker-dealer activities. Domestic commercial banks and other financial institutions are generally excluded from the definition of broker-dealer. Today, most banks and other financial institutions engage in securities activities through broker-dealer subsidiaries. The broker-dealer subsidiaries of banks are, as a result, not excluded from the definition of a broker-dealer and are therefore subject to the same securities regulations as other broker-dealers. Keep in mind that formation of these subsidiaries eliminates the need for the bank holding companies to register as broker-dealers. Their broker-dealer subsidiaries must, of course, register. Take note, keep in mind the distinction between a bank holding company and a wholly owned commercial bank subsidiary. Commercial banks, the subsidiaries of bank holding companies, do not have to register because they are excluded from the definition of a broker-dealer. When engaged in securities transactions with the public, broker-dealer subsidiaries are subject to securities regulation as any other broker-dealer. Test Topic Alert. It will be safe to assume that any question mentioning securities activities by a bank will treat the bank as exempt from registration. It isn't a broker-dealer. The only exception will be if the question specifically describes the entity as a wholly owned subsidiary engaged in securities transactions. No place of business in the state. There is another exclusion from the definition of broker-dealer. This exclusion relates to the location of the broker-dealer's place of business. Broker-dealer does not include a person who has no place of business in this state if it affects transactions in this state exclusively with or through the issuers of the securities involved in the transactions, such as when underwriting a new issue, other broker-dealers or banks, savings institutions, trust companies, insurance companies, investment companies, and pension or profit-sharing trusts with assets of not less than $1 million, or the person is licensed under the Securities Act of a state in which the person maintains a place of business, and the person offers and sells in this state to a person who is an existing customer of the person, and whose residence is not in this state. This is sometimes referred to as the snowbird exemption and applies as well to agents, investment advisors, and investment advisor representatives. In other words, the USA excludes broker-dealers with no place of business in the state from the definition of a broker-dealer in that state to allow firms that deal exclusively with other broker-dealers, issuers of the securities being traded, and financial institutions to operate in the state without registering. The reason for this exclusion is that the regulators understand that this category of investor has a high level of investment sophistication and expertise and does not need the same degree of protection as the so-called little guy. The USA also allows broker-dealers to do business with existing customers who are temporarily in a state to avoid unnecessary multiple registrations. In most states, when an existing client legally changes residence to another state in which the broker-dealer is not registered, the firm has 30 days during which it may continue to do business with that client without registration in the new state. Should it wish to continue to maintain the client, the broker-dealer would have to register in that state. As long as your client has not changed state of residence, there is no time limit. For example, many snowbirds spend the entire winter in Florida, which is no problem for the firms they do business with up north, or many people, after a couple of years in the workforce, decide to get an MBA. If they go out of state to a resident program for a year or two, that does not mean they've changed their state of residence, merely that they are not commuter students. Only when official residency is changed, new driver's license or voter registration, does the 30-day rule apply. Notice how important language is here. If persons with no place of business in the state were defined as broker-dealers, they would be subject to state registration. If such persons with no place of business in the state are not defined as broker-dealers, those persons are not subject to the registration requirements of that state. If a person or entity is defined as a broker-dealer, that person is covered by, subject to, the provisions of the Act. If a person or entity is excluded from a definition, that person is not subject to, covered by the Act. Practice question. One of the terms defined in the Uniform Securities Act is broker-dealer. Who of the following is included in that definition? A. An individual employed by a business entity to open new customer accounts for the purpose of trading securities. B. A business entity seeking to raise additional capital using the regulated securities markets. C. A person whose primary function is buying and selling securities for its own account and for the accounts of others. D. A person whose primary function is providing advice on what assets belong in clients' investment portfolios. The answer is C. A broker-dealer is defined as a person in the business of effectuating securities transactions for its own account or the account of others. Those employed to open new accounts are defined as agents. Those seeking to raise new capital are issuers, and a person who provides investment advice is an investment advisor. Take note, under the USA, you are a broker-dealer if 1. You have a place of business in the state, or 2. You have even one retail client in the state. Under the USA, you are not a broker-dealer if 1. You have no place of business in the state, and 2. Your only clients are other BDs, institutions, and issuers of the security involved in the transaction, and / or your only business in the state is with existing clients who are temporarily in the state. Note that even one retail client who resides in a state triggers the need for a broker-dealer to register in that state. In the next unit, we will learn that investment advisors and their representatives have a de minimis exemption. That means that as long as the number of retail clients in the state does not exceed the stated number, the person is not an IA or ILR using the Internet. Obviously, there was no Internet when the Uniform Securities Act was written in 1956. As with other changes in the way we do business, NASA has written model rules to update the regulatory scheme. An example that has been addressed by NASA is broker-dealers and investment advisors using the Internet. A firm's website, considered advertising, can be seen everywhere. Does it mean the firm has a place of business in the state? Without getting too technical, there are several requirements to ensure that the person is not deemed to be in the state. The communication clearly states that the person may only do business in this state if properly registered or exempt from registration. Any follow-up individualized responses with prospects in this state that involve either effecting or attempting to effect transactions in securities or rendering personalized investment advice for compensation, as may be, will not be made without compliance with state broker-dealer, investment advisor, agent, or investment advisor representative registration requirements, or an applicable exemption or exclusion. The site may only make available general information, not specific advice or recommendations. In the case of an agent or IOR, the affiliation with the broker-dealer or investment advisor of the agent or IOR is prominently disclosed within the communication. The broker-dealer or investment advisor with whom the agent or IOR is associated retains responsibility for reviewing and approving the content of any Internet communication by an agent or IOR. The broker-dealer or investment advisor with whom the agent or IOR is associated first authorizes the distribution of information on the particular products and services through the Internet communication, and, in disseminating information through the Internet communication, the agent or IOR acts within the scope of the authority granted by the broker-dealer or investment advisor. What this basically means is that if a person or entity just generally advertises on the Internet, it does not have to be registered in the state. However, if it follows up with advice, IA, or offering securities BD, it either has to register or find some kind of exemption. Test topic alert. The exam focuses more on the exclusions from the definition of broker-dealer than on the definition itself. Know these exclusions well. Example. Exclusion from the definition of broker-dealer. First, Securities Corporation, FSC, is a broker-dealer registered in State A, the location of its only office. One of their agents contacts a client who is currently on vacation in State B and recommends the purchase of XYZ common stock. The client agrees and purchases 100 shares of XYZ. Neither the broker-dealer nor the agent is registered in State B. Is this a problem? What if the client enjoys being in State B to the extent that it becomes his permanent residence? When a broker-dealer has no place of business in a state and deals with an existing client who is temporarily in that state, the USA does not define that entity as a broker-dealer in the state. Therefore, FSC would not be required to register in State B, and neither would any of its agents. Things change, however, if the client becomes a resident of State B. Once the client's residence has officially changed, the relationship can only continue for a maximum of 30 days. After that, both FSC and the agent would have to register in State B if they wanted to keep the client. Let's take the example one step further. A question might appear something like this. Practice question. First, Securities Corporation, FSC, is a broker-dealer registered in State A, the location of its principal office. They have begun doing business in State B with the First Fidelity Bank and Trust Company and opened a small branch office in State B to service the account. Which of the following statements is correct? A. FSC does not need to register in State B because its only client is an institution. B. FSC needs to register in State B because it has a place of business in the state. C. Broker-dealers are only required to register in the state where their principal office is located. D. FSC would have to register in State B even if it did not have a place of business there. The answer is B. We learned that the USA excludes from the definition of broker-dealer a firm with no place of business in a state whose only clients are, among others, institutions, such as banks. That exclusion only applies when there is no place of business in the state. Opening a small branch in State B voids that exclusion, so that is the correct answer. Even if there is no place of business in the state, if they have a single individual, called a retail client on the exam, who resides in the state, then registration is always required. Knowledge Check 2.1. Question 1. Under the Uniform Securities Act, a broker-dealer is defined as any person who A. buys securities, B. sells securities, C. is in the business of effecting securities transactions for its own account or for the accounts of others, D. is registered with the SEC. The answer is C. A broker-dealer is any person, partner, officer, director, or securities firm engaged in the business of effecting securities transactions for the accounts of others, broker, or for its own account, dealer. Question 2. Under the Uniform Securities Act, the definition of a broker-dealer in a state would include A. the First Federal Company Trust, B. XYZ broker-dealer with an office in the state whose only clients are insurance companies, C. an agent effecting transactions for a broker-dealer, D. a broker-dealer with no place of business in the state who only does business with other broker-dealers. The answer is B. Any broker-dealer with an office in the state, regardless of the nature of its clients, is defined as a broker-dealer under the USA. If the firm did not have an office in the state, and its only clients were institutions, such as insurance companies or other broker-dealers, it would be excluded from the definition. Banks or trust companies and agents are never broker-dealers. Question 3. A broker-dealer, having no place of business in the state, would be exempt from registration under the Uniform Securities Act if its only clients were Roman numeral 1, banks or other financial institutions, Roman numeral 2, investment companies, Roman numeral 3, accredited investors, A1 and 2, B1 and 3, C2 and 3, D1, 2, and 3. The answer is A. Do not be misled by the term accredited investor. It has absolutely no meaning other than when referring to a private placement of securities under the Securities Act of 1933. This term will appear frequently on the exam out of context, i.e., unrelated to private placements. Whenever it does, you can make the question easier by replacing the term with the phrase ordinary public investor who needs all of the protection available under the law. As long as the broker-dealer has no place of business in the state, it is exempt from registration if its only clients are institutional investors, such as banks, insurance companies, investment companies, other investment advisors, broker-dealers, $1 million or larger employee benefit plans, college endowment funds, and governmental units. Question 4. A broker-dealer is registered in State X. It has no offices in State Y, although it does do business in that state. Under the Uniform Securities Act, registration in State Y is required if the client is A. a bank, B. a broker-dealer, C. an insurance company, D. an agent of another broker-dealer. The answer is D. Broker-dealers must always register in a state if they do business with non-institutional, individual clients, regardless of the nature of the individual's employer. Lesson 2.2. Registration and post-registration requirements of broker-dealers. Learning Objective 2C. Classify the initial and post-registration requirements of the Uniform Securities Act applying to broker-dealers. Broker-dealer registration requirements. Under the Uniform Securities Act, any person included in the definition of broker-dealer must register as a broker-dealer in the states where it does business. The Uniform Securities Act is clear about broker-dealer registration. It states, it is unlawful for any person to transact business in this state as a broker-dealer, unless the person is registered under this act. Take note, for exam purposes, unless stated to the contrary, all broker-dealers register with the SEC and those states where they are defined as a broker-dealer. As you will learn in the next unit, this is different from investment advisors who register with either the SEC or the State S, never both. This means every person, legal entity, that falls within the definition of a broker-dealer must register with the administrator of the state. Again, keep in mind that if a person falls under one of the exclusions from the definition, that person does not have to register in the state. What exactly are the registration procedures? Unless qualifying for an exemption, any person who meets the definition of broker-dealer or agent, investment advisor, or investment advisor representative must register with the state. To register with the state securities administrator, such persons must submit an application, provide a consent to service a process, pay filing fees, post a bond, if required by the administrator, and take and pass an examination, if required by the administrator, which may be written, oral, or both. The administrator may require that an applicant publish a notice of the registration in one or more newspapers in the state. Submitting an application. All persons must complete and submit an initial application to the state securities administrator. The application, Form BD for broker-dealers, Form U4 for agents, must contain whatever information the administrator may require by rule and may include form and place of business, broker-dealers, proposed method of doing business, qualifications and business history. Broker-dealers must include the qualifications and history of partners, officers, directors, and other persons with controlling influence over the organization. Disclosure if the applicant has ever been the subject of any court-issued injunctions and administrative orders. Disclosure if the applicant has ever been the subject of any adjudications by the SEC or any securities SRO. Disclosure if any federal regulatory agency, any state regulatory agency, or foreign financial regulatory authority has ever denied, suspended, or revoked the applicant's or control affiliate's registration or license or otherwise by order, prevented it from associating with an investment-related business or restricted its activities. Disclosure of any charge, conviction, or guilty plea to a misdemeanor involving investments or an investment-related business or bribery, forgery, extortion, or similar offenses. Disclosure of any charge, conviction, or guilty plea to any felony. Financial condition and history, including the end date of the fiscal year. Broker-dealers only, but only of the firm, no credit reports on the officers, and, in the case of an individual registrant, agent, citizenship information. Test topic alert. As stated previously, the Form U-4 requires disclosing if an agent has ever been convicted, or even just arrested, charged, with no time limit. The 10 years is for statutory disqualification by statute, that is, generally automatic denial or revocation. In the case of a broker-dealer, there are similar disclosures on the Form BD for the applicant or a control affiliate. A control affiliate is any person that is a director, general partner, or officer exercising executive responsibility, or having similar status or functions. A yes answer to most of the above disciplinary issues will lead to statutory disqualification. Provide a consent to service a process. New applicants for registration as a securities professional, broker-dealer, agent, investment advisor, and investment advisor representative must provide the administrator of every state in which they intend to register with a consent to service a process. The consent to service a process appoints the administrator as the applicant's attorney to receive and process non-criminal securities-related complaints against the applicant. Under the consent to service a process, all legal documents, e.g. subpoenas or warrants, received by the administrator have the same legal effect as if they had been served personally on the applicant. Take note. The consent to service a process is submitted with the initial application. It is included in the Form U-4 or the Form BD, and remains in force permanently. It does not need to be supplied with each renewal of a registration. Test topic alert. If a securities professional is registering in 6 states, the administrator of each state must receive a consent to service a process. Payment of initial and renewal filing fees. States require filing fees for initial applications, as well as for renewal applications. If an application is withdrawn or denied, the administrator is entitled to retain a portion of the fee. Filing fees for broker-dealers, investment advisors, and their representatives need not be identical. Broker-dealers or investment advisors may file, without a fee, an application for registration of a successor firm, whether or not the successor is then in existence, for the unexpired portion of the year. The renewal date for all registrations is December 31, and there is no proration of fees. In the case of broker-dealers and investment advisors, a successor firm, an entity that acquires or takes over the operation of the existing firm, pays no fees until the renewal date. Test topic alert. One of the tricks the exam likes to play is asking about a person who registers in November. When does the registration come up for renewal? Well, even if it is only a month or so later, every registration of a securities professional comes up for renewal on the next December 31, so your first year is always less than 365 days. Financial requirements. For the protection of investors, the administrator may establish minimum financial standards for broker-dealers, generally the requirement to maintain minimum net capital. Think of net capital as the broker-dealer's liquid net worth. Net capital requirements of the states may not exceed those required by federal law. In this case, the Securities Exchange Act of 1934. The administrator may require broker-dealers who are registered in his state and who have custody of or discretionary authority over client funds or securities to post surety bonds in amounts that the administrator may prescribe, subject to the limitations of the Securities Exchange Act of 1934. A deposit of cash or securities in the appropriate amount may be accepted in lieu of any bond so required. However, if the broker-dealer's net capital exceeds the amounts required by the SEC, a bond will not be required by the state. The NISMIA of 1996 amended the Securities Exchange Act of 1934 to add Section 15H1, which reads as follows: No law, rule, regulation, or order, or other administrative action of any state or political subdivision thereof shall establish capital, custody, margin, financial responsibility, making and keeping records, bonding, or financial or operational reporting requirements for broker-dealers that differ from, or are in addition to, the requirements in those areas established under the Exchange Act. Simply stated, when it comes to broker-dealers, regardless of how many states in which they are registered, other than enforcing anti-fraud statutes, the administrator has relinquished most control to the SEC. Test topic alert. You will have to know that broker-dealers who meet the SEC net capital or bonding requirements cannot be required to meet higher ones in any state in which they do business. Test topic alert. In lieu of a surety bond, the administrator will accept deposits of cash or securities. Effectiveness of registration. Unless a legal proceeding is instituted or the applicant is notified that the application is incomplete, the registration of a broker-dealer, agent, investment advisor, or investment advisor representative becomes effective at noon, 30 days after the later of the date an application for licensing is filed and is complete or the date an amendment to an application is filed and is complete. An application is complete when the applicant has furnished information responsive to each applicable item of the application. By rule or by order, the administrator may authorize an earlier effective date of licensing. In other words, there could be an occasion where, in effect, a person was the subject of a rush order. In the same manner as a registration becomes effective on the 30th day after application, a request to withdraw registration also becomes effective on the 30th day after submission. However, should there be any legal proceedings in progress, the withdrawal will be delayed until resolution of the issue. In any event, once withdrawal has taken place, the administrator has jurisdiction of the former registrant for a period of 1 year. Just as with initial registration, the administrator has the power to grant an earlier effective date. Post-registration requirements of broker-dealers. Once registered, broker-dealers and investment advisors, the firms, are subject to numerous administrative requirements to keep their registrations current and in good order. The exam will deal primarily with the requirements pertaining to broker-dealers. The requirements for investment advisors will be covered in the next unit. If any material information in those documents relating to the application for registration becomes inaccurate or incomplete, the registrant must promptly file a corrected copy, amend their application with the administrator. The USA requires registered broker-dealers to keep account records, blotters, records of original entry, correspondence, including emails, memoranda, papers, books, advertisements, and other records the administrator requires. In most cases, these records must be preserved for 3 years by broker-dealers unless the administrator prescribes otherwise. All records must be readily accessible, in the principal office, for the first 2 years. These records must be available for inspection by the administrator or his representative at any time during normal business hours. An appointment is not necessary. The administrator may also require registered broker-dealers to file financial reports. As noted previously, for SEC-registered broker-dealers, the record-keeping and financial reports required by the state administrator may not exceed those required by the Securities Exchange Act of 1934. All required documents are subject to reasonable periodic, special, or other examination as the administrator deems appropriate, in the public interest, or for the protection of the investor. Test topic alert. Although it is required to keep all records relating to customers, there are no requirements to keep copies of their tax returns. Maintenance and preservation of records. How may these records be kept and preserved by the broker-dealer? The records may be maintained and preserved for the required time by a broker-dealer on paper or hard copy form, as those records are kept in their original form. Micrographic media, including microfilm, microfiche, or any similar medium, or electronic storage media, including any digital storage medium or system that meets the terms of this section, such as computer disk or the cloud. The firm must arrange and index the records in a way that permits easy location, access, and retrieval of any particular record. Promptly provide any of the following that the administrator may request: a legible, true, and complete copy of the record in the medium and format in which it is stored, a legible, true, and complete printout of the record, and means to access, view, and print the records, and separately store, for the time required for preservation of the original record, a duplicate copy of the record on any medium allowed by the rules. In the case of records created or maintained on electronic storage media, the firm must establish and maintain procedures to preserve the records so as to reasonably safeguard them from loss, alteration, or destruction. Digital records must be in a worm format, write once, read many. To limit access to the records to properly authorized personnel and the administrator, and to reasonably ensure that any reproduction of a non-electronic original record on electronic storage media is complete, true, and legible when retrieved. Take note, we will discuss data protection again in greater detail in Unit 8. Test topic alert. keeping up with current trends, the exam is likely to ask about retention requirements for electronic communications, specifically email. Email has the same requirements as any other documents. 3 years for broker-dealers, and as we will learn in the next unit, 5 years for investment advisors. Emails from a registered person that are strictly of a personal nature and not to a client. Honey, I'll be late for dinner. Or, I'll pick up the kids after basketball practice. Do not have to be retained. Take note, to avoid unnecessary duplication of examinations, the administrator may cooperate with the securities administrators of other states, the SEC, and any national securities exchange or national securities association registered under the Securities Exchange Act of 1934. Test topic alert. The administrator's authority does not stop at the state line. The administrator or his representative of any state in which the person is registered may demand an inspection of any of these books and records during reasonable business hours with whatever frequency the administrator deems necessary. Website storage. What about a broker-dealer's website? Websites are treated as any other advertisement would be. The original site design is kept for 3 years, and whenever revised, the new copy is maintained and starts a new retention requirement for that copy. Therefore, a broker-dealer will likely have several different versions in its advertising file at the same time. Practice question. Which of the following is part of a broker-dealer's renewal of registration? A. Filing Form BD. B. Providing a consent to service a process. C. Paying the licensing fee. D. Submitting a copy of the firm's tax return for the previous year. The answer is C. Renewing the registration of any securities profession requires paying the appropriate fee. The Form BD is an initial filing with amendments filed if there are material changes. The consent to service is part of the initial filing and is a permanent document for that registration. In some cases, an audited balance sheet might be required, but never a copy of the income tax return. Learning Objective 2D recognized the requirement for broker-dealers to properly supervise their agents. For those of you who have taken a FINRA exam, you know there is a supervisory level of registration, registered principal. No such gradations apply under NASA rules. Therefore, no matter how high-ranking the officer of a broker-dealer or an investment advisor, the registration status is that of an agent or an IR. However, that does not mean that supervisory responsibility is ignored by NASA. Registered broker-dealers are responsible for the supervision of individuals registered as agents of the firm. It makes no difference if the individual is an actual employee of the broker-dealer or is acting in the capacity of an independent contractor. Take note, many financial planners set up their own independent financial planning business. If they wish to be able to sell securities, they affiliate with a broker-dealer, register as an agent of that BD, and indicate the relationship on their business cards with a statement to the effect of securities offered through ABC Securities, member FINRA and SIC. Although considered independent contractors for tax and other purposes, all securities-related activity is under the supervisory responsibility of the broker-dealer. The Uniform Securities Act states that the administrator shall consider that an agent who will work under the supervision of a registered broker-dealer need not have the same qualifications as a broker-dealer. That means that new agents, like you, are not expected to have the knowledge, experience, and background of the employing broker-dealer. In a later unit, we will cover reasons for disqualifying an agent, but here is what the USA says about improper supervision. The disqualification of any agent may not automatically be used against the broker-dealer, but when the agent's disqualification is due to lack of reasonable supervision, the administrator may proceed against the broker-dealer. Put into plain English, if an agent commits a violation serious enough to lead to a revocation of her license, the firm can also be disciplined if it can be shown that there was a lack of adequate supervision of the agent. Knowledge Check 2.2. Question 1. Under the Uniform Securities Act, which of the following statements regarding the registration of a successor firm is true? A. The appropriate filing fee must be included with the application. B. The successor firm must be in existence before the filing of the application. C. The registration of the successor firm will be effective until the December 31 renewal date without payment of a registration fee. D. All of the above. The answer is C. No filing fee is necessary, nor is it required that the successor firm even be in existence at the time of filing. The registration is effective for the unexpired portion of the year and then must be renewed with a renewal fee each December 31. Question 2. Those persons meeting the Uniform Securities Act's definition of a broker-dealer in a state must, unless otherwise exempted, register in that state. Which of the following is correct regarding the initial registration and expiration of the registration of a broker-dealer? A. The effective date of an initial registration is at noon on the 30th day after receipt of a completed application. Expiration, unless renewed, is each December 31st. B. The effective date of an initial registration is when ordered by the administrator, and the same is true of the expiration date. C. The effective date of an initial registration is when ordered by the administrator, and the expiration, unless renewed, is each December 31st. D. The effective date of an initial registration is at noon on the 30th day after receipt of a completed application. Expiration, unless renewed, is on the anniversary date of the initial registration. The answer is A. Under the USA, it states, if no denial order is in effect and no proceeding is pending under Section 204, registration becomes effective at noon of the 30th day after an application is filed. Further, it states, every registration or notice filing under this section expires December 31st unless renewed. Question 3. The Uniform Securities Act specifies certain record-keeping requirements for broker-dealers. When it comes to email correspondence, the requirements are A. the same as they would be for written correspondence. B. that a receipt that the email has been read is sufficient. C. the firm must keep the correspondence in cloud storage for 3 years. D. only that the correspondence be reviewed by a principal. The answer is A. Email correspondence is treated the same as written correspondence. The records must be kept for 3 years. One method is cloud storage, but there are other acceptable methods as well. Question 4. Unless otherwise specified, compliance with the record-keeping requirements of the Uniform Securities Act for a broker-dealer means maintaining copies. A. for 3 years, the first year in an easily accessible place. B. for 3 years, the first 2 in an easily accessible place. C. for 2 years, the first 3 in an easily accessible place. D. for 5 years, the first 2 in an easily accessible place. The answer is B. For the most part, the USA broker-dealer record-keeping requirements parallel those of the SEC. The general requirement under the USA is 3 years, with the first 2 kept in an easily accessible place. Question 5. In which of the following cases would it be most likely that a broker-dealer's registration might be suspended for violations of the Uniform Securities Act? A. The broker-dealer's reported profits tripled this year. B. One of the firm's agents was convicted of felony spousal abuse. C. The broker-dealer failed to promptly notify the administrator of a change to the company's toll-free customer service phone number. D. After repeated warnings, one of the firm's agents continued to conduct unauthorized trading in customer accounts. The answer is D. Failure to supervise the activities of agents or any other associated person is just cause for significant disciplinary action against a broker-dealer. The administrator understands that an agent doing something improper one time does not necessarily reflect poorly on the firm's supervisory procedures. However, when continued bad behavior is not controlled, a suspension could well be forthcoming. The felony conviction would likely lead to revocation of the agent's registration, but the firm cannot be responsible for non-securities actions committed at the agent's home. Lesson 2.3. Who is and who is not an agent? Learning Objective 2E. Define an agent. The USA defines an agent as any individual who represents a broker-dealer or an issuer in effecting or attempting to effect transactions in securities. As agents, they act on behalf of others, and usually are compensated on a commission basis. Other than on this exam, agents are usually referred to as registered representatives. A partner, officer, director of a broker-dealer or issuer, or a person occupying a similar status or performing similar functions is an agent only as she otherwise comes within this definition. That is, being an agent depends upon functions performed, not the individual's title. The use of the term individual here is important. Only an individual or a natural person can be an agent. A corporation, such as a brokerage firm, is not a natural person. It is a legal entity. The brokerage firm is the legal person, entity, that the agent, natural person, represents in securities transactions. Take note, individuals representing broker-dealers in a sales capacity must register as agents whether they sell registered securities or securities exempt from registration. In Unit 4, we will go into depth on registration of securities and conditions where they are exempt. The point here is that an exemption from registration of the security has no bearing upon the exemption from registration as an agent for those who represent broker-dealers. Learning Objective 2F, identify exclusions and exemptions from the definition of agent under the Uniform Securities Act. Exclusions from definition of agent for administrative personnel. Knowing who is not an agent is just as important as knowing who is an agent. In fact, it sometimes seems that the exam asks more about who isn't rather than who is. Therefore, it is critical to know the circumstances under which certain individuals are not agents. Clerical and administrative. Sometimes referred to as ministerial, employees of a broker-dealer are generally not included in the definition of agent and therefore are not required to register. The logic for this exclusion from the definition should again be obvious. Clerical and administrative employees do not affect securities transactions with the public. They attend to the administration of the broker-dealer as a business organization. Under these circumstances, they are similar to administrative or clerical employees of any other corporation. A testable point is that if the broker-dealer they work for wishes to pay its employees, including this group, a year-end bonus based on company profits, not related to any individual's sales efforts, it would be allowable and would not require registration of the clerical personnel. The situation changes when administrative personnel take on sales-related functions. When they do so, they lose their exclusion and must register as agents. Example: secretaries and sales assistants are not agents if their activities are confined to administrative activities, including responding to an existing client's request for a quote or posting to client records. However, if secretaries or sales assistants accept customer transactions or take orders over the phone, they are engaging in securities transactions and are subject to registration as agents. Test topic alert. Cold callers working for a broker-dealer would have to register as agents if they did any more than ask if clients wanted to receive information. For example, pre-qualifying clients or suggesting ways to receive more income from their current stock or bond holdings would require registration as agents. As is customary in other industries, broker-dealers frequently hire summer interns. If these interns received any selling-related compensation, such as $10 for each existing client solicited, they would be considered agents and would have to register. Exclusions from the definition of agent for personnel representing issuers. Although the majority of new securities issues are sold to investors through the efforts of broker-dealers acting in the capacity of investment bankers underwriters, there are cases where the issuer itself takes on the chore of selling a stock or bond issue to the public. When might the issuer choose not to use an underwriter? In many cases, a local company is looking to raise some additional capital, something in the range of several $1,000,000. Instead of going through the normal investment banking procedure and paying all of those fees and commissions to the investment bankers, the company, known under the USA as the issuer, either uses its own employees or hires an independent sales force acting under contract with the issuer to sell the new security. Determining if these individuals are defined as agents depends on the nature of the security being sold, the way it is being sold, or to whom it is being sold. Individuals representing an issuer are excluded from the definition of agent and therefore are exempt from registration in a state when representing issuers in effecting transactions. In certain exempt securities, listed below, exempt from registration, exempt transactions, and, with existing employees, partners, or directors of the issuer, if no commission or other remuneration is paid or given directly or indirectly for soliciting any person in this state. Affecting transactions in exempt securities. Securities exempt from registration are called exempt securities. Although there are almost a dozen different securities that qualify for exemption under the Uniform Securities Act, they will be discussed in Unit 4. An individual is excluded from the term agent only when that individual represents an issuer in effecting transactions for the following exempt securities: any security issued or guaranteed by the United States, any state, any political subdivision of a state or any agency of one or more of these, or any security issued or guaranteed by Canada, any Canadian province, or any political subdivision of any such province, any security issued or guaranteed by any foreign government with which the United States currently maintains diplomatic relations, any security issued or guaranteed by any bank organized under the laws of the United States, or any bank, savings institution, or trust company organized and supervised under the laws of any state, Commercial paper rated in the top 3 categories by the major rating agencies with denominations of $50,000 or more and maturities of 9 months or less. Investment contracts issued in connection with an employee's stock purchase, savings, pensions, or profit-sharing plans. Affecting exempt transactions. An employee of an issuer is not an agent when representing an issuer in exempt transactions. Transactions exempt from registration are called exempt transactions. Some examples are unsolicited brokerage transactions. The client initiates the trade. Transactions between issuers and underwriters. Transactions with financial institutions, such as banks or trust companies, insurance companies, or investment companies, and offerings to a limited number of investors, usually referred to as private placements. Exempt securities and exempt transactions will be covered in thorough detail in Unit 4. Practice question. The Bailey Brothers Savings Institution, organized in State X and authorized to do business in States X, Y, and Z, has an offering of common stock being made in State Z in order for an individual selling the offering to be excluded from the definition of an agent in State Z. The individual A. could not sell without being an agent. B. would have to be employed by a broker-dealer registered in States X and Z. C. would have to be employed by a broker-dealer registered in State Z. D. would have to be representing the Bailey Brothers Savings Institution. The answer is D. Included in the USA list of exempt securities offering an exclusion from the definition of agent for those representatives selling the issue are those issued by any savings institution organized under the laws of any state and authorized to do business in this state. No such exemption applies to those representing broker-dealers. Affecting transactions with employees of the issuer. The final exclusion applies when the individual is affecting transactions with existing employees, partners, or directors of the issuer, as long as no commission or other remuneration is paid or given directly or indirectly for soliciting any person in this state. In other words, salaried employees engaged in distributing their employer's shares as part of an employee benefit plan would not be required to register as agents because they are, by definition, excluded from the definition. If such employees were compensated on the basis of the number of shares sold, they would be defined as agents and therefore would be subject to registration. Take note, an employee of an issuer is not an agent when representing an issuer if the issue is exempt from registration, as long as it is one of the group listed above. Additionally, the employee is not an agent when representing an issuer in exempt transactions, e.g., transactions between an underwriter and issuer. Test topic alert. Individuals representing broker-dealers in a sales capacity must register as agents whether they sell registered securities, securities exempt from registration, or in exempt transactions. Knowledge Check 2.3. Question 1. Which of the following persons is defined as an agent by the Uniform Securities Act? A. A silent partner of a broker-dealer whose only relationship to the firm is a contribution of capital. B. The secretary of a branch office sales manager who is in charge of scheduling the manager's interviews with new agents. C. A clerk at a broker-dealer who is authorized to take orders for stock, but not bonds. D. The vice president of diversity training for a broker-dealer who is not authorized to solicit or transact securities business. The answer is C. Anyone who solicits or receives an order while representing a broker-dealer is an agent. Silent partners and administrative personnel are not agents under the terms of the USA if they do not solicit or receive orders. As long as the officer has no supervisory role or other active participation in the securities business of the broker-dealer, the USA does not consider this position to require registration as an agent. An example might be the Vice President of Human Resources. Remember, broker-dealers are not agents. Agents represent broker-dealers. If, however, any of these individuals were authorized to accept orders, registration as an agent would be required. Question 2. Which of the following would be an agent under the terms of the Uniform Securities Act? A. A sales representative of a licensed broker-dealer who sells securities in the secondary markets to the general public. B. An assistant to the president of a broker-dealer whose sole responsibility is filing the president's documents. C. A subsidiary of a major commercial bank registered as a broker-dealer that sells securities to the public. D. An issuer of non-exempt securities registered in the state and sold to the general public. The answer is A. The primary function of a registered agent is representing a broker-dealer in securities transactions. Functioning in a clerical capacity does not make one a securities sales agent. A broker-dealer is not an agent. Agents represent BDs, such as the subsidiary of the bank. Issuers are the entities that issue securities, such as corporations and governments. They are not individuals. Question 3. Under the Uniform Securities Act, the term agent would include an individual who represents the issuer in effecting non-exempt transactions in A City of Montreal general obligation bond, B. Common stock offered by a commercial bank, C. A New Jersey Turnpike revenue bond, D. Commercial paper with a 19-month maturity. The answer is D. As long as the individual represents the issuer in a transaction involving specified exempt securities, such as those issued by governments or banks, he is not included in the definition of agent even when the transaction is non-exempt. On the other hand, when the securities themselves are non-exempt and the transactions are non-exempt, the individual is defined as an agent. And, yes, you may see this many negatives in a single question. Notice that a 19-month commercial paper is not an exempt security. It is over 9 months, but the other choices are. Question 4. Under the Uniform Securities Act, the term agent would include A. An individual who represents an issuer in exempt transactions, B. An individual who represents a broker-dealer in an exempt transaction in an exempt security, C. A receptionist for a broker-dealer who directs calls for trade information to the appropriate individual, D. The vice president of human resources for a national brokerage firm. The answer is B. There is almost no case where an individual performing a sales function for a broker-dealer is not an agent. Clerical persons are not agents, nor officers with no apparent sales function. Anytime an individual represents the issuer in an exempt transaction or one of the specified exempt securities, that individual is not defined as an agent under the USA. As will be covered in Unit 4, those exemptions apply to the security, not the agent. Question 5. Under the Uniform Securities Act, the term agent would not include an individual who represents the issuer in effecting non-exempt transactions in any security, A. Issued or guaranteed by any federal credit union, B. Issued or guaranteed by any bank organized under the laws of the United States, C. Issued or guaranteed by a regulated public utility or public utility holding company, D. Of an issuer equal to or senior to common stock, which is a federal covered security. The answer is B. Although each of these choices is an exempt security under the USA, only those issued by banks, savings institutions, and trust companies are in the group of issuers that exempt the individual representing the issuer from being defined as an agent. Question 6. A publicly traded corporation offers its employees an opportunity to purchase shares of the company's common stock directly from the issuer. Several specific employees of the company are designated to process orders for that stock. Under the Uniform Securities Act, those employees, A. must register as an agent of the issuer, B. need not register as an agent of the issuer under any circumstances, C. may receive commissions without registration, D. must register as an agent if they will receive commissions or remuneration, either directly or indirectly. The answer is D. Under the USA, an individual is an agent when effecting transactions with an issuer's existing employees if sales-related compensation is received. This is one of the cases when an individual representing an issuer in the sale of its securities is considered an agent. Lesson 2.4. Registration and post-registration requirements of agents. Learning Objective 2G. Classify the initial and post-registration requirements of the Uniform Securities Act applying to agents. Agent registration requirements. The registration requirements for an agent who is not exempt are similar to those covered previously for a broker-dealer. An application, generally the Form U-4, is filed with the administrator. When everything is complete, including passing the exam, the administrator will notify the employing firm of the effectiveness of the registration. The final step is for the firm to notify the applicant that she is now legal to begin soliciting clients. Test topic alert. We do expect you to pass, but if an applicant is not successful on the first or second attempt, there is a 30-day waiting period before the exam may be retaken. After the third and subsequent attempts, the waiting period is 180 days. One thing, however, that is on the agent's application that does not apply to a broker-dealer is disclosing citizenship. It is not required that the applicant be a citizen of the United States. Test topic alert. Please note that, unlike FINRA registration requirements, fingerprints do not have to be submitted. The USA states, It is unlawful for any person to transact business in this state as an agent unless he is registered under this act. In other words, an individual may not conduct securities transactions in a state unless that person is registered or exempt from registration in that state. This is true even when receiving unsolicited orders. Agents doing business in a state must be registered in that state, even if there is only one client who resides in that state. This is not like investment advisors and their representatives who, as we will learn in the next unit, enjoy a de minimis exemption. Furthermore, the Act makes it unlawful for any broker-dealer or issuer to employ an agent unless the agent is registered. So, what can an individual who has been hired to become an agent of a broker-dealer do while registration is pending? After all, one does not fill out the Form U-4 and become an agent immediately. Permitted activities would be those allowed to any other employee of the broker-dealer who is not required to be registered. That would include clerical functions, such as posting trade details to client accounts, or administrative activities, like assisting with research. As long as it does not involve customer contact relating to selling or offering securities or opening accounts, these newbies can hang around the office and try to make themselves useful. Of course, most of their time should be spent preparing to pass the exam. Test topic alert. While registration as an agent or IR is pending, the individual may not take part in any activity that would require registration. Clerical work or assisting with research would be permitted. An agent's registration is not effective during any period when the agent is not associated with a broker-dealer registered in the state. Therefore, if the broker-dealer's registration is terminated, the agent is no longer considered licensed. The terminology depends on the specific state. In some cases, the agent's license is placed in suspense. In other states, it is put on hold, or some similar language. Whatever the phrase, when the broker-dealer closes up shop, either voluntarily or involuntarily, think revocation of registration by the administrator. The agent cannot function because there is no broker-dealer affiliation. This effectively cancels the agent's active registration. Example: it is important to understand when someone is an agent and when someone is not. The following is an example of what you might encounter on the exam. The City of Chicago issues bonds for the maintenance of local recreational facilities. Purchasers have two choices. They can purchase the bonds directly from the city through MS Stith, a City of Chicago employee responsible for selling the bonds, or they can purchase them from Mr. Thompson, an employee of First Securities Corporation of Illinois. Practice question. Which of the following statements is correct? A. MS Stith and Mr. Thompson must be registered as agents. B. MS Stith must be registered as an agent, but Mr. Thompson is excluded. C. Mr. Thompson must be registered as an agent, but MS Stith is excluded. D. Mr. Thompson and MS Stith are excluded from the definition of agent. The answer is C. Any individual selling securities while representing a registered broker-dealer is always defined as an agent, even when the securities are exempt from registration, as are these municipal bonds. When an individual represents the issuer of certain exempt securities, such as municipal bonds, that individual is excluded from the definition of agent and does not register. That is why Mr. Thompson must register and MS Stith is excluded. It is important to remember the 5 categories of exempt issuers to which this exclusion applies. Take note, exemptions from registration as an agent apply only to individuals who represent issuers, rather than to individuals who represent broker-dealers. Test topic alert. When representing the issuer, the only time when compensation comes into play is when affecting transactions with existing employees, partners, or directors of the issuer. In that case, for the individual to be excluded from the definition of an agent, no commission or other remuneration is paid or given directly or indirectly for soliciting any person in this state. Agent's financial requirements. Unlike a broker-dealer, there are no financial requirements or minimum net worth requirements to register as an agent. The administrator may, however, require an agent to be bonded, particularly if the agent has discretion over a client's account. Please note that an agent would never maintain custody of money or securities of a client. Multiple registrations. An individual may not act at any one time as an agent for more than one broker-dealer or for more than one issuer, unless the broker-dealers or issuers for whom the agent acts are affiliated by direct or indirect common control or the administrator grants an exception. In the event an agent does wish to affiliate with a second broker-dealer, the agent would have to go through the registration process with the second firm in the same manner as the original application, filing another Form U-4. Automatic registration of partners, officers, and directors. Let's take a look at a frequently tested rule found in the Uniform Securities Act. Registration of a broker-dealer automatically constitutes registration of any agent who is a partner, officer, or director, or a person occupying a similar status or performing similar functions. Registration of an investment advisor automatically constitutes registration of any investment advisor representative who is a partner, officer, or director, or a person occupying a similar status or performing similar functions. As stated previously, it isn't the title that determines your registration. It is the function performed. Note that the rule quoted states that the agent or IR is a partner, officer, or director of the broker-dealer or investment advisor. Doesn't that mean she is already registered? What is the purpose of automatic registration to someone already registered? When a registered broker-dealer, or state-registered IA, expands its business so that registration is required in another state or states, the application process is basically the same as its initial state registration. That is, Form BD or Form ADV is filed. That filing includes the names and other pertinent information about all of the partners, officers, or directors who are already acting as agents or IARs. Therefore, when the firm's registration becomes effective in that new state, those individuals included in the filing are granted automatic registration. They don't have to file an individual Form U-4. Please note, it is not any agent or IR. It is only those listed or, as the rule states, those occupying a similar status who receive this treatment. Any of the firm's other existing agents or IARs who will need to be registered in the new state must file an amended Form U-4 with the administrator and wait for their supervisor to tell them that the firm has received the word that their registration is effective within that state. It is also important to note that, unlike FINRA, there is no separate principal registration category for those in supervisory positions. They are all agents. Post-registration requirements of agents. Unlike broker-dealers, once the initial registration has been completed, there isn't much effort required to maintain an agent's license. There are no record-keeping requirements, and the only possible financial requirement is a surety bond if the agent will be exercising discretion in client accounts. Even the renewal process, including fee payment, is generally taken care of by the broker-dealer. Of course, if the fee is not paid, the registration is not renewed, and as stated with broker-dealers, the renewal date is December 31. Test topic alert. If there is a change to any material information in the Form U-4, e.g., change of permanent address or change to military status, an amendment must be filed within 30 days. Termination procedures. If an agent terminates employment with a broker-dealer or is involuntarily terminated, both parties must notify the administrator promptly. If an agent terminates employment with one broker-dealer to join another broker-dealer, all three parties must notify the administrator. One way to remember this is that in the case of an agent, the first letter, 8, tells us that all the parties involved must notify the administrator. As is the case with the other securities professionals, unless the administrator has commenced an investigation, withdrawal becomes effective 30 days after submission of the Form U-5. Even after withdrawal, the administrator can initiate a case against the agent for a period of 1 year. Limited registration of Canadian broker-dealers and agents. Provided the following limited registration requirements are met, a broker-dealer domiciled in Canada that has no office in this state may effect transactions in securities with or for, or attempt to induce the purchase or sale of any security by. A person from Canada who is temporarily resident in this state and who was already a client of the broker-dealer. Or a person from Canada who is a resident in this state and whose transactions are in a self-directed tax-advantaged retirement plan in Canada, of which the person is the holder or contributor. Canada's equivalent of our IR is called a Registered Retirement Savings Plan, RRSP. An agent who will be representing a Canadian broker-dealer who registers under these provisions may effect transactions in securities in this state on the same basis as permitted for the broker-dealer. For the Canadian broker-dealer to register in this fashion, it must file an application in the form required by the jurisdiction where it has its principal office in Canada. File a consent to service of process. Provide evidence that it is registered in good standing in its home jurisdiction, and be a member of an SRO or stock exchange in Canada. Requirements for agents are the same, except that membership in an SRO or stock exchange is not relevant. However, just as with domestic broker-dealers, if there is no place of business in the state, There are no registration requirements if the only securities transactions are with issuers, other broker-dealers, and institutional clients. Take note: renewal applications for Canadian broker-dealers and agents who file for limited registration must be filed before December 1 each year. Knowledge Check 2.4. Question 1. When an agent's permanent residence address changes, updates must be made to the information on file with the regulatory bodies. The proper procedure is to file A. A Form U-4 within 30 days. B. A Form U-4 within 4 to 5 days. C. A Form U-5 within 30 days. D. A Form U-5 within 4 to 5 days. The answer is A. It is Form U-4 that is most commonly used when registering as an agent of a broker-dealer. Changes to material information, such as home address or a bankruptcy filing, are accomplished by filing an amended Form U-4 within 30 days. Form U-5 is used for terminations or withdrawals. Question 2. During the application process for registration as an agent, the administrator may not request information about the applicants: A. Annual income. B. Citizenship. C. Record involving a securities-related misdemeanor conviction 5 years ago. D. Permanent residence address. The answer is A. The earnings of an agent are not within the purview of the administrator and are not pertinent to an applicant for registration. The administrator asks all registrants about their address. In the case of individuals, their home address. Individual registrants may be asked about their citizenship. Being charged with or convicted of any securities-related misdemeanor must be reported, although denial is generally reserved for convictions within the past 10 years. Question 3. Under the Uniform Securities Act, which of the following automatically becomes registered as an agent when a broker-dealer registration becomes effective? A. Only the designated supervisory principal. B. Any partner, officer, or person of similar status or similar function whose activities fall under the definition of an agent. C. All agents currently registered with FINRA through that broker-dealer. D. No one. The answer is B. Registration of a broker-dealer automatically constitutes registration of any individual meeting the definition of an agent who is a partner, officer, or director, or a person occupying a similar status or performing similar functions. Question 4. Andrew voluntarily leaves his position as an agent with Gibraltar Securities. Which of the following best describes the reporting requirements relative to this termination? A. Only the firm must notify the administrator, and must do so within 30 days of Andrew's resignation. B. Only Andrew must notify the administrator, and must do so within 30 days of his resignation. C. Both Andrew and the firm must notify the administrator of Andrew's resignation promptly. D. Notification to the administrator is not required, presuming that Andrew was not terminated for cause. The answer is C. On termination of an agent from a firm with which he is registered, both the agent and the firm must notify the administrator of such termination promptly. Question 5. Canadian broker-dealers with clients in the United States are eligible for a limited registration with the states where those clients reside. For the Canadian broker-dealer to register in this fashion, it must do all of the following except: A. File an application in the form required by the jurisdiction where it has its principal office in Canada. B. File a consent to service a process. C. Provide evidence that it is registered in good standing in its home jurisdiction. D. Be a member of a stock exchange registered with the SEC. The answer is D. The limited registration of Canadian broker-dealers requires that the firm be a member of an SRO or stock exchange in Canada, not the U.S. Question 6. An agent of a broker-dealer has terminated his registration. During a routine examination of the agent's broker-dealer, the administrator discovers a violation of the Uniform Securities Act committed by that agent before the filing date of the Form U-5. The administrator cannot bring an action against the former agent once more than A. 30 days has elapsed from the filing of the Form U-5. B. 30 days has elapsed from the effective termination date. C. 1 year has elapsed from the effective termination date. D. 2 years has elapsed from the effective termination date. The answer is C. If no proceeding is pending or instituted and withdrawal becomes effective on the 30th day, the administrator may institute a revocation or suspension proceeding within 1 year after withdrawal became effective. After 1 year has elapsed, it is too late. For those who say, "But isn't it true that you can't bring an action once more than 2 years has elapsed?" You are missing the once in the question. That refers to the earliest date at which the administrator no longer has the power to bring a charge.
Unit 3. Regulation of investment advisors and their representatives under the Uniform Securities Act. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 3A. Define investment advisor, including the impact of SEC Release IA 1092 on the definition of investment advisors and their activities. Learning Objective 3B. Identify exclusions and exemptions from the definition of investment advisor under the Uniform Securities Act. Learning Objective 3C. Classify the initial and post-registration requirements of the Uniform Securities Act applying to investment advisors. Learning Objective 3D. Define investment advisor representative. Learning Objective 3E. Identify exclusions and exemptions from the definition of investment advisor representative under the Uniform Securities Act. Learning Objective 3F. Classify the initial and post-registration requirements of the Uniform Securities Act applying to investment advisor representatives. Introduction. In addition to registration as a broker-dealer or agent, the Uniform Securities Act provides for the registration of two other types of securities professionals. Those two are investment advisors and those individual who represent them, investment advisor representatives. Although, as already mentioned, the exam will focus on broker-dealers and their agents, approximately 6 questions will deal with investment advisors and their representatives. Many of the provisions are similar, such as registration taking effect at noon of the 30th day and renewal of licenses on the next December 31. We will mention those. Repetition always helps solidify the knowledge, and will explain those areas specific to these two registrations. As we did with BDs and agents, we will define who they are and are not, and deal with the various registration requirements. One specific point to note is that, unlike broker-dealers who register with both the SEC and the appropriate states, investment advisors register with either the SEC or the appropriate states, never both. Similarly, unlike agents who register as representatives of FINRA member firms with both the SEC and the states, investment advisor representatives, IARs, register solely on the state level. As stated above, you can expect to see 6 questions on the material covered in this unit. Lesson 3.1. Who is and who is not an investment advisor? Investment advisor. Learning Objective 3A. Define investment advisor, including the impact of SEC Release IA 1092 on the definition of investment advisors and their activities. In Lesson 1.1, we gave the definition of investment advisor. It is important to note that the definition specifies that the advice must be related to securities. Advice given on investments not defined as securities, such as rare coins, art, and real estate, is not investment advice covered by the USA or other securities legislation. As a result, persons providing such advice are not investment advisors. Again, definitions are crucial for determining whether an activity is subject to securities law. To be an investment advisor under both state and federal securities law, a person must provide advice about securities, not about jewelry, rare coins, or real estate, provide that advice as part of an ongoing business, hang a shingle and have an office for conducting business on a regular basis, and receive compensation, payment for the advice. Test topic alert. Remember, the definition of an IA is any person who meets the ABC test, gives advice, is in the business of advising, and receives compensation. Take note. In most cases, investment advisors are legal persons, such as partnerships or corporations, who provide investment advice or portfolio management services on an ongoing basis. Investment advisor representatives work for investment advisors, just as agents work for a broker-dealer. Note that an individual can be an investment advisor and the only investment advisor representative when the business is organized as a sole proprietorship. SEC Release IA 1092. In the 1980s, as a result of the proliferation of persons offering investment advice, Congress directed the SEC to define the activities that would subject a person to the Investment Advisors Act of 1940. The SEC did so in SEC Release IA 1092. Because so much of the USA interpretations dealing with investment advisors parallels the federal law, it is important to know how this release has influenced the industry. SEC Release IA 1092 interprets the definition of investment advisor under the Investment Advisors Act of 1940 to include financial planners, pension consultants, and others who offer investment advice as part of their financial practices. Release IA 1092, in short, identifies as an investment advisor anyone who provides investment advice, reports, or analyses with respect to securities, is in the business of providing advice or analyses, and receives compensation, directly or indirectly, for these services. Take note, if a person engages in these three activities, sometimes referred to as the three-prong test, that person is an investment advisor subject to the Investment Advisors Act of 1940 or the Uniform Securities Act. As an investment advisor, this person must register with either the SEC or the states. Additionally, as we will cover further in this course, investment advisors and their representatives have a fiduciary responsibility to their customers. A fiduciary is one in a position of trust, especially over financial assets. Because investment advisors are being paid for their advice, it is critical that the advice always be in the best interest of the customer, not the IA or IR, provides investment advice. In Release IA 1092, the SEC, and NASAT as well, maintains that a person who gives advice, whether in written or oral form, and issues reports, analyses, and recommendations about specific securities, is an investment advisor if that person is in the business of doing so and receives compensation for the advice. This definition of investment advisor includes financial planners, pension consultants, and sports and entertainment representatives. Financial planners. Financial planners who make recommendations regarding a person's financial resources or perform analyses that concern securities are investment advisors if such services are performed as part of a business and for compensation. Under this interpretation, the SEC holds that there is no such thing as a comprehensive financial plan that does not involve securities. In fact, the SEC even includes financial planners who advise clients as to the desirability of investing in securities as an alternative to other investments, such as real estate, intangibles, or other assets. Pension consultants. Consultants who advise employee benefit plans on how to fund their plans with securities are also considered investment advisors by the SEC. In addition, under Release IA 1092, the SEC considers pension consultants who advise employee benefit plans on the selection, performance, and retention of investment managers to be investment advisors. A bit later in this unit, you will learn the conditions under which pension consultants become eligible to register with the SEC rather than the states. Sports and entertainment representatives. Persons who provide financially related services to entertainers and athletes that include advice related to investments, tax planning, budgeting, and money management are also investment advisors. As earnings for these celebrities continue to climb, more and more of them use personal managers to handle all of their finances, and those individuals or firms are generally going to be considered investment advisors. Take note, a sports agent who secures a favorable contract for a football player and receives a commission of 10% of the player's salary is not necessarily an investment advisor. However, if the sports agent advises the football player to invest his money in specific securities, the person is then in the business of offering investment advice and would then be subject to the Investment Advisors Act of 1940 or the Uniform Securities Act. Is in the business of providing advice. A person is in the business of providing advice and is subject to regulation as an investment advisor if he gives advice on a regular basis such that it constitutes a business activity conducted with some regularity. Although the frequency of the activity is a factor, it is not the only determinant in whether a person is in the business of giving advice, and providing advice does not have to be the person's principal activity. And advertises investment advisory services and presents himself to the public as an investment advisor or as one who provides investment advice. Take note. A person is in the business of giving investment advice if he receives separate compensation that represents a charge for giving the advice. Even when the advice doesn't mention specific securities, such as recommending an allocation of assets into highly rated bonds, technology stocks, or growth mutual funds, it meets the prong of advice on securities. On the other hand, a person whose business is to offer only nonspecific investment advice through publication of a general newsletter, for example, is not covered by the Act. We'll discuss this exclusion shortly. Receives compensation. A person who receives an economic benefit as a result of providing investment advice is an investment advisor. The compensation can be direct or indirect. Compensation includes advisory fees, commissions, and other types of fees related to the service rendered. A separate fee for the advice need not be charged. The fee can be paid by a third party on behalf of the beneficiary of the advice. No matter what the source, all compensation must always be disclosed to the client. Example: fees that an investment advisor receives from a corporation for advice given to the corporation's employees or retirees are considered compensation. A financial planner who designs a comprehensive financial plan for the corporation's employees without charging a fee, but receives commissions on insurance policies sold as part of the plan, is acting as an investment advisor. Even though that compensation is indirect, it meets the release's definition of compensation for investment advice. Practice question: which of the following is not considered one of the three prongs making a person an investment advisor? A. Giving advice on securities. B. Being in the business of giving advice. C. Executing trades in recommended securities. D. Receiving compensation for the advice rendered. The answer is C. Execution of trades is the role of the broker-dealer, not an investment advisor. Learning Objective 3B, identify exclusions and exemptions from the definition of investment advisor under the Uniform Securities Act. Exclusions from the definition of investment advisor. As is the case with broker-dealers and agents, there are exclusions from the term investment advisor. If a person is excluded, none of the registration requirements apply. Under the USA, the following 7 bullet points describe persons excluded from the definition and are not investment advisors. Investment advisor representatives. The business entity is the investment advisor, not the representative. Banks, savings institutions, and trust companies. Take note. Just as we covered at Learning Objective 2B referring to a broker-dealer, if a bank holding company has a subsidiary meeting the definition of an investment advisor, there is no exclusion for that entity. Any lawyers, accountants, teachers, or engineers, LATE, whose advice is solely incidental to the practice of their profession, are excluded. This exclusion is not available to any of these who have established a separate advisory business. Also, the exclusion would not be available to any of these who hold themselves out as offering investment advice. Any broker-dealer whose investment advisory services are incidental to their brokerage business and who receive no special or separate compensation, wrap fees, for offering advice. This exclusion also applies to agents of these broker-dealers. Take note. Why is it that broker-dealers qualify for this exclusion? Including this exception in the law amounts to a recognition that brokers-dealers commonly give a certain amount of advice to their customers in the course of their regular business, and that it would be inappropriate to bring them within the scope of the definition of an IA merely because of this aspect of their business. On the other hand, reference to special compensation amounts to an equally clear recognition that a broker-dealer who is specially compensated for the rendition of advice should be considered an investment advisor and not be excluded from the purview of the Act merely because he is also engaged in effecting market transactions in securities. It is well known that many broker-dealers have investment advisory departments which furnish investment advice for compensation in the same manner as an investment advisor who operates solely in an advisory capacity. The essential distinction to be borne in mind in considering borderline cases is the distinction between compensation for advice itself and compensation for services of another character, to which advice is merely incidental. A publisher, employee, or columnist of a newspaper, news magazine, or business or financial publication of regular and general circulation, or an owner, operator, producer, or employee of a cable, radio, or television network, station, or production facility, if in either case the financial or business news published or disseminated is made available to the general public and the content does not consist of rendering advice on the basis of the specific investment situation of each client. Test topic alert. An investment newsletter is being published for a subscription fee. Rather than being published on a regular basis, weekly, monthly, quarterly, and so forth, issues are released in response to market events. How does the law view this publisher? In this case, the publisher would be considered an investment advisor requiring registration. The exclusion requires that the publication is published with some sort of regular schedule, rather than being timed to specific market events. Federal covered investment advisors registered with the SEC, e.g. those with the required assets under management or under contract to a registered investment company, or those excluded from the definition under the Investment Advisors Act of 1940. Any other person the administrator specifies. Take note. Sometimes the exam will refer to exceptions rather than exclusions. Both terms mean the same thing for test purposes. Take note. For purposes of the exclusion, the term bank does not include a savings and loan association, a building and loan association, or a foreign bank. Take note. When referring to the late exclusion, it is important to understand the meaning of incidental. A lawyer advising clients to carefully invest a settlement from a legal case is not giving investment advice unless charging a separate fee for helping set up the portfolio. An accountant is not giving investment advice when suggesting to a wealthy client that investing in tax-exempt municipal bonds might be a wise idea unless charging a separate fee to help select the bonds. Practice question. Under the Uniform Securities Act, the definition of investment advisor would include a bank, b. a lawyer charging a fee to advise clients how to invest an injury settlement she just won for them, c. an investment advisor representative, d. none of the above. The answer is B. Although lawyers are generally excluded from the definition of investment advisor, that exclusion holds true only if the advice given is solely incidental to the practice of the profession and no separate fees are charged. The separate billing here is what loses the exclusion. Remember, investment advisor representatives are not investment advisors, just as agents are not broker-dealers. Federal covered advisors. The National Securities Markets Improvement Act of 1996, NISMIA, made major changes in the way investment advisors register. The NISMIA divided registration responsibilities between the SEC and the state securities departments. Basically, the largest firms are required to register with the SEC, and the smaller ones are required to register with the states. Unlike broker-dealers who almost always register with the SEC and one or more states, investment advisors are registered with one or the other, never both. Advisors registered with the SEC are known as Federal Covered Investment Advisors, or sometimes on the exam, just as covered advisors, without the word federal. Federal covered advisors are those: required to be registered or registered as an investment advisor with the SEC because they meet the minimum threshold of assets under management, currently $110 million. Registered with the SEC because they are under contract to manage an investment company registered under the Investment Company Act of 1940, regardless of the amount of assets under management, or not registered with the SEC because they are excluded from the definition of an investment advisor by the Investment Advisors Act of 1940. The only testable example of a person who is excluded under this provision is one whose advice, analyses, or reports are related only to securities that are direct obligations of or obligations guaranteed by the United States or by certain U.S. government-sponsored corporations designated by the Secretary of the Treasury, e.g., Fannie Mae, Ginnie Mae. Take note, because so much of this exam deals with interpreting the laws, it is sometimes necessary to review some legal concepts. For example, if a person is excluded from the definition of investment advisor under the Investment Advisors Act of 1940, the states, under the NISMIA, cannot define this person as an investment advisor because federal law excluded that person from the definition. In other words, if the separate states could define the persons who were excluded from the federal definition as investment advisors, the federal law would have no meaning. Take note, as a general rule, the SEC or federal rules involve bigger numbers than the state rules. Large investment advisors must register with the SEC. Small and mid-size investment advisors must register with the state. Dodd-Frank and assets under management. As stated previously, the NISMIA eliminated state registration requirements for federal covered advisors, largely based upon assets under management. Dodd-Frank has created 3 thresholds, one for the large advisor, one for the mid-size advisor, and logically, one for the small advisor. Let's examine each of these thresholds requirements and exceptions, if any. Large investment advisors. Large advisors, those advisors with at least $100 million or more in assets under management, AUM, are eligible for SEC registration. Once AUM reach $110 million, registration with the SEC is mandatory. Unless covered by one of the exemptions mentioned previously, all large IA must register with the SEC. State registration is not required because the NISMIA preempts state registration. Small investment advisors. This category includes advisors with assets under management of less than $25 million. Unless the investment advisor is an advisor to an investment company registered under the Investment Company Act of 1940, e.g., a mutual fund, registration with the SEC is prohibited, and unless exempted under state rules, registration with the state is required. In addition, if the advisor would be required to register in 15 or more states, registration with the SEC would be permitted instead. Mid-size advisors. This is a new category added by Dodd-Frank. It includes those with AUM of at least $25 million, but not $100 million. Generally, these advisors are prohibited from SEC registration and must register with the state. However, there are more extensive exceptions than exist with the small advisors. Just as with any other category, those who are advisors to an investment company registered under the Investment Company Act of 1940 also register with the SEC. That is true regardless of their size. There are several other ways for a mid-sized firm to qualify for SEC registration. A mid-sized advisor is not prohibited from registering with the SEC. If the advisor is not required to be registered as an investment advisor with the securities administrator of the state in which it maintains its principal office and place of business. If registered, the advisor would not be subject to examination as an investment advisor by that securities administrator. If the advisor is required to register in 15 or more states, or if the advisor elects to take advantage of the buffer described below. Exceptions under Dodd-Frank. In addition to the exemptions from the prohibition just covered, There are several additional exemptions from the prohibition on registration, including pension consultants, but only those with at least $200 million under control. The SEC picked that number to ensure that, in order to register with the SEC, the consultant's activities are significant enough to have an effect on national markets. Those mid-size advisors with at least $100 million in AUM, but less than $110 million in AUM, who elect to register with the SEC rather than the State S. This buffer will be described below, and investment advisors expecting to be eligible for SEC registration within 120 days of filing Form ADV. The $20 million buffer. The SEC recognized that market conditions, or obtaining or losing clients, can cause AUM to fluctuate, so they established a buffer to keep advisors from having to switch back and forth. The numbers work like this. Once a state-registered advisor has assets under management of at least $100 million, subject to the exceptions previously mentioned, everyone needs at least $100 million to initiate registration with the SEC. It may choose to remain state-registered or register with the SEC. Once the AUM reach $110 million, registration with the SEC is mandatory. It can no longer stay state-registered. Then, once registered with the SEC, an investment advisor need not withdraw its SEC registration unless it has less than $90 million of assets under management. This means that an investment advisor can register with the SEC with AUM of as little as $100 million, but must register once AUM reach $110 million. Having become SEC registered, the IA can remain so as long as AUM remain at or above the $90 million level. Likewise, those investment advisors registered at the state level can choose to remain there until they reach the $110 million level. This buffer is designed to avoid the expense and hassle involved in potentially annual changes to where the investment advisor is registered. Time for measuring AUM. These numbers are based on the AUM reported on the IA Annual Updating Amendment. The effect of this is that a federal covered advisor's AUM could drop below $90 million during the year without triggering the need to change to state registration, just as long as the annual update showed at least the minimum $90 million required. Of course, the same would be true of a state-registered advisor whose AUM peaked above $110 million during the year, but then fell at the time of the update. If at the time of filing the annual updating amendment to the Form ADV by an SEC-registered IA, the reported AUM is less than $90 million, it is necessary for the investment advisor to withdraw its SEC registration and register with the appropriate State S within 180 days. On the other hand, if a state-covered advisor's reported AUM exceed $110 million, registration with the SEC must take place within 90 days. Test topic alert. An investment advisor registered under state law whose assets reach $110 million under management has 90 days to register with the SEC. A federal covered investment advisor whose assets under management fall below $90 million no longer qualifies for SEC registration and has 180 days to register with the State S. Why the difference in time? The logic is that the work involved in registering with one entity, the SEC, is less than registering with multiple entities, the different states. Notice filing for federal covered investment advisors. Even though these advisors are not defined as such under the Uniform Securities Act, administrators still have the ability to request information about those firms who are doing business in their states. This is accomplished through the process of notice filing. As part of the notice filing procedure, the administrator can require the federal covered investment advisor to submit copies of all documentation filed with the SEC and, of course, pay a filing fee. In general, federal covered investment advisors will make a notice filing with the state if they have a place of business in the state or have 6 or more retail clients in that state in a 12-month period, regardless of place of business. Practice question. A state-registered investment advisor would not qualify for the de minimis exemption if, over a 12-month period, it had A. 5 retail clients, B. 5 or fewer retail clients, C. fewer than 6 retail clients, D. 6 or fewer retail clients. The answer is D because the maximum is 5 retail clients in a 12-month period. The choice with 6 clients is over the limit. Notice that fewer than 6 and 5 or fewer mean the same thing. Exemption for private fund advisors. December 2011 saw the adoption of the NASA registration exemption for investment advisors to private funds model rule. The rule set out the conditions under which these advisors could qualify for the exemption. First, the advisor had to be one who provides advice solely and exclusively to one or more qualifying private funds. Definition of a private fund. Although it is highly unlikely you will be tested on the technical definition, a private fund is defined as an issuer that would be an investment company, as defined in Section 3 of the Investment Company Act of 1940, but for Section 3C, 1, or 3C, 7 of that Act. In more straightforward terms, a 3C1 issuer is one whose outstanding securities are beneficially owned by not more than 100 persons, and which is not making and does not presently propose to make a public offering of its securities. With no more than 100 shareholders and no public offering, the term private fund seems quite logical. It gets a bit more complicated because there is a special condition that must be met. All investors must be qualified clients. That is, they must have either at least $1.1 million in assets managed by the investment advisor or a net worth, excluding the value of the primary residence, of more than $2.2 million. Remember, value of primary residence means the fair market value of a person's primary residence minus the amount of debt secured by the property up to its fair market value, net equity. A 3C7 issuer is one whose outstanding securities are owned exclusively by persons who, at the time of acquisition of such securities, are qualified purchasers, a federal term referring to those with at least $5 million in investments for individuals and generally $25 million in investments for business entities, and which is not making and does not at that time propose to make a public offering of such securities. In this case, the lack of a public offering is logically private, and the fact that the invested wealth requirement limits the potential universe of investors is a factor as well. Regardless of which classification the issuer of the private fund has, there are 2 final conditions that must be met. Neither the private fund advisor nor any of its advisory affiliates are subject to an event that would disqualify an issuer under Rule 506, D.1 of SEC Regulation D, the bad actor provisions. The private fund advisor files with the state the reports specified by the Securities and Exchange Commission. For an exempt reporting advisor, ERA reports. These are reports that the SEC determines are necessary or appropriate in the public interest or for the protection of investors. The point is, regardless of how it's defined, if one is an advisor solely to private funds, it is possible to qualify for an exemption from registration with the administrator. Take note. Please note that these exemptions are granted on the basis of who you advise, not on which types of securities are the subject of your advice. Note also that exclusion means exclusion from a definition, whereas exemption means not subject to registration. All of the cases mentioned here involve investment advisors. It's just that they qualify for an exemption from registration under state law. Knowledge Check 3.1. Question 1. Registration as an investment advisor would be required for any firm in the business of giving advice on the purchase of A. Convertible bonds, B. Gold coins. C. Rare convertible automobiles. D. Apartments undergoing a conversion to condominiums. The answer is A. Only persons in the business of giving advice on securities are required to register as investment advisors. Only the convertible bonds are securities. Question 2. Under the Uniform Securities Act, all of the following may provide investment advice incidental to their normal business without having to register as an investment advisor except A. A teacher, B. An economist, C. A lawyer, D. An engineer. The answer is B. The Uniform Securities Act does not exclude economists from the definition of investment advisor, as it does lawyers, accountants, teachers, and engineers who give advice that is incidental to the practice of their professions. Remember the acronym LATE: lawyers, accountants, teachers, and engineers. Test takers often mistake the E in LATE for economist. Question 3. The Uniform Securities Act would include all of the following in the definition of investment advisor except A. A broker-dealer who charges for investment advice, B. A publisher of a financial newspaper of general circulation, C. A person who sells security analysis, D. A CPA who, as an added service, suggests specific tax-free municipal bonds. The answer is B. A publisher of a financial newspaper that has a general circulation is excluded from the definition of investment advisor. Although broker-dealers are usually excluded, once there is a charge for investment advice, the exclusion is lost. If the CPA advice was an incidental part of her practice, she would generally be excluded. However, this choice goes on to say the specific securities are recommended, and the specificity of her advice makes her an investment advisor. Question 4. Under the Uniform Securities Act, an investment advisor with no place of business in the state would be required to register if its only clients in the state are A. Banks, B. Insurance companies, C. 6 or fewer individual clients, D. Closed-end investment companies. The answer is C. Under the USA, an investment advisor with no place of business in the state is exempt if its clients are institutional, banks, insurance companies, investment companies, and so forth. But when the advice is given to more than 5 non-institutional clients, 6 is more than 5, who are residents of the state, registration is required. Question 5. An investment advisor would be exempt from registration under the Uniform Securities Act if it had no place of business in the state and Roman numeral 1. It offered their services to no more than 5 individuals in that state during any consecutive 12-month period. Roman numeral 2. It offered their services to fewer than 15 individuals in that state during any consecutive 12-month period. Roman numeral 3. Its only clients were registered investment companies. Roman numeral 4. Its only clients were broker-dealers and other investment advisors. A. 1 and 3, B. 1, 3, and 4, C. 2 and 3, D. 2 and 4. The answer is B. To enable an investment advisor to service a small number of clients in neighboring states without the hassles of registration, the de minimis requirements allow offers to up to 5 persons, other than institutional accounts, during any 12-month period. There is no limit to the number of institutional clients, e.g., investment companies and broker-dealers. An out-of-state advisor can have and still be exempt from registration in that state. Question 6. In the absence of any other possible exemption, registration with the SEC would be prohibited for which of the following investment advisors? A. A pension consultant managing $150 million. B. The investment advisor under contract to an open-end investment company with $18 million in assets. C. An investment advisor whose assets under management are $103 million. D. An investment advisor who would be required to register in 17 states. The answer is A. In order for a pension consultant to be eligible for SEC registration, it must manage at least $200 million. An investment advisor to an investment company always registers with the SEC, regardless of the size of the fund. Advisors who would otherwise be required to register in 15 or more states qualify for an exception, and once an investment advisor has reached the $100 million threshold, SEC registration is permitted, not required until reaching $110 million. Question 7. All of the following would meet the definition of investment advisor under the Uniform Securities Act except A. A broker-dealer charging separately for investment advice. B. The publisher of a weekly magazine sold on newsstands that contains at least 5 stock recommendations per issue. C. A civil damages attorney who advertises that he is available to assist clients by suggesting appropriate investments for their successful claims. D. A finance teacher at a local community college who offers weekend seminars on comprehensive financial planning at a very reasonable price. The answer is B. Publishers of general circulation newspapers and magazines are excluded from the definition of investment advisor, even if the entire publication is devoted to investment advice. A broker-dealer loses its exclusion the moment it offers advice for a separate charge, as does an attorney who holds himself out as offering investment advice. Normally, a teacher is excluded, but not when charging for advice, as would appear to be the case here. On this examination, the term comprehensive financial planning always includes securities advice. Lesson 3.2. Registration and post-registration requirements of investment advisors. Learning Objective 3C. Classify the initial and post-registration requirements of the Uniform Securities Act applying to investment advisors. The registration requirements for an investment advisor are much like those for a broker-dealer. The USA states, "It is unlawful for any person to transact business in this state as an investment advisor, unless he is so registered under this act or is exempt from a state's registration requirements." In other words, persons included in the definition of investment advisor must register in the states in which they do business, unless they are exempt from registration. Registering with the Form ADV. The application for registration as an investment advisor is on the Form ADV. There are 4 parts to this form. Parts 1A and 1B and Parts 2A and 2B as stated previously. The effective date of registration is normally at noon of the 30th day after the filing of a complete application. Form ADV Part 1. Part 1A contains information about the IA, including location of the principal office, location of books and records, if not at the principal office, form of business organization, sole proprietorship, partnership, corporation, type S, of advisory activities provided, portfolio management for individuals, portfolio management for investment companies, financial planning services, other business activities, broker-dealer, agent of a broker-dealer, maintaining custody of customer assets and / or exercising discretion, details relating to all control persons, officers, directors, partners, etc., disciplinary history, and states in which the IA intends to or is already registered. Part 1B asks additional questions required by state securities authorities. Federal covered advisors do not complete Part 1B. Form ADV Part 2A. Part 2A is known as the Investment Advisor's Brochure and tends to focus on customer-related information, such as compensation arrangements, fees, commissions, hourly charges, types of clients, individuals, institutions, pension plans, type of investments recommended, equities, corporate debt, municipal securities, U.S. Treasuries, investment companies, types of strategies employed, buy and hold, value, growth, methods of analysis used, technical, fundamental, the consent to service of process, educational and business background of those who formulate investment advice for a client and have direct client contact, as well as those who have discretionary authority over a client's assets, and an audited balance sheet if the investment advisor requires or solicits a substantial prepayment of fees or maintains custody. The brochure is arranged in a narrative form using plain English. Part 2B requires advisors to create brochure supplements containing information about certain supervised persons. Together, Part 2A and Part 2B are delivered to the client as described later at Learning Objective 6B. State registered advisors file both Part 1 and Part 2 with the administrator of each state in which they are registering. Similar to the case with broker-dealers, anytime there is a material change to the information on the Form ADV, an amended copy must be filed with the administrator. Form ADV Part 2B. As has been mentioned earlier, Part 2B is a brochure supplement that must contain certain information about advisory personnel on whom clients rely for investment advice. The brochure supplement is also a narrative format in plain English and includes 6 required disclosure categories: cover page identifying the supervised person or persons covered by the supplement as well as the advisory firm, educational background and business experience, including disclosing if the supervised person has no high school education, no formal education after high school, or no business background, disciplinary information about material events within the past 10 years, although the SEC says that even if more than 10 years have passed since the date of the event, you must disclose the event if it is so serious that it remains currently material to a client's or prospective client's evaluation. Other business activities, including disclosing if the supervised person receives commissions, bonuses, or other compensation based on the sale of securities or other investment products, including as a broker-dealer or registered representative, agent, and including distribution or service, trail, fees from the sale of mutual funds, additional compensation beyond that paid by the client, such as a sales award or other prize, and supervision, including providing the name, title, and telephone number of the individual responsible for supervising the supervised person's advisory activities on behalf of the firm. The investment advisor must give a client a brochure supplement for the following supervised persons: any supervised person who formulates investment advice for a client and has direct client contact, or any supervised person who has discretionary authority over a client's assets, even if the supervised person has no direct client contact. Take note, although there are no minimum educational or experience requirements, there is a specific area on the Form ADV Part 2 where state-registered advisors must identify each of the principal executive officers and management persons and describe their formal education and business background. If this information has been supplied elsewhere in the Form ADV, it is not necessary to repeat it in response to this question. Test Topic Alert. Under the USA, if a federal covered investment advisor has an office in the state, the administrator may require, by rule or by order, that the IA submit any documents that have been filed with the SEC. A federal covered IA submits only Part 1A of the Form ADV. Therefore, if the administrator requests the Form ADV, all that will be sent is Part 1A. It is only a state-registered advisor who files Parts 1A and 1B. Take note, because it is important that clients and prospective clients understand that the state, or the SEC if appropriate, is not approving the advisor's information or the advisor's methods of business, it is required that the cover page of Part 2A contain the following statement. This brochure provides information about the qualifications and business practices of name of the IA. If you have any questions about the contents of this brochure, please contact us at phone number and / or email address. The information in this brochure has not been approved or verified by the SEC or by any state securities authority. Form ADV Part 3. In June 2019, the SEC implemented Regulation BI, Best Interest, for broker-dealers. At the same time, they adopted new Rule 204-5 under the Investment Advisors Act of 1940. This created the requirement for investment advisors to prepare a Customer Relationship Survey, CRS, as Form ADV Part 3. This form applies solely to investment advisors registered with the SEC who deal with retail clients. As of the date of this printing, there has been nothing about this form on the exam. If this topic becomes testable, we will note the details in exam tips and content updates and create sample questions relating to the material. Updating the Form ADV? The Form ADV must be updated each year by filing an annual updating amendment within 90 days after the end of the advisor's fiscal year. This annual updating amendment is used to update the responses to all items on the ADV. Of critical importance is the verification of assets under management, AUM, to determine if the advisor is eligible to register with the SEC or must remain state-registered. One of the requirements relating to the brochure described later in Learning Objective 6B is that submission must be made of a summary of material changes either in the brochure, cover page, or the page immediately thereafter, or as an exhibit to the brochure. Amendments for material changes. In addition to the annual updating amendment, the IA must amend the Form ADV by filing additional amendments promptly if information relating to any of the following changes or becomes inaccurate in any way. Change to the registrant's name. Change in the principal business location. Change in the location of books and records if they are kept somewhere other than at the principal location. Change to the contact person preparing the form. Change in organizational structure, such as from partnership to corporation and so on. Information provided in the brochure becomes materially inaccurate. Change to any of the questions regarding disciplinary actions, or change in policy regarding custody of the customer funds and or securities. Financial requirements for investment advisors. Under the USA, the administrator may, by rule or order, establish minimum financial requirements for an investment advisor registered in the state. The administrator may require an advisor who has custody of client funds or securities or has discretion over a client's account to post a surety bond or maintain a minimum net worth. Usually, the requirement is higher for custody than for discretion. Typically, the net worth required of investment advisors with discretionary authority is $10,000, and that for those taking custody is $35,000. If the investment advisor does both, the $35,000 is sufficient. Test topic alert. Because the USA is only a template, some states have higher net worth or bonding requirements. The exam may want you to know that if an IA meets the net worth or surety bonding requirements of the state where its principal office is located, that is sufficient in any other state in which it may be registered. Record-keeping requirements for investment advisors. Because this exam is about agents and their broker-dealers, the fine details of record-keeping for investment advisors is not tested. Any of the general business records required by broker-dealers have the same requirement for investment advisors. One major difference is the retention requirements. While broker-dealers must keep most of their records for 3 years, the first 2 easily accessible, it is not less than 5 years from the end of the fiscal year during which the last entry was made on that record, with the first 2 easily accessible for investment advisors. Similar to the broker-dealer rule, for investment advisors registered in multiple states, the location of the principal office determines which state's rules to follow. Take note, many investment advisors are duly registered. That means they are registered as broker-dealers and as investment advisors. The record-keeping requirements are kept separate. That is, records relating to the broker-dealer operation have the shorter retention period than those applying to the advisory function. Knowledge Check 3.2. Question 1. If a prospective client wanted to know what type of investment strategies are used by an investment advisor, the desired information would be found in the advisor's A. Form ADV Part 1A, B. Form ADV Part 1B, C. Form ADV Part 2A, D. Form ADV Part 2B. The answer is C. The Form ADV Part 2A contains the most useful information to clients, such as the type of strategies used by the advisor. Part 1A contains information needed by the regulators, Part 1B is only for state-registered IA, and Part 2B contains information dealing with individuals in the firm who manage accounts. Question 2. Mammon Money Managers, MMM, has its principal office in State A and is also registered in States B, C, and D. MMM exercises discretion in client accounts. As a result, MMM would have to meet the net worth or bonding requirements of A, the SEC, B, State AC, the state with the highest requirement, D, each state. The answer is B. A state-registered investment advisor only needs to meet the financial requirements of the state in which its principal office is located. SEC requirements are meaningless here because this is a state-registered firm. Question 3. Thomas Hobson is the founder and principal owner of Hobson Investment Strategies. His has its principal office in State A with branch offices in States B, C, and D. On its last annual updating amendment, his reported AUM of $300 million. His maintains custody of client assets. As a result, when it comes to meeting financial requirements, Hobson's choice would be adhering to those of A, the SEC, B, State AC, the state with the highest requirements, D, the state. The answer is A, with AUM of $300 million. Hobson Investment Strategies is a federal covered advisor. Therefore, no state may impose financial or record-keeping requirements. It is only those of the SEC that must be followed. Question 4. With regard to state-registered investment advisors, all of the following statements regarding the powers of the administrator are true except A. The administrator may request submission of literature used by the advisor to solicit new business. B. The administrator must be provided with a detailed description of the advisor's proposed method of selecting investments. C. An investment advisor's registration must be renewed each December 31. D. The administrator may rule that custody of client funds is not permissible. The answer is B. It is not required that an investment advisor disclose to the administrator the methods it uses to select investments. The administrator can request to see sales literature used by the IA. As will all securities professionals, the registration comes up for renewal each December 31. As long as it is not prohibited under the state securities laws, if a state-registered investment advisor plans to maintain custody of customer assets, written notification must be given to the administrator. Question 5. Perfidy Trusted Advisors, TA, is registered as an investment advisor in States A, B, and C. PTA principal office is in State B. As such, PTA must meet the record-keeping requirements of A. The state having the longest requirement, B. The state having the shortest requirement, C. State B, D. The SEC. The answer is C. A state-registered investment advisor must meet the record-keeping requirements of the state where its principal office is located. In this question, that would be State B. The SEC's requirement is relevant only for federal covered advisors. How do we know PTA is not a federal covered investment advisor? We know because covered advisors never register with any state. Lesson 3.3. Who is and who is not an investment advisor representative? Learning Objective 3D. Define investment advisor representative. An investment advisor representative, IR, is any partner, officer, director, or an individual occupying a similar status or performing similar functions, or other individual employed by or associated with an investment advisor that is registered or required to be registered under the Uniform Securities Act, state-registered IA. If employed by or associated with a federal covered advisor, This individual only comes under the registration requirements by having a place of business in the state. In both cases, state or federal, the individual meets the definition of an IAR by doing any of the following: making any recommendations or otherwise rendering advice regarding securities, managing accounts or portfolios of clients, determining which recommendation or advice regarding securities should be given, soliciting, offering, or negotiating for the sale of, or selling investment advisory services, supervising employees who perform any of the above. As described at Learning Objective 2G, while registration as an agent or IAR is pending, the individual may not take part in any activity that would require registration. Clerical work or assisting with research is a permitted activity. Take note, the use of the term individual here is important. Only an individual or a natural person can be an investment advisor representative. The investment advisory firm is the legal person, entity that the IAR, natural person, represents in performing the above listed functions. Learning Objective 3E, identify exclusions and exemptions from the definition of investment advisor representative under the Uniform Securities Act. The USA exclusions from the definition of investment advisor representative. Certain employees of investment advisory firms are excluded from the term investment advisor representative, provided their activities are confined to clerical duties or those activities that are solely incidental to the investment advisory services offered, such as mailing out a research report to an advisory client when directed by an IAR should the investment advisory employee step over the line, as the saying goes, and perform any activity that makes one an IAR. The employee would then have to register as an investment advisor representative. Exclusion criteria for administrative employees of investment advisors are much the same as those for administrative personnel of broker-dealers. Take note, although not specifically tested, you should know that to become an investment advisor representative, one must pass either the NASA Series 65 or Series 66 exam. In the case of the Series 66, the FINRA Exam Series 7 exam must also be completed. The USA exemptions from the requirement to register as an investment advisor representative. The USA allows several exemptions from the requirement to register as an IAR. If the following discussion sounds familiar, it should because much of it is the same as covered at Learning Objective 3B. However, in the second paragraph following, we will be focusing on one specific point that is highly tested and only applies to IARs. No place of business in the state. An exemption from registration exists when the individual is licensed under the Securities Act of a state in which the individual maintains a place of business, and the individual offers advice in this state to a person who is an existing customer of the person and whose residence is not in this state. This is sometimes referred to as the snowbird exemption and applies to investment advisor representatives as well as the other three categories of securities professionals. Representing a federal covered investment advisor. There is a special rule applying to those individuals who represent federal covered IA. That rule is found in Section 203A of the Investment Advisors Act of 1940. It states that for those performing as IARs for federal covered advisors, state registration is required only in those states where that individual has a place of business. Place of business of an investment advisor representative means 1. An office at which the investment advisor representative regularly provides investment advisory services, solicits, meets with, or otherwise communicates with clients. And 2. Any other location that is held out to the general public as a location at which the investment advisor representative provides investment advisory services, solicits, meets with, or otherwise communicates with clients. Test Topic Alert. This provision is highly testable. It is critical to remember that individuals representing a federal covered investment advisor only register in those states where they have a place of business. An IRR could have 1,000 or more clients in a specific state and not register there if that IRR did not maintain a place of business in the state. On the other hand, if there were a place of business and the IRR had a single client, registration would be required. This is true only for those affiliated with federal covered advisors and means there is no de minimis rule for them. Learning Objective 3F. Classify the initial and post-registration requirements of the Uniform Securities Act applying to investment advisor representatives. Registration requirements for investment advisor representatives. It is unlawful for any state-registered investment advisor to employ an investment advisor representative unless the investment advisor representative is registered under this act. However, the registration of an investment advisor representative is not effective during any period when she is not employed by an investment advisor registered under this act. The same holds true for a federal covered advisor to employ, supervise, or associate with an investment advisor representative having a place of business located in this state, unless such investment advisor representative is registered under this act or is exempt from registration. Registration is most often accomplished through the filing of the Form U-4. There is another option, the Form U-10, but we have not heard anything about that appearing on the exam. Just as was the case described earlier with a broker-dealer, registration of an investment advisor also leads to automatic investment advisor representative registration of partners, officers, or directors active in the business, and anyone else performing a similar function. Furthermore, the effective day of registration is as previously stated, noon of the 30th day after the filing of a complete application. Many independent financial planners operate as independent contractors, not employees of investment advisory firms or broker-dealers. Regardless, they are required to be registered as investment advisor representatives of the firm and must be placed under the same level of supervisory scrutiny as employees. Their business cards may contain the name of their separate planning entity, but must also disclose the name of the entity registered as the investment advisor. Similar to agents, financial planner initial registration is accomplished by filing a Form U-4, including a consent to service of process. As is the case with all of the securities professionals, the renewal date is December 31. Test topic alert. Registered investment advisors are responsible for the supervision of individuals registered as investment advisor representatives, but are acting in the capacity of independent contractors to the same extent that they supervise those who are actual employees of the firm. Test topic alert. Registration as an IAR is done solely on a state basis. IARs never register with the SEC, even when they are representing a federal covered advisor. That is why it is NASA who has the responsibility for this exam, rather than FINRA or the SEC. Take note. An individual may act as both an investment advisor and an investment advisor representative. This is typically the case when the business is organized as a sole proprietorship. Other than that situation, an individual who acts solely as an investment advisor representative is excluded from the definition of investment advisor. IAR termination procedures. If an investment advisor representative terminates employment with an investment advisor, notification requirements depend on how the investment advisor is registered. If the investment advisor is a state-registered advisor, the firm must notify the administrator. If the investment advisor is a federal covered advisor, the investment advisor representative must notify the administrator. All notifications must be made promptly. A clue that might help is to visualize the I in IAR as the number 1 to remember that only one person gives notification. What is the story if the IAR leaves one firm to go to another? Test topic alert. This provision is highly testable. It is critical to remember that individuals representing a federal covered investment advisor only register in those states where they have a place of business. An IR could have 1,000 or more clients in a specific state and not register there if that IR did not maintain a place of business in the state. On the other hand, if there were a place of business and the IR had a single client, registration would be required. This is true only for those affiliated with federal covered advisors and means there is no de minimis rule for them. Learning Objective 3F. Classify the initial and post-registration requirements of the Uniform Securities Act applying to investment advisor representatives. Registration requirements for investment advisor representatives. It is unlawful for any state-registered investment advisor to employ an investment advisor representative unless the investment advisor representative is registered under this act. However, the registration of an investment advisor representative is not effective during any period when she is not employed by an investment advisor registered under this act. The same holds true for a federal covered advisor to employ, supervise, or associate with an investment advisor representative having a place of business located in this state, unless such investment advisor representative is registered under this act or is exempt from registration. Registration is most often accomplished through the filing of the Form U-4. There is another option, the Form U-10, but we have not heard anything about that appearing on the exam. Just as was the case described earlier with a broker-dealer, registration of an investment advisor also leads to automatic investment advisor representative registration of partners, officers, or directors active in the business, and anyone else performing a similar function. Furthermore, the effective day of registration is as previously stated, noon of the 30th day after the filing of a complete application. Many independent financial planners operate as independent contractors, not employees of investment advisory firms or broker-dealers. Regardless, they are required to be registered as investment advisor representatives of the firm and must be placed under the same level of supervisory scrutiny as employees. Their business cards may contain the name of their separate planning entity, but must also disclose the name of the entity registered as the investment advisor. Similar to agents, financial planner initial registration is accomplished by filing a Form U-4, including a consent to service of process. As is the case with all of the securities professionals, the renewal date is December 31. Test topic alert. Registered investment advisors are responsible for the supervision of individuals registered as investment advisor representatives, but are acting in the capacity of independent contractors to the same extent that they supervise those who are actual employees of the firm. Test topic alert. Registration as an IR is done solely on a state basis. IARs never register with the SEC, even when they are representing a federal covered advisor. That is why it is NASA who has the responsibility for this exam, rather than FINRA or the SEC. Take note, an individual may act as both an investment advisor and an investment advisor representative. This is typically the case when the business is organized as a sole proprietorship. Other than that situation, an individual who acts solely as an investment advisor representative is excluded from the definition of investment advisor. IR termination procedures. If an investment advisor representative terminates employment with an investment advisor, notification requirements depend on how the investment advisor is registered. If the investment advisor is a state-registered advisor, the firm must notify the administrator. If the investment advisor is a federal covered advisor, the investment advisor representative must notify the administrator. All notifications must be made promptly. A clue that might help is to visualize the I in IR as the number 1 to remember that only one person gives notification. What is the story if the IR leaves one firm to go to another? IARs. Individuals employed by investment advisors to give advice to their clients. After an IR advises a client about a specific security, the next step is to contact the broker-dealer where that client maintains a brokerage account to give the buy/sell order to an agent. Now that we have defined the 4 categories of securities professionals, here is an explanatory summary. A broker-dealer is a business entity. From a legal standpoint, this entity may be organized as a sole proprietorship, but in the real world, there are less than a handful of FINRA members who are. Virtually every BD is a corporation, partnership, or LLC. The primary business function of all broker-dealers is the execution of securities transactions, either for their clients or for their own accounts. These firms hire individuals, known on this exam as agents, to work for them. You may have heard the term stockbroker, registered rep, account executive, and so forth, but on this exam, they are only called agents. The role of an agent is to represent her employer, the broker-dealer, in working with clients or supervising those who do. Upon completing the registration requirements, including passing this exam, a person will be an agent. Agents are always individuals. An investment advisor, like a broker-dealer, is a business entity. Unlike broker-dealers, there are a number of IA who are organized as sole proprietorships. There is a reason for this, but it is totally unrelated to anything you will ever have to know for the exam. Still, most investment advisors are structured as corporations, partnerships, or LLCs. The primary function of every investment advisor is, as the name implies, to give investment advice. They do not engage in securities transactions. That is the role of a BD. Just as broker-dealers hire individuals, agents, to work for them, investment advisors hire individuals, known as investment advisor representatives, to represent them in the rendering of investment advice. Once again, we have an employer/employee relationship. There are many firms that are registered as both broker-dealers and investment advisors. Therefore, there are many individuals who are agents as well as IARs. These are 2 different roles that perform different functions. Hopefully, this summary makes it clear what these are. Example: let's use 3 syllogisms to make a couple of testable points. Mary is an investment advisor representative. All investment advisor representatives work for investment advisors. Therefore, Mary works for an investment advisor. Here is another one. Albert is an agent. All agents are individuals. Therefore, Albert is an individual. These 2 examples tell us that IARs go together with IA, and anyone who is an agent is a natural person. That is also true of IARs, but we did not include that in the syllogism. How about this one? Woodward is an agent. All agents work for broker-dealers. Therefore, Woodward works for a broker-dealer. This is faulty logic because some agents can work for issuers, so we cannot determine who Woodward represents. Knowledge Check 3.3. Question 1. Under the Uniform Securities Act, which of the following requires registration as an investment advisor representative? A. An employee, highly skilled in evaluating securities, who performs administrative or clerical functions for an investment advisor. B. An individual who renders fee-based advice on precious metals. C. A solicitor for an investment advisory firm who is paid a fee for his services. D. An agent of a broker-dealer who offers incidental advice on securities as part of his sales commissions. The answer is C. An individual who solicits business for an investment advisor is considered an investment advisor representative under the Uniform Securities Act. An employee who performs only clerical or administrative functions is not an investment advisor representative. Precious metals are not securities. Therefore, a person advising on them is not considered an investment advisor representative. An agent is a representative of a broker-dealer, and as long as the only form of compensation is sales commissions, registration as an investment advisor representative is not required. Question 2. Under the Uniform Securities Act, any partner, officer, or director of a registered investment advisor is an investment advisor representative if she, Roman numeral 1, offers advice concerning securities, Roman numeral 2, manages client accounts or portfolios. Roman numeral 3. Determines securities recommendations for representatives to disseminate. Roman numeral 4. Supervises personnel engaged in the above activities, but does not sell these services to the public. A. 1 only, B. 1 and 2, C. 1, 2, and 3, D. 1, 2, 3, and 4. The answer is D. The Uniform Securities Act defines persons associated with an investment advisor as investment advisor representatives, including any partner, officer, or director who offers advice concerning securities. Persons who manage client accounts or portfolios, determine securities recommendations, or supervise personnel engaged in the above activities are investment advisor representatives. Question 3. Sharika Williams is an investment advisor representative with High Tide Advisors, a federal covered investment advisor with its principal office in State X. Williams provides advisory services to a bank located in State X, a state in which she has no place of business. Under current regulations, A. Because Williams has no place of business in State X, she does not have to register as an IRR in State X. B. Because Williams' client is a bank, she does not have to register as an IRR in State X. C. Because Highwater's principal office is in State X, Williams would be required to register as an IRR in State X. D. Because Williams has a client in State X, registration as an IRR would be required in State X. The answer is A. The key is that Williams is an IRR for a covered IA. When that is the case, the IRR is required to register only in states where she, the IRR, maintains a place of business. Williams does not have a place of business in State X, so no registration is required there. The fact that the client is a bank is of no relevance, nor is the location of her employer's principal office. Question 4. Allison Cook is an investment advisor representative with a state-registered investment advisor. Cook operates out of an office in State Y. She would be required to register in State Z if during the previous 12 months she had A. Fewer than 6 retail clients who were residents of State Z, B. 5 or fewer retail clients who were residents of State Z, C. No more than 5 retail clients who were residents of State Z, D. 6 or fewer retail clients who were residents of State Z. The answer is D. The de minimis exemption applies when during the preceding 12-month period, the IRR has had no more than 5 retail clients. There are 3 ways of stating that. 1. No more than 5. 2. 5 or fewer. 3. Fewer than 6. Question 5. DEF Investment Advisors, organized as a partnership, is currently registered with State Y. Marjorie is one of the partners and is registered as an IRR if DEF were to register with State Z. A. Marjorie would be required to complete an application for IRR registration with State Z. B. Marjorie would automatically be registered as an IRR in State Z. C. Marjorie's registration as an IRR in State Z would become effective after passing the Series 6-5 or Series 66 exam. D. Because DEF is a state-registered investment advisor, Marjorie could only register in State Z if she was a resident of the state. The answer is B. When DEF registration becomes effective in State Z, those individuals included in the filing are granted automatic registration. They don't have to file an individual Form U-4. That filing includes the names and other pertinent information about all of the partners, officers, or directors who are already acting as IARs. Please note, it is not any IRR, it is only those listed, or, as the rule states, those occupying a similar status, etc., who receive this treatment. No new test is required because Marjorie passed that when registering in State Y. Question 6. Which of the following securities professionals must be a natural person? Roman numeral 1. An agent, Roman numeral 2. A broker-dealer, Roman numeral 3. An investment advisor, Roman numeral 4. An investment advisor representative, A. in review, B. in review, C. D. Holy and review. The answer is B. Registration as an agent or investment advisor is limited to natural persons, individuals. Virtually all broker-dealers are organized as some form of business entity, corporation, partnership, etc. Although there are a significant number of investment advisors organized as sole proprietorships, most of the larger ones are structured as a form of business entity, such as a corporation or partnership. Unit 4. Securities and their issuers, registration and exemptions. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 4A. Identify instruments that the Uniform Securities Act defines as securities. Learning Objective 4B. Identify those who issue securities. Learning Objective 4C. Identify the methods of security registration under the Uniform Securities Act. Learning Objective 4D. Recollect the procedures for registering non-exempt securities under the Uniform Securities Act. Learning Objective 4E. Recognize the securities exempt from registration under the Uniform Securities Act. Learning Objective 4F. Recall the exempt transactions under the Uniform Securities Act. Introduction. State securities administrators regulate securities transactions that occur in their states similarly to the way they regulate persons engaged in those transactions. This unit discusses the procedures for the registration of securities as well as their exemptions from registration. For a securities transaction to be lawful under the USA, the security itself must be registered unless it or the transaction is exempt from registration requirements. The Series 63 exam will include 3 questions on the material presented in this unit. Please note, there is a great deal of material covered in this unit, considering that only 3 questions will appear on the exam. It is necessary to include all of this because those few questions will be drawn from the breadth of the topic. Keeping in mind the minimal coverage of this unit on the exam, do not get bogged down on this unit and move on to others with a greater point value. Lesson 4.1. What are securities and who issues them? What is included in the Uniform Security Act's definition of a security? Learning Objective 4A. Identify instruments that the Uniform Securities Act defines as securities. Perhaps the most important term in the Uniform Securities Act is the term security. Why is it so important? The reason is simple. The USA applies only to those financial instruments that are securities. The purchase, sale, or issuance of anything that is not a security is not covered by the Act. The definition of a security, however, is complex. Over the years, courts have determined case by case what constitutes a security. The U.S. Supreme Court, in the Howey decision, defined the primary characteristics of what constitutes a security. Howey is still the leading case on the definition of an investment contract as a security. For an instrument to be a security, the court held it must constitute 1. An investment of money, 2. In a common enterprise, 3. With the expectation of profits, 4. To be derived primarily from the efforts of a person other than the investor. A common enterprise means an enterprise in which the fortunes of the investor are interwoven with those of either the person offering the investment, a third party, or other investors. Example, let's show how common stock in a corporation meets the Howey definition. If you purchase shares, you have invested money, 1, as have a number of other investors, 2, hoping to make money by receiving dividends or selling the stock at a profit, 3, and your success depends not on your efforts, but on the skill of the management of that corporation, 4. List of securities under the Uniform Securities Act. The USA does not define the term securities, but provides a comprehensive list of financial instruments that are securities under the Act, and therefore are covered by its provisions. Under the Uniform Securities Act, security means any. Note, stock, treasury stock, bond, debenture. Evidence of indebtedness such as a promissory note, certificate of interest or participation in a profit-sharing agreement, collateral trust certificate, pre-organization certificate or subscription, transferable share, investment contract, voting trusts certificate, certificate of deposit for a security, adders, not a bank CD, certificate of interest or participation in an oil, gas, or mining title or lease, or in payments out of production under such a title or lease, puts, calls, straddles, options, or privileges on a security, any interest or instrument commonly known as a security, or certificate of interest or participation in, receipts of, guarantees of, or warrants or rights to subscribe to or purchase any of the above. The following 6 items are not securities under the Act: an insurance or endowment policy or annuity contract under which an insurance company promises to pay a fixed sum of money, either in a lump sum or periodically. This is basically any product from a life insurance company that does not use the word variable. Interest in a retirement plan, such as an IRA or 401k plan. Collectibles. Commodities such as precious metals and grains or futures contracts for commodities. Condominiums used as personal residences. Currency. Test topic alert. The exam will want you to know what is and what is not a security. We suggest that you concentrate on learning the 6 that are not securities because they are much easier to remember, and you will still be able to answer the questions correctly. You might also have to know that a confirmation of a securities trade is not a security. It is just a document evidencing that a transaction took place. Non-security investments, although collectibles, fixed annuities, precious metals, grains, futures, real estate, and currencies can be attractive investments, they are not securities. Because these items are not securities, their sale is not regulated by state securities law. Furthermore, if a registered agent commits fraud in the sale of any of these items, he has not committed a violation of state securities law. He has violated the antifraud provisions of another act prohibiting fraudulent commercial transactions. An individual's direct ownership of an automobile is not a security. It is just ownership of a car. However, if that individual makes an investment of money in the stock of an automobile manufacturer with the expectation of making money due to the efforts of the company's management skill, he has purchased a security. In the same manner, if a condominium is purchased in a resort area with the goal of placing it into a rental pool and renting it out most of the year, and it is used only for personal vacation time, the condo is considered a security because there is a profit motive, typically reliant on the efforts of a third party, the rental agent. On the other hand, if the individual has chosen to live in the condominium as a personal residence, it is a home, not a security. Example: annuities with fixed payouts are not securities, but variable annuities are because they are dependent on the investment performance of securities within the annuity separate account portfolio. Learning Objective 4B, identify those who issue securities. Issuer. An issuer is any person who issues, distributes, or proposes to issue a security. The most common issuers of securities are companies or governments, federal, state, and municipal governments and their agencies and subdivisions. If an issuer is non-exempt, it must register its securities in the states where they will be sold under one of the registration methods described in the unit. Example: ABC Shoe Company, a retail chain store, issues shares to the public. Mr. Bixby, an investor, buys the shares through his agent, Mr. Thompson, at First Securities Corporation. ABC Shoe Co. is the issuer, Mr. Bixby is the investor, First Securities is the broker-dealer, and Mr. Thompson is the agent. Test topic alert. You might need to know this legal statement. Under the Uniform Securities Act, with respect to certificates of interest, participation in oil, gas, or mining titles or leases, or in payments out of production under such titles or leases, there is not considered to be any issuer. Issuer transaction. An issuer transaction is one in which the proceeds of the sale go to the issuer. All newly issued securities are issuer transactions. In other words, when a company raises money by issuing securities to investors, the proceeds from the sale go to the company itself. Primary offering. An issuer transaction involving new securities is called a primary offering. If it is the first time an issuer distributes securities to the public, it is called an initial public offering, IPO. Any offering of new securities, whether initial or an offering of additional securities at a later time, is an issuer transaction because the issuer, the company, receives the proceeds from the investor investing in the company. Non-issuer transaction. A non-issuer transaction is one in which the proceeds of the sale do not go, either directly or indirectly, to the entity that originally offered the securities to the public. The most common example is everyday trading in the secondary markets, such as the New York Stock Exchange or the Nasdaq stock market. In a non-issuer transaction, the proceeds of the sale go to the investor who sold the shares. Because the shares are not new, we refer to this as secondary trading. Secondary offering. As previously discussed, when the proceeds of the sale go to the issuer, it is a primary offering. However, it is not unusual to find a large shareholder, sometimes a founder of the company or an institution holding a large block of the company's stock, desiring to sell a large portion of their holding. In many cases, SEC regulations require that, due to the size of the offering, registration is necessary. When that happens, it is a secondary distribution and classified as a non-issuer transaction because the proceeds go to the seller rather than the issuer. Example: the first time that ABC Shoe Company issued shares to the public, ABC Shoe engaged in an IPO or a primary offering because it received the proceeds from distributing its shares to the public. After ABC Shoe went public, transactions between its investors executed on exchanges through brokerage agents were secondary transactions in non-issuer securities. If Mr. Bixby, an investor, sells 100 shares of stock he owns in ABC Shoe Co., the issuer of the security on the New York Stock Exchange, NYSE, Mr. Bixby receives the proceeds from the sale, not ABC Shoes. This is a non-issuer transaction. Knowledge Check 4.1. Question 1. Which of the following is included in the Uniform Security Act's definition of a security? A. An individual's vested interest in his 401k plan. B. Fixed, guaranteed annuity payments made for life or for a specified period. C. Commodity futures contracts. D. A U.S. Treasury bond. The answer is D. Any bond, regardless of the nature of the issuer, is considered a security. The physical commodity as well as futures contracts on commodities are included in the list of non-security investments. Retirement plans and fixed annuities are not securities. Question 2. Included in the Uniform Securities Act's definition of a security would be A. Collectibles, B. Commercial paper, C. Commodities, D. Currency. The answer is B. Commercial paper, a form of promissory note, is a security. Please note that the term commercial paper is not used in our list of a few pages ago. That should not have affected your ability to select the correct answer. Remember our statement that the way to get these questions correct on the exam is to learn the 6 items that are not securities. 4 of them begin with the letter. See, the one missing here is a condominium used as a personal residence. Question 3. A primary transaction is A. The first transaction between 2 parties in the over-the-counter market. B. A sale between investors of securities traded on the New York Stock Exchange. C. A new offering of an issuer sold to investors. D. When the proceeds of the sale go to the selling party. The answer is C. A primary transaction is a new offering of securities by an issuer sold to investors. The key is that the proceeds of the sale go to the issuer. Transactions between two investors in the over-the-counter market are called secondary transactions, the market between investors. A sale between investors of securities traded on the New York Stock Exchange is another example of a secondary transaction. In both of those cases, the proceeds of the sale go to the selling party, but that party is not the issuer. Question 4. State F is proposing to issue a $100 million bond issue. The Uniform Securities Act would define State F as A. An issuer, B. A municipality, C. An institutional investor, D. An underwriter. The answer is A. Under the USA, issuer means any person who issues or proposes to issue any security. Persons include governments, such as states. Would this be a municipal bond? Yes. Are there conditions where a state could be considered an institutional investor? Yes. On this exam, you must look at the context of the question. It is dealing with issuing a security. Who issues securities? Issuers. Lesson 4.2. Registration of securities under state law. Registration of securities under the Uniform Securities Act. Learning Objective 4C, identify the methods of security registration under the Uniform Securities Act. Let's begin with a statement that is key to understanding the basic law involving the sale of securities on the state level. The following is a direct quote from the Uniform Securities Act. It is unlawful for any person to offer or sell any security in this state unless it is registered under the Act. The security or transaction is exempted from registration under the Act, or it is a federal covered security. Or put into our words, if the security or transaction is not exempt or is not a federal covered security as defined by the NISMIA, it must be registered in the state, or it cannot be lawfully sold in the state. National Securities Markets Improvement Act of 1996, NISMIA. We introduced you to the NISMIA in the previous unit. This law effectively divided the responsibility for regulating investment advisors between the states and the SEC by bifurcating, splitting in two, the regulation of investment advisors and creating the category of registration known as a federal covered advisor. Of importance to this unit, the NISMIA also created the term federal covered security, a security that was exempt from registration on the state level. Examples include securities listed on national stock exchanges, investment companies registered under the Investment Company Act of 1940, and securities issued by federal and state governments. State securities registration requirements were preempted with respect to federal covered securities. However, states may require notice filings consisting of filing fees and copies of documents filed with the Securities and Exchange Commission, SEC. Notice filing is used primarily for registered investment companies, such as mutual funds. You may see the term simply as covered security. We will get into the details later in this unit at exempt securities. Methods of state registration of securities. The USA provides two methods for securities issuers to register their securities in a state, plus a special method for certain federal covered securities. They are notice filing, coordination, and qualification. Notice filing. As previously mentioned, the National Securities Markets Improvement Act of 1996, NISMIA, designated certain securities as federal covered and therefore removed from the jurisdiction of the state regulatory authorities. Although the states are preempted from requiring registration for federal covered securities, status as a federal covered security is not a preemption of the licensing or antifraud laws. Any person who sells a federal covered security must be licensed as a broker-dealer or agent, unless otherwise exempted, and must also comply with the antifraud provisions of state laws. The Uniform Securities Act gives the administrator the authority to require notice filings with respect to federal covered securities. Generally, investment companies registered with the SEC under the Investment Company Act of 1940. So, what is this notice filing? Primarily, it is an opportunity for the states to collect revenue in the form of filing fees because, unlike with the two actual methods of registration we are going to discuss, the administrator has limited powers to review any documentation filed with his department. The fees for notice filing are generally lower than for the two forms of state registration. Under the notice filing procedure, state administrators may require the issuer to file the following documents as a condition for sale of its securities in the state. Documents filed along with their registration statements filed with the SEC. Documents filed as amendments to the initial federal registration statement, a report on the value of such securities offered in the state, consent to service of process. Test topic alert. Before the initial offer of any federal covered security in this state, the administrator may, by rule or order, require the filing of all documents that are part of a federal registration statement filed with the U.S. Securities and Exchange Commission under the Securities Act of 1933, together with a consent to service of process signed by the issuer. However, unless there is an appearance of fraud, the administrator does not have the power, because of lack of jurisdiction, to prevent the sale of a federal covered security in his state. Test topic alert. Even though an issuer of a federal covered security, think about a Fortune 500 company listed on the NYSE, may not have to notice file, that does not mean that the company can make misrepresentations during an offer made in any state. Doing so would violate the antifraud provisions of the USA. Registration by coordination. The most common form of registration for those securities that are not federal covered, typically securities traded on the OTC Bulletin Board or the OTC Link, is coordination. A security may be registered by coordination if a registration statement has been filed under the Securities Act of 1933 in connection with the same offering. In coordinating a federal registration with state registration, issuers must supply the following records in addition to the consent to service of process: copies of the latest form of prospectus filed under the Securities Act of 1933 if the administrator requires, copy of articles of incorporation and bylaws, copy of the underwriting agreement, copies of any other information filed by the issuer under the Securities Act of 1933 if the administrator requests, each amendment to the federal prospectus promptly after it is filed with the SEC. Effective date. Registration by coordination becomes effective at the same time the federal registration becomes effective, provided that no stop orders have been issued by the administrator and no proceedings are pending against the issuer. The registration has been on file for at least the minimum number of days specified by the administrator, a number that currently ranges from 10 to 20 days, depending on the state, and a statement of the maximum and minimum proposed offering prices and maximum underwriting discounts and commissions have been on file for 2 full business days. Registration by coordination is by far the most frequently used method, and from a practical standpoint, is the only sensible way to register a multi-state offering. Registration by qualification. Any security can be registered by qualification, but this method is almost exclusively used for intrastate, single-state offerings. Intrastate offerings are not registered with the SEC. That makes them ineligible for registration by coordination. Registration by qualification requires a registrant to supply any information required by the state securities administrator. Securities not eligible for registration by another method must be registered by qualification. To register by qualification, an issuer must supply a consent to service of process and the following information: name, address, and form of organization, description of property and nature of business, information on directors, officers, and every owner of 10% or more of the issuer's securities, and the remuneration paid to owners in the last 12 months, description of the issuer's capitalization and long-term debt, estimated proceeds and the use to which the proceeds will be put, type and amount of securities offered, offering price, and selling and underwriting costs. Stock options to be created in connection with the offering, copy of any prospectus, pamphlet, circular, or sales literature to be used in the offering, specimen copy of the security, along with opinion of counsel as to the legality of the security being offered, audited balance sheet current within 4 months of the offering, with an income statement for 3 years before the balance sheet date. The administrator may require additional information by rule or order. The administrator may require that a prospectus be sent to purchasers before the sale and that newly established companies register their securities for the first time in a state by qualification. Example: knowing which method goes with what kind of security or offering is important. Let's do a simple matching exercise. Match the term in column B that goes with the registration term in column A. Column A: coordination, notice filing, qualification. Column B1: intrastate offering. 2. SEC plus state registration. 3. Registered investment company. The answer is coordination. 2. Notice filing. 3. Qualification. 1. Take note. As we've noted previously, in order to register, even by notice filing, there must be a consent to service of process filed with the administrator. However, a person, remember the broad definition, who has filed such a consent in connection with a previous registration or notice filing need not file another. A practical effect of this is if a company decides to raise additional capital by issuing more stock, a new consent is not required. Effective date. Unlike coordination, in which the effective date is triggered by SEC acceptance of the registration, a registration by qualification becomes effective whenever the state administrator so orders. Regardless of the method used, every registration statement is effective for 1 year from its effective date. Unlike agent and broker-dealer registrations, the date December 31 is of no consequence. One interesting facet of the law is that the registration may remain in effect past the first anniversary if there are still some unsold shares remaining, as long as they are still being offered at the original public offering price by either the issuer or the underwriter. Although the previous rule applies to all methods of registration, as a practical matter, it would rarely apply other than in a security registered by qualification. Those registered by coordination are also obviously registered with the SEC and therefore are sold by the major investment banking houses. Unless the issue is a real dog, it will sell out rather quickly. Even those that are not popular are usually completely subscribed to in a week or 2. On the other hand, what if the issue, regardless of the method of registration, is in very high demand? Is it possible to increase the number of shares in the offering without having to file a new registration statement? Yes. A registration statement may be amended after its effective date in order to increase the securities specified to be offered and sold if 2 conditions are met. The public offering price is not changed from the amounts stated in the original registration statement. The underwriter's discounts and commissions are not changed from the respective amounts stated in the original registration statement. The amendment becomes effective when the administrator so orders. Every person filing such an amendment shall pay a late registration fee and a filing fee, calculated in the same manner as the original quantity, levied against the additional securities proposed to be offered. Test topic alert. A registration statement may be amended after its effective date to change the number of shares to be offered and sold, as long as the public offering price and underwriters' discounts and commissions are unchanged. Learning Objective 4D. Recollect the procedures for registering non-exempt securities under the Uniform Securities Act. State securities registration procedures. The first step in the registration procedure is for the issuer or its representative to complete a registration application and file it with the state securities administrator. The person registering the securities is known as the registrant. There are some provisions applicable to all registrations regardless of the method used. The exam will want you to know these well. Filing the registration statement. State administrators require every issuer to supply the following information on their applications: amount of securities to be issued in the state, states in which the security is to be offered, but not the amounts offered in those other states, any adverse order or judgment concerning the offering by regulatory authorities, court, or the SEC, anticipated effective date, anticipated use of the proceeds, why are we raising this money? Test topic alert. One item that will not be found in the registration statement is the rating of the security. Test topic alert. Although most registration statements are filed by the issuer, the exam may require you to know that they may also be filed by any other person, such as a stockholder making a large block sale or by a broker-dealer. Filing fee. The issuer or any other person on whose behalf the offering is to be made must pay a filing fee as determined by the administrator when filing the registration. The filing fees are often based on a percentage of the total offering price. Ongoing reports. The administrator may require the person who filed the registration statement to file reports to keep the information contained in the registration statement current and to inform the administrator of the progress of the offering. Test topic alert. These reports cannot be required more often than quarterly. Escrow. As a condition of registration under coordination or qualification, the administrator may require that a security be placed in escrow if the security is issued, within the past 3 years, to a promoter at a price substantially different than the offering price, or to any person for a consideration other than cash. In addition, the administrator may require that the proceeds from the sale of the registered security in this state be impounded until the issuer receives a specified amount from the sale of the security either in this state or elsewhere. There have been many instances where companies were unable to raise their targeted goal and just took the money and ran. This impound or escrow lessens the likelihood that this will happen. Special subscription form. The administrator may also require, as a condition of registration, that the issue be sold only on a form specified by the administrator, and that a copy of the form or subscription contract be filed with the administrator or preserved for up to 3 years. Practice question. With regard to the registration requirements of the Uniform Securities Act, which of the following statements are true? Roman numeral 1. Only the issuer itself can file a registration statement with the administrator. Roman numeral 2. An application for registration must indicate the amount of securities to be issued in the state. Roman numeral 3. The administrator may require registrants to file quarterly reports. A 1 and 2, B 1 and 3, C 2 and 3, D 1, 2, and 3. The answer is C. The USA requires that any application for registration include the amount of securities to be sold in that state. The administrator has the power to request regular filings of reports, but no more frequently than quarterly. Although the issuer is most commonly the registrant, selling stockholders and broker-dealers may also file an application. Prospectus delivery requirements. As previously mentioned, the administrator may require that, in the case of a security registered by qualification, the prospectus be delivered prior to or concurrent with the sale. For registrants using the other methods, the USA follows the rules of the Securities Act of 1933, requiring that delivery be no later than the mailing of the trade confirmation or actual delivery of the security. Take note. In the next unit, we will learn what the administrator can do to deny a registration so that it does not become effective, or, when it has already become effective, to suspend or revoke the registration. Knowledge Check 4.2. Question 1. Registration is effective when ordered by the administrator in the case of registration by A. Coordination, B. Integration, C. Notice filing, D. Qualification. The answer is D. Registration by qualification is the only registration method in which the administrator sets the effective date. The effective date under registration by coordination is set by the SEC, and notice filing is merely the filing of certain documents enabling the registrant to offer securities in that state. Question 2. Registration statements for securities under the Uniform Securities Act are effective for A. A period determined by the administrator for each issue. B. 1 year from the effective date. C. 1 year from the date of issue. D. 1 year from the previous January 1. The answer is B. Securities registration statements are effective for 1 year from the effective date. The date of issue is when the actual shares are issued. That is usually a short time after the effective date. Question 3. XYZ Corporation has been in business for over 20 years. It needs additional capital for expansion and determines that a public offering in its home state and neighboring states is appropriate. Which method of securities registration most likely would be used to register this initial public offering? A. Coordination. B. Notice filing. C. Qualification. D. Any of the above. The answer is A. Because this offering is being made in more than one state, SEC registration is necessary. The state registration method would be coordination, which is the simultaneous registration of a security with both the SEC and the states. Question 4. Under the Uniform Securities Act, if a security is registered by qualification, the administrator may require an agent to present the prospectus for a new issue to the offeree, A. prior to making the offer, B. prior to making the sale, C. prior to the effective date of the issue, D. once payment has been made. The answer is B. Under Section 305I of the Uniform Securities Act, the administrator may require that a prospectus be sent or given to each person to whom an offer is made before the sale of the security. Lesson 4.3. Exemptions and Exclusions from Registration of Securities. Exemptions from registration. Learning Objective 4E recognize the securities exempt from registration under the Uniform Securities Act. It is worth repeating that one of the most important statements found in the USA is the following: It is unlawful for any person to offer or sell any security in this state unless it is registered under the Act, the security or transaction is exempted under the Act, or it is a federal covered security. In certain situations, the USA exempts both securities and transactions from registration and filing requirements of sales literature. A security, a transaction, or both can be exempt. An exempt security retains its exemption when initially issued and in subsequent trading. However, justification as an exempt transaction must be established before each transaction. The USA provides for a number of categories of exempt securities and even more categories of exempt transactions in Section 402 of the Act. Those securities that are non-exempt must register unless sold in exempt transactions. Federal covered securities do not register with the administrator but may, especially in the case of investment companies, have to notice file with the administrator. As mentioned above, an exempt security retains its exemption at its initial issue and in subsequent trading. An exemption for a transaction, on the other hand, must be established with each transaction. Provided it is in the public interest, the state administrator can deny, suspend, or revoke any securities transaction exemption other than that of a federal covered security. This action may be taken with or without prior notice, summarily. Take note, a security is exempt because of the nature of the issuer, not the purchaser. An exempt transaction is exempt from the regulatory control of the state administrator because of the manner in which a sale is made or because of the person to whom the sale is made. A transaction is an action and must be judged by the merits of each instance. For example, an agent can sell a security that is not exempt from registration in the state if the purchaser of the security is a bank or other institutional buyer. Why is that so? Because the sale of securities to certain financial institutions is an exempt transaction, as will be explained shortly. The sale can be made without registration. This means that the securities sold in exempt transactions do not have to be registered in the state. If such securities were not sold in exempt transactions, such as to an individual investor, they would have to be registered in the state. Exempt securities. Securities exempt from state registration are also exempt from state filing of sales literature. Exempt securities include the following: U.S. and Canadian government and municipal securities. These include securities issued, insured, or guaranteed by the United States or Canada, by a state or province, or by their political subdivisions. Foreign government securities. These include securities issued, insured, or guaranteed by a foreign government with which the United States maintains diplomatic relations. However, unlike U.S. or Canadian issues, political subdivisions are not included unless guaranteed by the sovereign government. Depository institutions. These include securities that are issued, guaranteed by, or are a direct obligation of a depository institution. The USA divides them into the following categories. 1. Any security issued by and representing an interest in or a debt of or guaranteed by any bank organized under the laws of the United States, or any bank, savings institution, or trust company organized and supervised under the laws of any state. 2. Any security issued by and representing an interest in or a debt of or guaranteed by any federal savings and loan association or any building and loan or similar association organized under the laws of any state and authorized to do business in this state. And 3. Any security issued or guaranteed by any federal credit union or any credit union, industrial loan association, or similar association organized and supervised under the laws of this state. Please note that for categories 2 and 3, if the institution is not federally chartered, then it must be authorized to do business in the state under the supervision of a regulator in that state. Insurance company securities. These include securities issued, insured, or guaranteed by an insurance company authorized to do business in the state. Insurance company securities refer to the stocks or bonds issued by insurance companies, not the variable policies sold by the companies. Fixed insurance and annuity policies are not securities. Public utility securities. These include any security issued or guaranteed by a public utility or public utility holding company or an equipment trust certificate issued by a railroad or other common carrier, regulated in respect to rates by federal or state authority, or regulated in respect to issuance or guarantee of the security by a governmental authority of the United States, any state, Canada, or any Canadian province. Federal covered securities. Described in more detail below, these include any security of an issuer equal to or senior to the common stock, such as rights, warrants, preferred stock, and any debt security. Securities issued by nonprofit organizations. These include securities issued by religious, educational, fraternal, charitable, social, athletic, reformatory, or trade associations, and which are not for pecuniary profit. Nonprofit is the key word. Securities issued by cooperatives. These include securities issued by a nonprofit membership cooperative to members of that cooperative. Securities of employee benefit plans. These include any investment contract issued by an employee stock purchase, saving, pension, or profit-sharing plan. Certain money market instruments. Commercial paper and bankers' acceptances are the two most common examples. Take note, the 5 items listed above with an asterisk are the only cases where an individual representing the issuer in the sale of its securities is excluded from the definition of an agent. This was described previously at Learning Objective 2F. The distinction between exemptions and exceptions, or exclusions, from definitions is important in view of the fact that an exempt security is not exempt from the antifraud provisions of the Uniform Securities Act. For example, as we covered earlier in this unit, the typical life insurance policy or fixed annuity is not a security, and the blue sky law has no impact on it. On the other hand, we have just seen that securities issued by insurance companies are exempted from registration under the conditions of the Act. Even though these securities are exempt from registration and the filing of advertising and sales literature with the administrator, they are still subject to the anti-fraud provisions. Therefore, an individual cannot be charged with violating the USA in the sale of a fixed annuity, but could be in the sale of stock in an insurance company or any other exempt security. Take note. The USA also grants an exemption for certain short-term debt securities. Examples are a promissory note, commercial paper, draft, bill of exchange, or banker's acceptance if it matures in 9 months or less, is issued in minimum denominations of $50,000, and receives one of the 3 highest ratings from a nationally recognized rating agency. Please note that this is the only case where a securities rating is part of the registration or exemption under the Uniform Securities Act. Categories of federal covered securities. As discussed several times, the NISMIA of 1996 created a new exemption, the federal covered security. The major categories of federal covered securities: securities covered by federal securities laws that cannot be regulated by state securities administrators, except for violating anti-fraud provisions, include securities listed on the New York Stock Exchange, the NYSE American, LLC, formerly known as the American Stock Exchange, Amex, the NASDAQ stock market, and not tested, several other U.S. exchanges. In addition, any security equal in seniority, rights or warrants, or senior to these securities, bonds and preferred stock, is also considered federal covered. Investment company securities registered under the Investment Company Act of 1940, such as open-end management investment companies, mutual funds, closed-end management investment companies, unit investment trusts, and face amount certificates, and offers and sales of certain exempt securities, such as any security issued or guaranteed by the United States or any bank regulated by the Federal Reserve Board, securities offered by a municipal issuer, unless the issuer is located in the state in which the municipal securities are being offered, and offers and sales of securities sold through certain exempt transactions, such as securities offered to qualified purchasers under Regulation D of the Securities Act of 1933, private placements. Take note. Although securities issued by SEC-registered investment companies are federal covered securities, the USA allows states to impose filing fees on them under a process called notice filing, which was described at Learning Objective 4. See other federal covered securities are generally not required to notice file, but the administrator reserves the right to request a filing from listed and NASDAQ securities. Be aware that there are several types of funds, such as hedge funds, venture capital funds, and private equity funds that are not registered investment companies under the Investment Company Act of 1940 for the purpose of notice filing. Bonds issued by municipalities, for example, those issued by states or cities, are federal covered securities exempt from registration requirements in the states. However, there is an exception to the rule. States may impose certain requirements on municipal securities issued within their own states, but they may not require registration of municipal securities issued by other states. Why? Municipal securities of other states are federal covered securities exempt from state registration. Municipal securities issued in an administrator's state are not federal covered securities. They are not covered by the exemption. States retain authority over the issue of the municipal securities by their own municipalities. Even though these municipal bonds are exempt securities under the USA, they are not included in the NISMIA definition of federal covered security. Yes, this is confusing, but just try to keep it simple as in the following example. Example: a bond issued by the City of Columbus, Ohio, is a federal covered security everywhere except in the state of Ohio. The effect of this is that no state regulators can enforce any of their rules against the bond. But in the state of Ohio, even though the security is exempt under Ohio's securities laws, the administrator could request that the issuer, the city, furnish certain details about the issue. Take note, it is important to note that registering a security with the SEC does not automatically make it federal covered. Yes, that is true of investment companies and those securities listed on the exchanges and the NASDAQ stock market. However, there are thousands of stocks registered with the SEC that trade on the OTC Bulletin Board or the OTC link of the OTC Markets Group, formerly known as the Pink Sheets, that are not federal covered. These stocks generally have to be registered with both the SEC and the State S. Furthermore, a security does not have to be registered with the SEC to be included in the definition of federal covered security. For example, U.S. government and municipal securities are federal covered securities and are exempt from registration with the SEC. Practice question. Which of the following securities is not exempt from the registration and advertising requirements of the Uniform Securities Act? A. Shares of Commonwealth Edison, a regulated public utility holding company. B. Securities issued by the Carnegie Endowment for Peace. C. Securities issued by a bank that is a member of the Federal Reserve System. D. A variable annuity contract issued by Protection Plus Life Insurance Co. The answer is D. Variable annuities, whose performance depends on the securities in a segregated fund, are non-exempt, which means they are covered by the Act and have to be registered. Securities issued by regulated public utilities, charitable organizations, and banks that are members of the Federal Reserve System are exempt under the USA. Learning Objective 4F. Recall the exempt transactions under the Uniform Securities Act. Exempt transactions. Before a security can be sold in a state, it must be registered unless exempt from registration or traded in an exempt transaction. This section covers exemptions for transactions that take place in a state. There are many different types of exempt transactions listed in Section 402 of the Uniform Securities Act. We begin by focusing on those most likely to be on your exam and finish with several others. Isolated non-issuer transactions. Isolated non-issuer transactions include secondary, non-issuer, transactions, whether effected through a broker-dealer or not, that occur infrequently, very few transactions per agent per year. The exact number varies by state. However, these usually do not involve securities professionals. In the same manner that individuals placing a for sale by owner sign on their front lawns do not need a real estate license, one individual selling stock to another in a one-on-one transaction is engaging in a transaction exempt from the oversight of the administrator because the issuer is not receiving any of the proceeds and the parties involved are not trading as part of a regular practice. Unsolicited brokerage transactions. These are transactions initiated by the client, not the agent. They are the most common of the exempt transactions. If a customer calls a registered agent and requests that the agent buy or sell a security for the customer's account, the transaction is an unsolicited brokerage transaction exempt from state registration. To protect against fraud, the administrator may by rule require that the customer acknowledge upon a specified form that the sale was unsolicited and that a signed copy of the form be kept by the broker-dealer for a specified period. If the transaction with a retail customer is solicited, it is not exempt. Underwriter transactions. These include transactions between the issuer or any other person on whose behalf the offering is made, and broker-dealers performing in the capacity of an underwriter, such as a firm commitment underwriting, as well as those between underwriters themselves, as when functioning as members of a selling syndicate. Bankruptcy, guardian or conservator transactions. Transactions by an executor, administrator, marshal, sheriff, trustee in bankruptcy, or other fiduciary are exempt transactions. Test topic alert. Note that a custodian under UTMA or UGMA is not included in this list, and that the only trustee who is included is one in a bankruptcy case. Institutional investor transactions. These are primarily transactions with financial institutions and would include any offer or sale to a bank, savings institution, trust company, insurance company, or investment company as defined in the Investment Company Act of 1940. Employee benefit plans with assets of at least $1 million are also included, as are transactions with a broker-dealer, whether acting for itself or in some fiduciary capacity. There is no minimum order size used to determine these trades. Limited offering transactions. These include any offering called a private placement, directed at not more than 10 persons, called offerees, other than institutional investors during the previous 12 consecutive months, provided that the seller reasonably believes that all of the non-institutional buyers are purchasing for investment purposes only. No commissions or other remuneration is paid for soliciting non-institutional investors, and no general solicitation or advertising is used. Test topic alert. The USA does not require a written representation by each retail buyer that she is purchasing for investment. All that is required is that the seller reasonably believes that the buyer is purchasing for investment only. The number 10 is the figure that will be tested. But, for example, an administrator may want to reduce it for uranium stocks or oil royalties, or increase it for a closely held corporation that wants to solicit 20 or 30 friends and relatives of the owners for additional capital. As we continue to learn, the administrator has a great deal of power. Pre-organization certificates. An offer or sale of a pre-organization certificate or subscription is exemptive. No commission or other remuneration is paid or given directly or indirectly for soliciting any subscriber. The number of subscribers does not exceed 10, and no payment is made by any subscriber. You have probably never heard of a pre-organization certificate or subscription, so a little explanation is in order. A new corporation cannot receive a charter unless their documents of incorporation provide evidence that minimum funding is assured, because the purpose of these pre-organization certificates is to enable a new enterprise to obtain the minimum number of subscriptions required by the corporation law. The USA places a limitation on the number of subscribers rather than the number of offerees, as in the private placement exemption above. Hence, there may be a publicly advertised offering of pre-organization subscriptions, but there may be no payment until effective registration, unless another exemption is available. This tool itself simply postpones registration. It does not excuse registration altogether. Transactions with existing security holders. A transaction made under an offer to existing security holders of the issuer, including persons who are holders of convertible securities, rights, or warrants, is exempt as long as no commission or other form of remuneration is paid directly or indirectly for soliciting that security holder. Non-issuer transactions by pledge. A non-issuer transaction executed by a bona fide pledge, i.e., the one who received the security as collateral for a loan, as long as it was not for the purpose of evading the act, is an exempt transaction. For example, imagine that you pledged stock as collateral for a loan and defaulted on your obligation. The lender will sell your stock to try to recoup his loss, and under the USA, this is considered an exempt transaction. Example, here is the kind of language you might see in a question. Non-exempt securities need not be registered in the state in which they are sold. Always must be registered in the state in which they are sold. Need not be registered if sold in an exempt transaction. Need not be registered if sold in a non-exempt transaction. How do you handle a question like this? First, we change the double negative into a positive. Non-exempt means the securities are not exempt from registration. That means they need to be registered. Next, what are the requirements to sell a security that needs registration? There are two. It must be registered, or it must be sold in an exempt transaction. Therefore, for our example, the choice about being sold in an exempt transaction is correct. If the security were exempt, then it would not need registration regardless of how the sale is made. Practice question. Under the Uniform Securities Act, which of the following would be considered an exempt transaction? Roman numeral 1. The call from an existing client to purchase 1,000 shares of a non-exempt common stock that does not have an effective registration in this state. Roman numeral 2. The sale of shares of common stock of a NYSE-listed company to an individual client. Roman numeral 3. The sale of shares of a bank's IPO to an institutional client. Roman numeral 4. The sale of shares of an insurance company's IPO to an individual client. A1 and 3, B1, 3 and 4, C2 and 4, D1, 2, 3 and 4. The answer is A. A client calling to purchase stock is an unsolicited transaction, probably the most common of the exempt transactions. It makes no difference if the security is exempt or non-exempt. Any sale to an institutional client is an exempt transaction, while those to individuals, unless unsolicited, generally are not. Please note that even though the NYSE-listed stock, a federal covered security, is exempt, the transaction is not. Take note. Some students find it helpful to remember that an exempt security is a noun, while an exempt transaction is a verb, hence the word action. Test topic alert. Remember the distinction between an accredited investor and institutional investor. An accredited investor is an investor who meets the accredited investor standards of Regulation D. Rule 501 of Regulation D considers an individual with net worth greater than $1 million on the date of purchase, individually or with a spouse, excluding the net equity in the primary residence, to meet the definition of accredited investor. Alternatively, one may qualify with earnings greater than $200,000 per year, $300,000 if including spouse, in each of the previous 2 years, and a reasonable expectation of reaching that level in the current year. This term only applies to federal law, not the USA, and probably will never be the correct answer to a USA question. Please note, in August 2020, the SEC added additional qualifiers to the definition of accredited investor. Among those are individuals with a Series 7 or a Series 6 to 5 registration. We do not expect that to be on the exam, but if we should learn otherwise, it will be posted to the exam tips and content updates. An institutional investor is an investor that manages large amounts of money, such as a mutual fund, an insurance company, a bank, or a pension fund. The administrator's power over exemptions. The USA grants the administrator the authority, by rule or order, to exempt a security, transaction, or offer from the USA registration and filing requirements. In addition, the administrator may waive a requirement for an exemption of a transaction or security. Try to follow this next point because it is a bit tricky. The administrator may, by rule or order, deny or revoke the registration exemption of any security issued by any person organized and operated not for private profit, but exclusively for religious, educational, benevolent, charitable, fraternal, social, athletic, or reformatory purposes, or as a chamber of commerce or trade or professional association, your basic nonprofit exemption, and any investment contract issued in connection with an employee's stock purchase, savings, pension, profit sharing, or similar benefit plan. Please note that a few pages ago we gave you a bullet point list of 10 different exempt securities. It started with U.S. and Canadian government issues and went through certain money market instruments. However, the administrator can only deny exemption to the 2 specified above. On the other hand, with the exception of those involving federal covered securities qualifying for the designation under the NISMIA of 1996, the administrator may deny any exempt transaction. That means that, for example, if an agent solicited a securities transaction with an insurance company, The administrator has the power, if he feels it is justified, to consider that transaction non-exempt, even though it is a transaction with an institutional client. Test topic alert. Under the USA, the burden of providing an exemption or an exception from a definition falls upon the person claiming it. Take note. There are only 2 securities exemptions that the administrator may revoke, whereas all exempt transactions, other than in federal covered securities, may be revoked. Summary of exemptions from registration. Let's start our summary by repeating, once more, the key statement from the USA. It is unlawful for any person to offer or sell any security in this state unless 1. It is registered under this act, or 2. The security or transaction is exempted under this act, or 3. It is a federal covered security. We must point out that these exemptions apply to the security or transaction only, not to the securities professional. So if a security is exempt, such as a government security, it can be sold in this state without any registration. But the person who sells it must be properly registered in this state, unless that person qualifies for an exemption. Are you confused? Remember, we learned in Unit 2 that broker-dealers with no place of business in the state, dealing exclusively with other broker-dealers or institutional clients, are not considered to be BDs in the state, as long as they are properly registered in at least one state, the location of their principal office. Let's apply that to the following examples. Example: ABC Securities is a broker-dealer registered in State A. They have no place of business in State B, but they do effect transactions on behalf of a number of banks and insurance companies located in State B. Therefore, they are not considered BDs in State B and are exempt from registering. Should ABC Securities sell some government securities to these clients, neither ABC nor the agents making the sale are required to be registered. This is not because the government securities are exempt, that just means that they don't have to register with the administrator, but because under the USA, ABC does not meet the definition of a broker-dealer in State B. However, should ABC decide to have any of their agents sell these government bonds to individual, sometimes referred to as retail, clients in State B, then, even though the bonds are exempt securities, both ABC and the selling agents must register in that state. The same applies to exempt transactions. One of the most common cases is when a client calls an agent to purchase a security that is not exempt and not registered in your state. But because the transaction has been initiated by the client as an unsolicited trade, it is an exempt transaction and therefore the trade may be made even though the security is not registered. One way the exam will try to trick you is by asking about an individual calling an agent from a state in which the agent is not registered. The broker-dealer is registered in that state, and the individual is a client of the firm, but not that particular agent. The individual wishes to enter an unsolicited order. Can the agent accept it? No, although the transaction is exempt, which only means that the security does not have to be registered in that state. An agent can only do business with a resident of a state if the agent is properly licensed in that state. In this case, the agent would have to turn the order over to an agent who is licensed in that other state. Take note, as we have mentioned several times, regardless of whether the security or the transaction is exempt, as long as it is a security, it is not exempt from the antifraud provisions of the Uniform Securities Act. Knowledge Check 4.3. Question 1. Which of the following securities is not exempt from the registration provisions of the Uniform Securities Act? A. Common stock issued by a savings and loan association authorized to do business in the state. B. A general obligation municipal bond issued by a neighboring state. C. Bonds issued by a company that has common stock listed on the New York Stock Exchange. D. Variable life insurance policies sold by a life insurance company authorized to do business in the state. The answer is D. Securities issued by a life insurance company authorized to do business in the state, their stock and bonds, are exempt, but the variable policies, variable annuities, and variable life insurance are not. The USA exempts from registration a number of different issues, including securities issued by a bank or anything that resembles a bank, i.e., a savings and loan or credit union. Securities issued by a governmental unit are always exempt. Securities listed on the New York Stock Exchange are part of a group known as Federal Covered Securities that also includes securities listed on the Nasdaq stock market. Question 2. All of the following meet the definition of an exempt transaction except A. Base securities. A registered broker-dealer purchases securities from Nuco Computers for distribution as part of an initial public offering. B. First National Bank of Cleveland sells its entire publicly traded bond portfolio to Amalgamated National Bank of Detroit. C. Amalgamated National Bank of Detroit sells its publicly traded bond portfolio to Windsor Insurance Company. D. Bob Babbitt, an employee of Amalgamated National Bank of Detroit, buys securities from Base Securities, a registered broker-dealer. The answer is D. The purchase of securities from a broker-dealer by an employee of a bank is a non-exempt transaction. It is a sale of a security by a broker-dealer to a member of the public and is therefore not exempt. Transactions between broker-dealers and the issuers of the securities involved in the transaction, transactions between banks and transactions between banks and insurance companies are all exempt because they are transactions between financial institutions. Exempt transactions are most often identified by whom the transaction is with, rather than by what type of security is involved. Question 3. Under the Uniform Securities Act, all of the following are exempt securities except A. U.S. government securities, B. Unsolicited transactions, C. Bonds issued by Saskatoon, Saskatchewan, D. Securities of federal credit unions. The answer is B. Unsolicited transactions are exempt transactions, not exempt securities. U.S. government securities, Canadian provincial and municipal securities, and securities of federal credit unions are exempt securities, not exempt transactions. Question 4. As defined in the Uniform Securities Act, each of the following would be considered an exempt transaction except A. A trustee of a corporation in bankruptcy liquidates securities to satisfy debt holders. B. An offer of a securities investment is directed to 10 individuals in the state during a period of 12 consecutive months. C. An agent solicits insurance companies to purchase shares of non-exempt securities. D. Pre-organization certificates are subscribed to by 9 investors in the state, earning the agent a modest commission. The answer is D. The 9 investors are within the required 10, but in order for a pre-organization certificate to be an exempt transaction, there can be no payment of funds or commissions. Transactions by fiduciaries, such as a trustee in bankruptcy, the only trustee who qualifies, and transactions with institutions, such as insurance companies, are exempt. The private placement exemption applies as long as there are no more than 10 offers to individual, retail, purchasers within 12 consecutive months. Question 5. Which of the following would not be included in the definition of federal covered security? A. Unit investment trusts registered under the Investment Company Act of 1940. B. Stock issued by a life insurance company authorized to do business in the state. C. Bonds listed on the NYSE. D. Securities sold under Regulation D of the Securities Act of 1933. The answer is B. The term federal covered security includes securities listed on the NYSE and other major exchanges, investment companies registered under the Investment Company Act of 1940, and securities that are the subject of the private placement exemption of Regulation D of the Securities Act of 1933. The fact that the insurance company is authorized to do business in the state would make it exempt from registration in that state, but that does not make it a federal covered security. Question 6. A nonprofit organization wishes to issue a debt security to provide funds for expansion of the organization's activities. Under the Uniform Securities Act, if the administrator questions the security's eligibility for an exemption from registration, the obligation to prove the exemption is justified is on A. the person requesting the exemption, B. the broker-dealer selling the security, C. the agent receiving a commission on the sale of the security, D. the administrator. The answer is A. The USA language is, in any proceeding under this Act, the burden of proving an exemption or an exception from a definition is upon the person claiming it. Remember, the term person is very broad and is not limited to natural persons, individuals.
Unit 5, Remedies and Administrative Provisions. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 5A, recognize the jurisdiction and authority of the State Securities Administrator. Learning Objective 5B, identify the administrative actions that may be taken by the administrator. Learning Objective 5C, describe the civil rights of recovery for a securities sale or investment advice purchased in violation of the Uniform Securities Act. Learning Objective 5D, identify civil and criminal liability and penalties for violations of the Uniform Securities Act. Introduction. As we have previously stated, the Uniform Securities Act is model legislation for the states to use in writing their own securities laws. On your exam, you will not be tested on the specifics of your state's securities laws, but on the principles of state regulation laid out in the USA. This unit addresses the administrative provisions of the Act and the remedies available to the administrator. Under the USA, the state administrator has jurisdiction over securities transactions that originate in or are accepted in the administrator's state. When a securities transaction falls within the administrator's jurisdiction, the administrator has power to make rules and orders, conduct investigations and issue subpoenas, issue cease and desist orders, and deny, suspend, or revoke registrations. Both civil liabilities and criminal penalties exist for violating the Act. The Series 63 exam will include 6 questions on the material presented in this unit. Lesson 5.1, Authority of the State Securities Administrator. Learning Objective 5.8, recognize the jurisdiction and authority of the State Securities Administrator. The primary role of the administrator is to administer the securities laws of the state as well as make rules and issue orders in the public interest to ensure a well-functioning investment climate in the state. As we have already covered, the administrator deals with registration of securities professionals and securities. In this unit, we will concentrate on the scope of his authority, frequently referred to as his jurisdiction on the exam, and the penalties for those who run afoul of the law. Offer or offer to sell and sale or sell. We previously defined these terms in Unit 1, but we need to go into further detail here because the administrator's authority revolves around offers and sales of securities. Offer or offer to sell. The USA defines offer or offer to sell as every attempt or offer to dispose of or solicitation of an offer to buy a security or interest in a security for value. For test purposes, you should know that any security given or delivered with, or as a bonus on account of, a purchase of securities or anything else, a car, jewelry, and so forth, is considered to constitute part of the subject of the purchase and to have been offered and sold for value. A purported gift of assessable stock is considered to involve an offer and a sale. Assessable stock is stock issued below par for which the issuer or creditors have the right to assess shareholders for the balance of unpaid par, or a sale or offer of a warrant or right to purchase or subscribe to another security of the same or another issuer, as well as every sale or offer of a security which gives the holder a present or future right or privilege to convert into another security of the same or another issuer, is considered to include an offer of the other security. The person attempting to make the sale is known as the offerer, and the security is being offered to the offeree. Sale or sell. The USA defines sale or sell as every contract of sale, contract to sell, and disposition of a security or interest in a security for value. This means that any transfer of a security in which money or some other valuable consideration is involved is covered by this definition and subject to the Act. Take note. You must be able to distinguish between a sale and an offer to sell. The offer is the attempt. A transaction has not taken place. In a sale, there has been an actual transaction involving money or another form of consideration for value. One must be properly registered to both make a sale and make the offer. Example: if a car dealer, as an essential part of a sale, offers $1,000 in corporate bonds as an incentive, this would be considered a bonus under the Act. Therefore, this sale falls under the jurisdiction of the state securities administrator. As a result, to do this, the car dealer, believe it or not, would have to register with the state as a broker-dealer. Gifts of assessable stock. When assessable stock is given as a gift, the administrator has jurisdiction over the transaction because there is a potential future obligation in that either the issuer or, more likely, creditors can demand payment for the balance of the par value. For example, if an individual owned assessable stock and felt that the issuer was on the verge of bankruptcy, that person could give the stock as a present. If the bankruptcy occurred, the new owner would then be subject to the assessment. That, at least in the eyes of the law, means that this is an offer and sale rather than a gift. Test topic alert. Assessable stock no longer exists, but the exam may ask about it. Look for this direct quote from the Uniform Securities Act. A purported gift of assessable stock is considered to involve an offer and sale. Exclusions from the terms offer, offer to sell, sale, or sell. The terms offer and offer to sell, and sell or sale do not include any. Bona fide pledge or loan. Pledging stock as collateral for a loan, such as for a loan at the bank, is not a sale. You expect to get your stock back when the loan is paid off. You haven't sold it. Gift of non-assessable stock. All stocks today are non-assessable. Stock dividend, if nothing of value is given by stockholders for the dividend, and this would include stock splits. Class vote by stockholders, pursuant to the Certificate of Incorporation, or the applicable corporation statute, or a merger, consolidation, reclassification of securities, or sale of corporate assets in consideration of the issuance of securities of another corporation, or act incidental to a judicially approved reorganization with which a security is issued in exchange for one or more outstanding securities. Test topic alert. Because you have just learned that the gift of non-assessable stock is not considered a sale, you have to be careful not to be tricked by a question on the exam in which shares of non-assessable stock are given free as a bonus with the purchase of something else, e.g., a security, a car, a house. This would not be a gift and would, in fact, be an offer or a sale. Legal jurisdiction of the administrator. Under law, for any agent of a state, e.g., the administrator, to have authority over an activity such as a sale or offer of securities, he must have legal jurisdiction to act. Jurisdiction under the USA specifically means the legal authority to regulate securities activities that take place in the state. Jurisdiction applies to persons who sell or offer to sell when an offer to sell is made in this state, or an offer to buy is made and accepted in this state. What does it mean? For the purpose of this section of the Act, an offer to sell or to buy is made in this state, whether or not either party is then present in this state, when the offer originates from this state. For the purpose of this section of the law, an offer to buy or to sell is accepted in this state, when acceptance is communicated by the offeree to the offerer in this state. Can we say this in a simpler way? Because this is a law exam, the questions tend to follow the wording of the law. However, perhaps we can condense the wording a bit. The administrator always has jurisdiction over any offer made from his state or accepted in his state. It winds up looking like this. The Uniform Securities Act describes activities considered to have taken place in the state as any offer to buy or sell a security, as well as any acceptance of the offer if the offer originated in the administrator's state, or is accepted in the administrator's state. Take note. Because securities transactions often involve several states, more than one administrator may have jurisdiction over a security or a transaction. Let's work through some examples to see how this might appear on your exam. Practice question. Jane is an agent registered in states A and B while sitting in her office in state A. She contacts a client who lives in state B with a recommendation to buy ABC stock. The client agrees to make the purchase. Jurisdiction here would belong to A, the state administrator, B, the state B administrator, C, both the state and state B administrators, D, neither administrator, because this is an existing client. The answer is C in this case. It would be the administrators of both states and B, choice C. Why is that? Remember that the administrator has jurisdiction over any offer that originated in his state, and clearly this offer originated from Jane in state A. Recall that the administrator has jurisdiction over any offer that was accepted in her state, and this client accepted the offer while living in state B. The status of the client, existing or prospective, does not affect the administrator's jurisdiction. Let's take a look at another possible question. Practice question. Jane has a State A-based client, Sally, who spends the winters in State C, a state where neither Jane nor her broker-dealer have a place of business or any retail clients. Jane sends Sally a research report with a strong buy recommendation for XYZ stock. Sally calls Jane with an order to purchase 100 shares of XYZ. Jurisdiction over this transaction belongs to A. the State Administrator, B. the State C Administrator, C. both the State and State B Administrators, D. both the State and State C Administrators. The answer is D. Just as with the previous question, we have an offer being made from State A resulting in that administrator having jurisdiction. Although the client lives in State A, the offer was accepted while she was in State C, so the State C Administrator has jurisdiction. Although not related to the issue of jurisdiction, for review purposes, we should ask ourselves, can this transaction legally take place? Jane is not registered in State C. How can she make the offer to a client who is there, and how can she and her broker-dealer accept a retail order when neither of them are registered in State C? As noted in Unit 2, a broker-dealer with no place of business in a state who deals with existing clients, such as Sally, who are temporarily in the state as Sally is not defined as a broker-dealer in that state and therefore does not register, nor do their agents. We call that the snowbird exemption. Publishing and broadcast exceptions to jurisdiction. There are special rules regarding the administrator's jurisdiction over offers made through a TV or radio broadcast or a bona fide newspaper. The administrator would not have jurisdiction if the offer were made under any of the following circumstances: television or radio broadcast that originated outside of the state, bona fide newspaper or periodical published outside of the state, newspaper or periodical published inside the state but with more than 2/3, 66%, of its circulation outside the state in the last year. Take note: a bona fide newspaper is a newspaper of general interest in circulation, such as the Wall Street Journal. Private investment advisory newsletters, usually distributed by subscription, are not bona fide newspapers and therefore are not included in the publishing exception. Test topic alert. A radio or television program is considered to originate in the state where the microphone or television camera is located, not the transmitter. Let's take a look at how this publishing exemption might appear on the exam. Practice question. Wayne and Grayson, Limited, is a broker-dealer with offices in Gotham, New Jersey. They place an ad for a new securities issue in the Gotham Gazette. Approximately 55% of the Gazette's readership is in Delaware. Under the Uniform Securities Act, jurisdiction over this ad would lie with A. the Administrator of New Jersey, B. the Administrator of Delaware, C. the Administrator of both New Jersey and Delaware, D. the Administrator of neither New Jersey and Delaware. The answer is A. The correct choice is A. Although more than half the readers of the Gazette live in Delaware, under the terms of the Publishing and Broadcasting Exemption of the USA, the offer is not made in Delaware because the paper is not published there. Therefore, the Administrator of New Jersey has sole jurisdiction over the offering. No dual or multiple jurisdiction applies in this case, unless the offer is actually accepted in Delaware. What would the answer be if the question stated that more than 2/3 of the circulation was outside of New Jersey? Once that happens, believe it or not, no state has jurisdiction. Filing of sales and advertising sales literature. One other area of jurisdiction is the filing of sales and advertising materials. The administrator may, by rule or order, there is a difference between those two terms, as will be explained in the next LO, require the filing of any prospectus, pamphlet, circular, form letter, advertisement, or other sales literature or advertising communication addressed or intended for distribution to prospective investors, including clients or prospective clients of an investment advisor, unless the security is exempt, the transaction is exempt, or it is a federal covered security. Knowledge Check 5.1. Question 1. A state securities administrator has jurisdiction over a securities offering if Roman numeral 1. The security was registered in that state. Roman numeral 2. It originated in that state. Roman numeral 3. It was accepted in that state. Roman numeral 4. The broker-dealer is registered in that state. A. 1 and 2. B. 1 and 4. C. 2 and 3. D. 3 and 4. The answer is C. The administrator of this state has jurisdiction over an offer to buy or sell as follows. An offer to sell or to buy is made in this state, whether or not either party is then present in this state, when the offer originates from this state. An offer to buy or to sell is accepted in this state when acceptance is communicated to the offeror in this state. The security may be registered in dozens of states, including this state, or the security might be exempt from registration. That means it would not be registered in that state. However, the administrator has jurisdiction only when the offer is made or accepted in this state. Likewise, the broker-dealer may be registered in many states, but unless the BD is involved in an offer or acceptance in this state's administrator does not have jurisdiction. Question 2. An administrator has jurisdiction over an offer to sell securities if it was made in a newspaper published within the state with no more than a 1/3 of its circulation outside the state, b. 1/2 of its circulation outside the state, c. 2/3 of its circulation outside the state, d. 90% of its circulation outside the state. The answer is C. A state administrator has jurisdiction over a securities offering made in a bona fide newspaper published within the state with no more than 2/3 of its circulation outside the state. Question 3. Which of the following does the Uniform Securities Act consider an offer and a sale? A. A prospectus. B. A purported gift of assessable stock. C. A gift of non-assessable stock. D. An existing customer purchasing a federal covered security in an unsolicited transaction. The answer is B. The law specifically states that a purported gift of assessable stock is both an offer and a sale. A prospectus is considered an offer, and a purchase of any security in an unsolicited transaction is a sale. There is no offer made when the trade is unsolicited. A gift of non-assessable stock is neither an offer or a sale. Question 4. An agent recommends the purchase of ABC warrants. Each warrant enables the holder to exercise and receive 1 share of ABC common stock at a price of $45 per share. The Uniform Securities Act would view this as A sale of the ABC warrant and an offer of the ABC common stock. B. An offer of the ABC warrant and an offer of the ABC common stock. C. An offer of the ABC warrant. D. An offer of the ABC common stock. The answer is B. The recommendation is an offer, until the customer says, buy. There is no sale. Furthermore, every sale or offer of a warrant to purchase another security of the same or another issuer is considered to include an offer of the other security. Therefore, the agent is making an offer of the warrant, and inherent in that is the offer of the common stock that can be acquired by exercising the warrant. If the question said that the agent sold the warrant to the customer, then it would be a sale of the warrant and an offer of the ABC common stock. Lesson 5.2. Administrative Actions. Learning Objective 5B. Identify the administrative actions that may be taken by the administrator. The Uniform Securities Act not only establishes the jurisdiction of the administrator, but also outlines the powers or the actions that the administrator can take within its jurisdiction. The 4 broad powers the administrator has to enforce and administer the act in his state are to make, amend, or rescind rules and orders, and require the use of specific forms, conduct investigations and issue subpoenas, issue cease and desist orders, and seek injunctions, and deny, suspend, cancel, or revoke registrations and licenses. Because the administrator has the power to enforce the act for the benefit of the public, the administrator, as well as his employees, have an obligation not to use the office for personal gain. Administrators are, as a result, prohibited from using for their own benefit any information derived from their official duties that has not been made public. Rules, orders, and forms. To enforce the USA, the administrator has the authority to make, amend, or rescind rules, forms, and orders necessary to administer the act. A rule or order of the administrator has the same authority as a provision of the act itself, but these rules and orders are not part of the USA itself. The difference between a rule and an order is that a rule applies to everyone, whereas an order applies to a specific instance. Take note. The administrator may decide to issue a rule requiring all agents to pay an annual registration fee of $250. This rule applies to everyone. Or the administrator may find that a specific agent has violated a provision of the law and orders a 30-day suspension. This order applies only to that particular agent. A person may appeal an order of the administrator in court within 60 days of order issuance. Although the administrator has the power to make and amend rules for compliance with his state's blue sky law, he does not have the power to alter the law itself. The composition or content of state securities law is the responsibility of the state legislature, not of administrative agencies. Rules for administration and compliance with the law are the responsibility of the Securities Administrator. Case study: Rules and orders of the Administrator. Situation: the State Securities Administrator requires, by rule, that all companies registering their securities in the state must supply financial statements in a specific form and with content prescribed by the Administrator. However, the Administrator does not publish the rule because the rule is too long and complex. Analysis: the Uniform Securities Act allows state administrators to issue rules and orders in carrying out their regulatory functions, and the State Administrator acted properly in designing the form and content for financial reports. However, the USA requires that administrators publish all rules and orders. The Administrator, despite the latitude he has in administering the USA, cannot suspend any provision of the USA itself. The State Administrator acted within his authority in designing the forms but acted without authority, i.e., he violated the USA, in suspending the requirement that all rules and orders be published. Conduct investigations and issue subpoenas. The Administrator has broad discretionary authority to conduct investigations and issue subpoenas. These investigations may be made in public or in private and may occur within or outside of the Administrator's state. Normally, these investigations are open to the public, but when, in the opinion of the Administrator, and with the consent of all parties, it is felt that a private investigation is more appropriate, that investigation will be conducted without public scrutiny. In conducting an investigation, the Administrator, or any officer designated by him, has the power to require statements in writing, under oath, regarding all matters relating to the issue under investigation, publish and make public the facts and circumstances concerning the issue to be investigated, subpoena witnesses and compel their attendance and testimony, and take evidence and require the production of books, papers, correspondence, and any other documents deemed relevant. Test topic alert. If the Administrator of State A wishes to investigate a BD registered in State A, but whose principal office is located in State B, does he need the okay of the State B Administrator? No. When can he go in? The Administrator can go in during normal business hours and doesn't need to make an appointment. Contumacy. So, what happens if a person who is the subject of an investigation refuses to furnish the required evidence or just ignores a subpoena? After all, the Administrator is not a police officer. She doesn't wear a badge and cannot arrest anyone. There is a legal term that describes this type of disobedience. That term is contumacy. This means that the Administrator may apply to the appropriate court in her state and ask for help. Upon application by the Administrator, the court can issue an order to the person requiring compliance with the request. Failure to obey the order of the court may be punished by the court as a contempt of court. Contempt of court can, of course, lead to jail time. In addition to having the power to conduct investigations, the Administrator may enforce subpoenas issued by administrators in other states on the same basis, as if the alleged offense took place in the Administrator's state. However, the Administrator may issue and apply to enforce subpoenas in his state at the request of a securities agency or administrator of another state, only if the activities constituting an alleged violation for which the information is sought would be a violation of the USA if the activities had occurred in his state. Issue cease and desist orders. If an administrator determines that a person is about to engage in an activity that constitutes a violation of the USA or her rules, the Administrator may issue a cease and desist order with or without a hearing. The Administrator is granted this power to prevent potential violations before they occur. It is sometimes said that the Administrator can act when she smells the smoke, even without seeing the fire. Sometimes a tipster or whistleblower will divulge information to the Administrator that might be relevant to a serious infraction. To prevent any further damage to investors, a cease and desist order can be entered. Although the Administrator has the power to issue cease and desist orders, she does not have the legal power to compel compliance with the order. To compel compliance in the face of a person's resistance, the Administrator must apply to a court of competent jurisdiction for an injunction. Only the courts can compel compliance by issuing injunctions and imposing penalties for violation of them. You will need to know that enjoined is the legal term that is used to refer to a person who is the subject of an injunction. If a temporary or permanent injunction is issued, upon request of the Administrator, a receiver or conservator may be appointed over the defendant's assets. Take note, cease and desist orders are not the same as stop orders. Cease and desist orders are directed to persons, requiring them to cease activities. Stop orders are directed to applications regarding registration of a security. Furthermore, stop orders require a hearing, while cease and desist orders do not. Deny, suspend, cancel, or revoke registrations. The administrator also has the power to deny, suspend, cancel, or revoke the registration of broker-dealers, investment advisors, and their representatives, as well as the registration of securities issues. Broker-dealers, advisors, and their representatives, to justify a denial, revocation, or suspension of the license of a securities professional. The administrator must find that the order is in the public interest and also find that the applicant or registrant, or in the case of a broker-dealer or investment advisor, any partner, officer, or director, or any person occupying a similar status or performing similar functions, has filed an incomplete, false, or misleading registration application, has willfully violated the USA, has been convicted of a securities-related misdemeanor as a result of an action brought by any securities or commodities regulatory body within the last 10 years, has been convicted of any felony within the last 10 years, has been enjoined by law from engaging in the securities business, is subject to any other administrator's denial, revocation, or suspension, is engaged in dishonest or unethical securities practices, is insolvent, has, in the case of a broker-dealer or investment advisor, been found guilty on the charge of failure to supervise, has failed to pay application filing fees, and is not qualified because of lack of training, experience, or knowledge of the securities business. In the USA, it states that the administrator may not enter an order solely on the basis of lack of experience if the applicant or registrant is qualified by training, knowledge, or both. Finally, the administrator may not suspend or revoke a registration on the basis of facts that were known to the administrator at the time the registration became effective. Test topic alert. Because of a lack of uniformity in state criminal laws, it can happen that one is convicted of a misdemeanor in one state and then moves to a state where that same crime is a felony. If the person were to then apply for registration, the administrator must consider the crime under the statutes of the state where it occurred, not his own. In other words, the administrator may only consider what is on the person's record. Test topic alert. If a person is subject to a disqualification by any SRO, even the NAST, before it became FINRA, for something that was not a violation of the Uniform Securities Act, that would still be a possible cause for denial. Test topic alert. Denial is generally limited to convictions for any felony or investment-related misdemeanors within the past 10 years. However, as pointed out in Unit 2, these convictions, and even just being charged, must always be disclosed on the application for registration. There is no time limit. Take note, the public's best interest is not reason enough for the denial, suspension, or revocation of a registration. There must be an additional reason, as described previously. Other than when acting summarily, no order to deny, suspend, or revoke may be entered without appropriate prior notice to the applicant or registrant, as well as the employer or prospective employer if the applicant or registrant is an agent or investment advisor representative, an opportunity for a hearing, and written findings of fact and conclusions of law. In addition, if the registrant is an agent or an IOR, the employing broker-dealer or IA, respectively, will receive notice of the final order from the administrator. Summary powers. One of the powers of the administrator is known as acting summarily. We define this term in Lesson 1.1, but here is further testable detail. Acting summarily means that he may order, without going through the hearing process, a postponement or suspension of a registration pending final determination of any proceeding based upon actions described above. Once the summary order is entered, the administrator will promptly notify the applicant or registrant, as well as the employer or prospective employer if the applicant or registrant is an agent or investment advisor representative, that it has been entered and of the reasons for it. If the applicant wishes a hearing, written request must be made, and within 15 days after the receipt of the written request, the matter will be set down for hearing. If no hearing is requested and none is ordered by the administrator, the order will remain in effect until it is modified or vacated by the administrator. As stated previously, and repeated because it is likely to be on the exam, other than when the administrator has acted summarily as described above, no final order may be issued without the administrator giving appropriate prior notice to the affected persons, granting an opportunity for a hearing, and providing findings of fact and conclusions of law. Lack of qualification. An administrator may not base a denial of a person's registration solely on his lack of experience. However, the administrator may consider that registration as a broker-dealer does not necessarily qualify one for a license as an investment advisor and may restrict that applicant's registration as a broker-dealer conditional upon its not functioning as an investment advisor. To better understand these 2 points, let's look at the wording in the Act itself. The administrator may not enter an order denying registration solely on the basis of lack of experience if the applicant or registrant is qualified by training or knowledge or both. Obviously, a new applicant for registration as an agent is not going to have any experience selling securities. So the Act says that this lack of experience by itself is not enough to deny the registration, as long as the administrator feels assured that the individual will receive adequate training or has the requisite knowledge. One could suppose that passing this exam demonstrates the necessary knowledge. The administrator may consider that a person applying for registration as a broker-dealer and an investment advisor is not necessarily qualified solely on the basis of experience as a broker-dealer or agent. When he finds that an applicant for initial or renewal registration as a broker-dealer is not qualified as an investment advisor, he may, by order, condition the applicant's registration as a broker-dealer upon his not transacting business, in this state, as an investment advisor. In this case, the Act is dealing with a person who has experience, albeit not necessarily in the giving of advice. Just because a person has been a broker-dealer or an agent for a broker-dealer, that does not mean the person is qualified to be an investment advisor. Therefore, the registration will be limited to acting only in its stated capacity, as long as it does not cross over the line and give investment advice. Securities issues. As is the case with a securities professional, a securities administrator may deny, suspend, cancel, or revoke a securities registration if the order is in the public's interest and the securities registrant files a misleading or incomplete registration statement, is engaged in an offering that is fraudulent or made on unfair, unjust, or inequitable terms, charges offering fees that are excessive or unreasonable, has a control person convicted of a securities-related crime, is subject to a court injunction, is engaged in a method of business that is illegal, or is subject to an administrative stop order of any other state. In addition, the administrator may deny a registration if the applicant fails to pay the filing fee. When the fee is paid, the denial order will be removed, provided the applicant is in compliance with all registration procedures. Test topic alert. When the conditions that led to the issuance of the stop order have changed for the better, the legal term, remember, this is a law exam, used to describe the lifting of the stop order is vacated, e.g., the order has been vacated. It is important that you be able to recognize the difference between a cease and desist order and a stop order. Look at the following examples. Practice question. An agent of a broker-dealer solicits clients to purchase unregistered promissory notes. The agent claims that promissory notes are not securities and therefore do not need to be registered. The administrator disagrees with that position and would issue A cease and desist order against the agent, B. a cease and desist order against the issuer of the note, C. a stop order against the agent, D. a stop order against the issuer. The answer is A, unless we had reason to believe that the issuer was the one claiming that its notes were not securities. The only person guilty here is the agent. Stopping the agent from continuing to solicit the purchase of unregistered securities is done by issuing a cease and desist order. Choice A. Alternatively, if the question went like this. Practice question. Palterer Products, Inc., PPI, headquartered in State J, has sent an announcement to a number of broker-dealers in the state promoting their 8% promissory notes as a high-interest non-security alternative to a bank CD. The compliance officer of your firm forwards this to the State J administrator. What action would the administrator likely take? A. Issue a cease and desist order against the compliance officer, with or without a hearing. B. Issue a cease and desist order against PPI, with or without a hearing. C. Issue a stop order against the compliance officer after giving opportunity for a hearing. D. Issue a stop order against PPI after giving opportunity for a hearing. The answer is D. Promissory notes are securities and therefore, PPI must stop soliciting the sale of them as non-securities. The method of doing so is through the issue of a stop order. Choice D. No order would be forthcoming against the compliance officer. She was only doing her job correctly. Remember, cease and desist orders are against registered securities professionals and stop orders against issuers. Finally, the cease and desist order can be issued with or without a hearing, and the stop order only after a hearing. Non-punitive terminations of registration. A registration can be terminated even if there has not been a violation of the USA. A request for withdrawal and lack of qualification are both reasons for cancellation. Withdrawal. A securities professional may request, on his own initiative, a withdrawal of a registration. The withdrawal is effective 30 days after the administrator receives it, provided no revocation or suspension proceedings are in process against the person making the request. In that event, if sufficient evidence of improper activity later becomes available, the administrator may institute a revocation or suspension proceeding within 1 year after a withdrawal becomes effective. Test topic alert. Once your registration has been withdrawn, the administrator still retains jurisdiction over you for a period of 1 year. Cancellation. If an administrator finds that an applicant or a registrant no longer exists or has ceased to transact business, the administrator may cancel the registration. Test topic alert. You may encounter this type of question regarding cancellation. What would the administrator do if mailings to a registrant were returned with no forwarding address? The answer is cancel the registration. The administrator may also cancel a registration if a person is declared mentally incompetent. Take note. Be familiar with the distinction between cancellation and denial, suspension or revocation. Cancellation does not result from violations or a failure to follow the provisions of the Act. Cancellation occurs as the result of death, dissolution, or mental incompetency and, unlike the others, is not a form of punishment. Test topic alert. Because in agents or ILRs, registration is dependent on being associated with a broker-dealer or IA. When the employer's registration is suspended or revoked, that of the registered individual is placed into suspense or some other term with essentially the same effect. When the period of suspension of the firm is over, registration of the individual is reactivated. If the firm's registration has been revoked, the individual's registration will be placed in suspense until finding a new affiliation. If a period of more than 2 years should transpire without re-registering, retaking the exam will be necessary. Administrative files and opinions. A document is considered to be filed when it is received by the administrator. Maintenance of records. The administrator maintains a record of all applications for registration of securities and registration statements and all applications for broker-dealer, agent, investment advisor, or investment advisor representative registration which are or have ever been effective in his state. All written notices of claim of exemption from registration requirements, and all orders entered under this Act, and all interpretative opinions or no-action determinations issued. All records may be maintained in computer or microfilm format or any other form of data storage. The record is available for public inspection. The information contained in or filed with any registration statement, application, or report may be made available to the public under such rules as the administrator prescribes. Practice question. An administrator would be in compliance with the Uniform Securities Act when using all of the following storage methods except A. Microfilm, B. Microfiche, C. Micrographic, D. Microscopic. The answer is D. Using microscopes is not a method of data storage. In addition to the micrographic family, digital storage, computer, as well as the old standby paper are acceptable. NASA has not used cloud storage in its literature, so we don't expect you will see that on your exam. Availability of copies. Upon request, and at such reasonable charges as he prescribes, the administrator shall furnish to any person photostatic or other copies, certified under his seal of office if requested, of any entry in the register or any document, which is a matter of public record. In any proceeding or prosecution under this Act, any copy so certified is prima facie evidence of the contents of the entry or document certified. Interpretive opinions. The administrator, in his discretion, may honor requests from interested persons for interpretative opinions or may issue determinations that the administrator will not institute enforcement proceedings against certain specified persons for engaging in certain specified activities, where the determination is consistent with the purposes fairly intended by the policy and provisions of this Act. The administrator may charge a fee for interpretative opinions and no-action determinations. This is similar to the same procedure used for letter rulings from the IRS. Knowledge Check 5.2. Question 1. To protect the public, the administrator may, Roman numeral 1, deny a registration if the registrant does not have sufficient experience to function as an agent, Roman numeral 2. Limit a registrant's functions to those of a broker-dealer if, in the initial application for registration as an investment advisor, The registrant is not qualified to act as an advisor. Roman numeral 3. Consider approving a registration that the registrant will work under the supervision of a registered investment advisor or broker-dealer. Roman numeral 4. Deny a registration, although denial is not in the public's interest, if it is prudent in view of a change in the state's political composition. A. 1 and 4. B. 2 and 3. C. 3 and 4. D. 1, 2, 3, and 4. The answer is B. The administrator may determine that an applicant, in his initial application for registration as an investment advisor, is not qualified to act as an advisor, and thus may limit the registration to that of a broker-dealer. The administrator can also take into consideration whether the registrant will work under the supervision of a registered investment advisor or broker-dealer when approving an application. The administrator can deny, suspend, or revoke a registration for many reasons, but they must be in the interest of the public. The administrator may not deny the registration simply because it is prudent. Lack of experience in itself is insufficient reason for denial. Question 2. With regard to the powers of the administrator, which of the following statements are not true? Roman numeral 1. The administrator must seek an injunction to issue a cease and desist order. Roman numeral 2. The Uniform Securities Act requires an administrator to conduct a full hearing, public or private, before issuing a cease and desist order. Roman numeral 3. The Uniform Securities Act grants the administrator the power to issue injunctions to force compliance with the provisions of the Act. A. 1 and 2. B. 1 and 3. C. 2 and 3. D. 1, 2, and 3. The answer is D. The administrator need not seek an injunction to issue a cease and desist order. The USA does not require that an administrator conduct a public or private hearing before issuing a cease and desist order. When time does not permit, the administrator may issue a cease and desist order before a hearing to prevent a pending violation. The USA does not grant the administrator the power to issue injunctions to force compliance with the Act. The Act permits the administrator to issue cease and desist orders, and if they do not work, the administrator may seek an injunction from a court of competent jurisdiction. A cease and desist order is an administrative order, whereas an injunction is a judicial order. Question 3. Although the administrator has great power, the Uniform Securities Act does place some limitations on the office. Which of the following statements regarding those powers are true? Roman numeral 1. In conducting an investigation, an administrator can compel the testimony of witnesses. Roman numeral 2. Investigations of serious violations must be open to the public. Roman numeral 3. An administrator in State A may enforce subpoenas from State B only if the violation originally occurred in State A. The answer is A. An administrator can compel the testimony of witnesses when conducting an investigation. Investigation of serious violations need not be held in public. An administrator in one state may enforce subpoenas from a different state whether the violation occurred in that state or not. Conviction for any felony within the past 10 years is one of a number of reasons the administrator has for denying a license. If the denial is done as a summary judgment, no hearing, a written request may be made for a hearing. That request must be honored within 15 days. Question 4. An administrator may summarily deny the registration of a securities professional who has been convicted of a felony within the past 10 years but must provide, if requested in writing, a hearing within 15 days. A. 1 and 4. B. 2 and 3. C. 1, 2, and 4. D. 1, 3, and 4. The answer is B. A cease and desist order is a directive from an administrative agency to immediately stop a particular action. Administrators may issue cease and desist orders with or without a prior hearing. Brokerage houses cannot issue cease and desist orders to each other. Question 5. Which of the following accurately describes a cease and desist order as authorized by the Uniform Securities Act? A. An order that a federal agency issued to a brokerage firm to stop an advertising campaign. B. An administrator's order to refrain from a practice of business she believes to be unfair. C. A court-issued order requiring a business to stop an unfair practice. D. An order from one brokerage firm to another to refrain from unfair business practices. The answer is A. If the broker-dealer qualifies by virtue of training or knowledge, registration cannot be denied for lack of experience only. Registration may be denied if the applicant willfully violates the Uniform Securities Act, is financially insolvent, or has been enjoined, is the subject of a court-issued injunction, from engaging in the securities business. Question 6. If it is in the public interest, the Uniform Securities Act provides that the state administrator may deny the registration of a broker-dealer for all of the following reasons except: A. The applicant is not qualified because of lack of experience. B. A willful violation of the Uniform Securities Act has taken place. C. The applicant is financially insolvent. D. The applicant is enjoined temporarily from engaging in the securities business. Question 7. An administrator may summarily suspend a registration pending final determination of proceedings under the USA. However, the administrator may not enter a final order without each of the following except: A. Appropriate prior notice to the applicant, as well as the employer or prospective employer of the applicant. B. An opportunity for a hearing. C. Findings of fact and conclusions of law. D. Prior written acknowledgement of the applicant. The answer is D. With the exception of proceedings awaiting final determination, the administrator must provide appropriate prior notice to the applicant, as well as the employer or prospective employer of the applicant, and provide the opportunity for a hearing. In addition, the administrator may issue a final order only after findings of fact and conclusions of law. An applicant is not required to provide written acknowledgement before an order is issued. Question 8. The administrator may cancel the registration of an advisor if: A. Mail is returned with a notice that the forwarding notice has expired. B. The advisor is not in the business any longer. C. A court has declared the advisor to be mentally incompetent. D. Any of the above. The answer is D. You must know the difference between cancellation of a registration, which requires no hearing, and revocation, which does. Cancellation is non-punitive. The registrant is not guilty of a violation. Lesson 5.3. Other penalties and liabilities. Learning Objective 5C. Describe the civil rights of recovery for a securities sale or investment advice purchased in violation of the Uniform Securities Act. Penalties and liabilities. The USA provides both civil liabilities and criminal penalties for persons who violate the USA. In addition, the Act provides for recovery by a client of financial loss that results from any action constituting a violation of any provision of the USA or any rule or order thereunder. In many cases, when an agent or IOR is found civilly liable for improper behavior, officers or other supervisory personnel of the firm may be liable as well, if failure to supervise can be proven. Civil liabilities. Persons who sell securities or offer investment advice in violation of the USA are subject to civil liabilities, as well as possible criminal penalties. The purchaser of securities sold in violation of the Act may sue the seller to recover financial loss. The purchaser can sue for recovery if the securities were sold in violation of the registration provisions of the USA. Sale was of an unregistered non-exempt security in violation of the registration provisions of USA. The securities professional omitted or made an untrue statement of material fact during a sales presentation. The agent was named along with the broker-dealer for a civil infraction. The securities were sold by an agent who should have been but was not registered under the Act, or the securities were sold in violation of a rule or order of the securities administrator. Although most civil suits are brought by the purchaser, the administrator may bring a civil enforcement action in a court, particularly to prevent publication, circulation, or use of any materials required by the administrator to be filed under the Act that have not been filed. Statute of limitations. The time limit or statute of limitations for violations of the civil provisions of the USA is 3 years from the date of sale or rendering of investment advice, or 2 years after discovering the violation, whichever occurred first. Test topic alert. The USA provides that every cause of action under the statute survives the death of any person who might have been a plaintiff or defendant. Therefore, any bond required must provide that suit may be brought for the specified statute of limitations, even though the person who is bonded dies before the expiration of that period. Rights of recovery from improper sale of securities. If the purchaser of securities feels that the sale has been made in violation of the USA, the purchaser may file a complaint with the administrator. If the administrator investigates the claim and finds it has merit, then a case will be opened against the offending broker-dealer, agent, or both. If the client's case is proven, at the direction of the administrator, the client may recover the original purchase price of the securities, made whole, plus interest at a rate determined by the administrator, generally referred to as the state's legal rate, minus any income received while the securities were held. Take note, the exam may refer to the interest paid to the client as being at the state's legal rate. Right of rescission for security sales. If the seller of securities discovers that he has made a sale in violation of the USA, the seller may offer to repurchase the securities from the buyer. In this case, the seller is offering the buyer the right of rescission. To satisfy the buyer's right of rescission, the amount paid back to the buyer must include the original purchase price and interest at a rate determined by the administrator. By offering to buy back the securities that were sold in violation of the Act, the seller can avoid a lawsuit and the payment of court costs and legal fees through a letter of rescission. The buyer has 30 days after receiving the letter of rescission to respond. If the buyer does not accept or reject the rescission offer within 30 days, the buyer forfeits the right to pursue a lawsuit at a later date. If the buyer accepts the rescission offer, she may recover the original purchase price, made whole, of the securities, plus interest at a rate determined by the administrator, generally referred to as the state's legal rate, plus all reasonable attorney's fees and court costs, minus income received during the period in which the securities were held. Take note: a client rejecting the offer of rescission within the 30-day period retains the right to take the matter to court, sue. But if the offer is not accepted or rejected within that 30-day period, it becomes null and void. Rights of recovery from improper investment advice. A person who buys a security as the result of investment advice received in violation of the USA also has the right to sue. In the case of securities purchased as a result of improper investment advice, the buyer may recover the cost of the advice, plus losses resulting from the advice, plus all interest costs from the date of fee payment at a rate determined by the administrator, plus any reasonable attorney's fees, less the amount of any income received from such advice. Right of rescission for investment advice. Similar to the right of rescission described above for securities sales, an investment advisor who realizes that he has given advice that will subject him to civil action may avoid legal expenses by offering the client the same package as he would receive if he had sued, that is, refunding the cost of the advice, losses from the advice and interest at the state's predetermined rate, less any income received on recommended securities. Test topic alert. Unlike some federal laws, there is no provision for receiving treble damages. That is, in addition to receiving back your investment, you receive payment equal to 3 times what you lost. The concept is found primarily in the federal laws regarding insider trading, but it is not relevant to this exam. Scope of liability. Under the USA, the actual seller of the securities or the advice is not the only person liable for the violation of the Act. Every person who directly or indirectly controls the person who sold the securities or the advice, or is a material aid to the transaction, is also liable to the same extent as the person who conducted the transaction. The effect of this is that if an agent makes a sale in violation, or IR gives improper advice, but it can be shown that officers or partners of the broker-dealer or IA were irresponsible, action can be taken against them as well, and they can be found civilly liable. Take note: when securities are sold improperly, the buyer can recover the original purchase price in addition to reasonable income plus, if suit is necessary, legal costs. When improper investment advice is offered, the purchaser of the advice is entitled to recover the cost of the advice, losses incurred, and legal costs, but is not entitled to recover the original purchase price from the advisor. Surety bond. In Unit 2, we discuss the need for securities professionals to post a surety bond under certain conditions. The USA states, every bond shall provide for suit thereon by any person who has a cause of action under this Act, and, if the administrator by rule or order requires, by any person who has a cause of action not arising under this Act. Every bond shall provide that no suit may be maintained to enforce any liability on the bond unless brought within the time limitations of the Act. Test topic alert. In other words, in order for a surety bond to meet the requirements of the USA, it must provide that any customer who can prove a violation, and does so within the statute of limitations, is entitled to collect against the bond. How might this play out on the exam? Let's take a look at a sample question. Practice question. Martha is an agent with Rapid Execution Services, RES, a broker-dealer registered in all 50 states. Martha offers an IPO of a non-exempt security to a client without realizing that the security has not been registered in the client's state. The client purchases 500 shares of the new issue, and, 6 months later, sells the stock at price 70% below the original purchase price. Because the stock was not registered in the client's state, the client could claim payment of the difference between the proceeds and the purchase price interest at the state's legal rate, minus any income received from the security court costs and lawyers' fees if the client has to go to court punitive damages equal to the amount of the loss. A4 only. B1 and 2. C1, 2, and 3. D1, 2, 3, and 4. The answer is C. When a security is sold in violation of the USA, a non-exempt security must be registered under this scenario. The client can claim to be made whole plus interest, plus the expenses of going to court and paying for legal representation. There are no punitive damages. The client recovers the entire loss plus costs. In general, to avoid the legal costs and publicity, when a case like this is uncovered, the broker-dealer will present an offer of rescission, which gives the client all of this except the court and legal fees, because it is not necessary to go to court. Learning Objective 5D identifies civil and criminal liability and penalties for violations of the Uniform Securities Act. Criminal penalties. Persons found guilty of a fraudulent securities transaction are subject to criminal penalties, as well as possible civil liabilities. Upon conviction, the court, not the administrator, may levy a fine against the person, impose a prison sentence, or do both. The maximum penalty is a fine of $5,000, a jail sentence of 3 years, or both. It is important to note that no person may be imprisoned for the violation of any rule or order if he proves that he had no knowledge of the rule or order. In other words, you have to know that you are willingly in violation in order to get jail time. It is also important to note that while the administrator does not have the power to arrest anyone, he may apply to the appropriate authorities in his state for the issuance of an arrest warrant. The appropriate state prosecutor, usually the state attorney general, may decide whether to bring a criminal action under the USA, another statute, or, when applicable, common law. It is up to the court to determine prison time. In certain states, the administrator has full or limited criminal enforcement powers. To be convicted of fraud, the violation must be willful and the registrant must know that the activity is fraudulent. Take note, fraud is the deliberate or willful concealment, misrepresentation, or omission of material information, or the truth to deceive or manipulate another person for unlawful or unfair gain. Under the USA, fraud is not limited to common law deceit. Statute of limitations. The statute of limitations for criminal offenses under the USA is 5 years from the date of the offense. The most common criminal case involves fraud. Some students remember the 5-year statute of limitations from noting that fraud has 5 letters. If it works for you, great. Take note. Remember the sequence 5 to 5-3 for the application of criminal penalties. 5-year statute of limitations, $5,000 maximum fine, and imprisonment of no more than 3 years. Under the civil provisions, the statute of limitations is 2 years from the discovery of the offense or 3 years after the act occurred, whichever occurs first. Judicial review of orders, appeal. Any person affected by an order of the administrator may obtain a review of the order in an appropriate court by filing a written petition within 60 days. In general, filing an appeal does not automatically act as a stay of the penalty. The order will go into effect as issued unless the court rules otherwise. Knowledge Check 5.3. Question 1. Aaron is a client of XYZ Financial Services. Over the past several years, Aaron has been suspicious of possible churning of his account, but has taken no action because account performance has been outstanding. After reviewing his most recent statement, Aaron suspects that excessive transactions have occurred. He consults his attorney, who informs him that under the Uniform Securities Act, any lawsuit for recovery of damages under the Act must commence within A. 1 year of occurrence, B. 2 years of occurrence, C. 3 years of occurrence or 2 years of discovery, whichever occurs first, D. 2 years of occurrence or 3 years of discovery, whichever occurs last. The answer is C. Under the USA, the lawsuit for recovery of damages must commence within the earlier of 3 years after occurrence of the offense or 2 years after its discovery. Question 2. An agent of a broker-dealer has been found civilly liable for making untrue statements in connection with a public offering. The officers of the firm purchased a compliance program from a third-party software developer that was designed to be able to protect against the untrue statements reaching clients. Unfortunately, the program was never used because they could not figure out how it worked. What is the nature of the civil liability of the officers? A. They are liable because they did not act responsibly. B. They are only liable if they willingly ignored the untrue statements. C. The liability is that of the agent's supervisor, not the officers. D. Officers are never liable for actions of their agents. The answer is A. As former President Harry Truman famously said, "The buck stops here." Officers carry liability on behalf of the broker-dealer. Had they taken the initiative to learn how to use the compliance program, the agent would have been stopped in his tracks. Question 3. Which of the following statements relating to penalties under the Uniform Securities Act is true? A. Unknowing violation of the Uniform Securities Act by an agent is cause for imprisonment under the criminal liability provisions of the Act. B. If a violation has occurred in the sale of a security, the purchaser of the security may recover the original purchase price, legal costs, and interest, less any earnings already received. C. The seller who notices that a sale was made in violation of the Uniform Securities Act may offer a right of rescission to the purchaser. The purchaser must accept this right within the earlier of 2 years after notice of the violation or 3 years after the sale. D. Any person aggrieved by an order of the administrator may request an appeal of the order within 15 days which, in effect, functions as a stay of the order during the appeal period. The answer is B. A client who purchased a security in violation of the USA may recover the original purchase price plus costs involved in filing a lawsuit. In addition, the purchaser is entitled to interest at a rate stated by the administrator, less any earnings already received on the investment. To be subject to time in prison, a sales agent must knowingly have violated the USA. The right of rescission must be accepted or rejected within 30 days of receipt of the letter of rescission. Although any person aggrieved by an order of the administrator may request an appeal of the order within 60 days, such appeal does not function as a stay order during the appeal process. The person who is the subject of the order must comply with the order during the period unless a stay is granted by the court. Question 4. When making an offer of a new issue that is in registration to a prospective client, an agent claims that his registration with the administrator is proof of his qualifications. Under the Uniform Securities Act, A. Claiming his registration is approved by the administrator while making an offer of a security undergoing registration subjects this agent to a civil liability claim. B. Claiming his registration is approved by the administrator while making an offer of a security does not subject this agent to a civil liability claim until the registration becomes effective. C. Claiming his registration is approved by the administrator subjects this agent to civil liability only if a sale results. D. Regardless of whether or not a sale takes place, an agent making a misleading statement of this type subjects himself to possible civil liability. The answer is C. For an agent to have civil liability, a sale must take place. If the offer is made using a statement like the one in this question and a sale subsequently occurs, a client suffering a loss would be able to sue. Even though one may never claim approval by the administrator, there is no civil liability unless the client has some kind of a claim of monetary loss. However, even though the client cannot bring a case, the administrator could bring a disciplinary action against the agent for making this claim. On a law exam, you must be careful to understand who has a claim and when they do. Question 5. If an agent chooses to appeal an administrator's order, when must the agent file for review of the order with the appropriate court? A. Immediately. B. Within 30 days after the entry of the order. C. Within 60 days after the entry of the order. D. Within 180 days after the entry of the order. The answer is C. Under the USA, a registered person has up to 60 days to appeal any order issued against him by the state administrator. Unit 6. Communications with customers and prospects. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 6A. Identify the disclosures that must be made to clients and prospects. Learning Objective 6B. Recognize the disclosures and delivery requirements of an investment advisor's brochure. Learning Objective 6C. Indicate the unlawful representations concerning registrations. Learning Objective 6D. Recall the restrictions on performance guarantees. Learning Objective 6E. Identify the required elements of customer account agreements. Learning Objective 6F. Describe the proper use of correspondence in advertising. Introduction. Before a person can become a customer, the person is first a prospect. Knowing what can and what cannot be said at all stages of the relationship is critical to not only the protection of the client, but to the securities professional as well. Failure to abide by the required practices can lead to suspension or a more severe penalty, such as a revocation or bar from the industry. The Series 63 exam will contain 12 questions on the material presented in this unit. Lesson 6.1. Disclosures. Learning Objective 6A. Identify the disclosures that must be made to clients and prospects. Required disclosures by broker-dealers. When asked about the 3 most important factors affecting the value of real estate, invariably the response is location, location, location. In this industry, the 3 most important factors involved in avoiding disciplinary actions are disclosure, disclosure, disclosure. There is very little that a securities professional cannot do as long as proper disclosure is made. Disclosure of capacity by broker-dealers. As stated in Unit 2, broker-dealers can operate either in a principal or agency capacity when executing transactions for their clients. When acting in a principal capacity, the BD is the contraparty to the trade. That is, they are on the other side of the trade of the client. When the client is buying a security, the broker-dealer is selling it out of inventory. In this case, the firm's profit comes from a markup. If the client is selling a security and the broker-dealer purchases it for its inventory, once again, the firm is acting as a principal. Every trade has 2 principals, the buyer and the seller, and, in this case, the profit comes from a markdown. When acting in an agency capacity, the firm is acting like any other broker or agent, real estate broker, insurance agent, travel agent, in that they are simply putting the buyer and seller together. As is the case with all agents or brokers, they earn a commission. For the exam, it is important to know that broker-dealers must always indicate their capacity on the trade confirmation, sent no later than completion of the trade, settlement date. They will indicate if they acted as a broker, and always disclose the amount of commission, or if they acted as a principal, and, depending on the circumstances, not tested, may have to indicate the markup or markdown. Disclosure of conflicts of interest. What is a conflict of interest? One legal definition goes something like this: a term used to describe the situation in which a person in a position of trust, contrary to the obligation and absolute duty to act for the benefit of a designated individual, exploits the relationship for personal benefit, typically pecuniary. Clients of securities professionals expect them to do what is best for them, not for the person they're trusting with their money. The best way to avoid these conflicts of interest is to disclose them so that the customer can decide what to do. We will detail some of the most common examples of potential conflicts of interest at Learning Objective 7E. Disclosure of fees. In 2015, NASA published an investor advisory regarding fees charged by broker-dealer firms for services and maintenance of investment accounts. The advisory followed research from NASA, showing that investors are confused about brokerage services and maintenance fees and want clear and easy access to fee information from their broker-dealer firms. A national public opinion poll commissioned by NASA found that fees are important to investors, but a general lack of standardization and clarity in their disclosures left investors unaware of how much their broker-dealer firms charge for the service and maintenance of their investment accounts. Here are some ways that broker-dealers can make the disclosures easier for customers to follow. Fees are to be disclosed when a customer account is opened. If the firm changes the fee schedule, be clear about it, and be sure to use appropriate methods to give advance notification of the changes to the customer. The advance notice should be a minimum of 30 days. Minimize the fine print, or at least make the fees and charges clear. Whether using a table, a chart, or a list, make sure it is easy for customers to determine what the fees and charges are and how they are computed. Regardless of the disclosure method, the information must be current. Use standardized and uncomplicated terms to describe service and maintenance fees in order to help clients compare fees between different firms. Make the fee schedule available on the firm's website without the need for a password or a login. After all, how can a potential investor compare firms if an existing account is required to view the fee schedule? Take note, a working group convened by NASA developed a model fee disclosure schedule and related accessibility guidelines to help investors better understand and compare various broker-dealer service and maintenance-related fees. The template and guidelines make fee disclosure easily accessible for retail investors to use to understand and compare fees. Typical broker-dealer fees. Examples of the more common fees that might be charged by a broker-dealer include the following. Issuance of a stock certificate. Although most securities are kept in street name, there could be instances where the customer wants delivery of the physical certificate. There is usually a charge for this service. Transferring an account. When a customer decides to move the account from one broker-dealer to another, there is usually a charge to cover the administrative expenses of the transfer. Wiring funds. Although frequently waived for those with large account balances, If the customer needs money wired out of the account, a charge, similar to that made by most banks, is levied against the account. Margin account interest. When purchasing on margin, money is borrowed, and the rate of interest charged on the borrowed funds must be disclosed. Account maintenance fees. Similar to the monthly charge on your bank statement, many firms charge an annual account fee, particularly if a small account. Safekeeping of funds/securities. This is the charge made for maintaining custody of customer assets, which is usually waived for larger accounts. Late settlement fee. This is similar to the late fee on a credit card. When a customer's payment arrives after settlement date or is returned due to insufficient funds, the broker-dealer may assess a fee. Postage and handling. Although many firms absorb the cost of normal mailings, express or overnight delivery at the request of the customer is usually subject to a charge. This is not a complete list, but it includes the most common charges. What is most important for the exam is that all of the fees must be disclosed. Test topic alert. Not included in the fee disclosure documents are commissions, markups and markdowns, and advisory fees. There are other documents used to make those disclosures. Learning Objective 6b. Recognize the disclosures and delivery requirements of an investment advisor's brochure. Investment Advisor Brochure Rule. To provide some assurance that the Act will not be violated, the regulators have recommended that each of the advisor's advisory clients be given a written statement, brochure, prepared by the advisor that makes all appropriate disclosures. The disclosure statement should include the nature and extent of any adverse interest of the advisor, including the amount of compensation it would receive in connection with the account. This is particularly important if the advisor will be receiving compensation from sources other than the agreed-upon advisory fee or that recommendations are limited to the firm's proprietary products. Furthermore, the advisor should, but is not required to, obtain a written acknowledgement from each of its clients of the receipt of the disclosure statement. Because the brochure is really the only way the potential or existing client can learn about the investment advisor, disclosure must be made to all current clients and to prospective clients regarding material disciplinary action. The broadest definition of material would include any actions taken against the firm or management persons by a court or regulatory authority within the past 10 years. Required disclosure would include the following: state or regulatory proceedings in which the advisor or a management person was found to have violated rules or statutes that led to the denial, suspension, or revocation of the firm's or the individual management person's registration; court proceedings, such as a permanent or temporary injunction against the firm or management person pertaining to an investment-related activity or any felony; self-regulatory organization proceedings in which the advisor or management person caused the business to lose its registration, the firm or individual was barred, suspended, or expelled, or a fine in excess of $2,500 or a limitation was placed on the advisor or management person's activities. Recall that in Unit 3 we mentioned that investment advisors registered with the administrator use the Form ADV Parts 1 and 2. Unless otherwise provided in this rule, an investment advisor, registered or required to be registered under the Uniform Securities Act, must furnish each advisory client and prospective advisory client with a brochure, which may be a copy of Part 2A of its Form ADV or written documents containing the information required by Part 2A of Form ADV. A copy of its Part 2B brochure supplement for each individual who provides investment advice and has direct contact with clients in this state, or exercises discretion over assets of clients in this state, even if no direct contact is involved. A copy of its Part 2A Appendix 1 wrap fee brochure if the investment advisor sponsors or participates in a wrap fee account. A summary of material changes, if any. The summary may be included in Form ADV Part 2 or given as a separate document, and such other information as the administrator may require. As stated in Learning Objective 3C, every state-registered investment advisor must file a copy of a complete ADV Part 2 with the administrator within 90 days of the end of the advisor's fiscal year. If during the year there should be a change of a material nature, such as a change of address or a change to the advisor's executive officers, the advisor files an amended Form ADV promptly with the administrator. Take note. It may help you remember that the A in Part 2A tells us that that part is about the advisor and the B in Part 2 is about the bodies, the people, who work there. Brochure delivery requirements. The NASA Model Rule dealing with investment advisor brochures has very specific delivery requirements, both at the initial phase of contact and on an ongoing basis. Initial delivery. An investment advisor, except as discussed in the following, must deliver the Part 2A brochure and any Part 2B brochure supplements required by the rule to a prospective advisory client, not less than 48 hours prior to entering into any advisory contract with such client or prospective client, or at the time of entering into any such contract, if the advisory client has a right to terminate the contract without penalty within 5 business days after entering into the contract. Test topic alert. There will be test questions implying that the brochure must be delivered at least 48 hours in advance. That is not so. It must be delivered not later than entering into the advisory contract. If it is not delivered at least 48 hours earlier, then the penalty-free termination requirement is in effect. Annual delivery. An investment advisor, unless exceptions discussed below apply, must deliver within 120 days of the end of its fiscal year a free, updated brochure and related brochure supplements, which include or are accompanied by a summary of material changes, or deliver a summary of material changes that includes an offer to provide a copy of the updated brochure and supplements and information on how the client may obtain a copy of the brochures and supplements. Take note. Investment advisors do not have to deliver a summary of material changes or a brochure to clients if no material changes have taken place since the last summary and brochure delivery. Exceptions to the brochure delivery requirements. Delivery of the brochure and related brochure supplements need not be made to clients who receive only impersonal advice and who pay less than $500 in fees per year, or a client who is an investment company registered under the Investment Company Act of 1940. Test topic alert. For the purpose of the brochure rule, contract for impersonal advisory services means any contract relating solely to the provision of investment advisory services, by means of written material or oral statements that do not purport to meet the objectives or needs of specific individuals or accounts, through the issuance of statistical information containing no expression of opinion as to the investment merits of a particular security, or any combination of the above services. Electronic delivery of the brochure. Delivery of the brochure and related supplements may be made electronically if the investment advisor, in the case of an initial delivery to a potential client, obtains verification that a readable copy of the brochure and supplements were received by the client. In cases other than initial deliveries, obtains each client's prior consent to provide the brochure and supplements electronically. Prepares the electronically delivered brochure and supplements in the format prescribed in the instructions to Form ADV Part 2. Delivers the brochure and supplements in a format that can be retained by the client in either electronic or paper form, and establishes procedures to supervise personnel transmitting the brochure and supplements and prevent violations of this rule. Many students get confused over the 90-day and 120-day requirements. This example should help. Practice question. Which of the following statements accurately describes the time limits for investment advisor documents? Roman numeral 1. Filing of the annual updating amendment to Form ADVs with the appropriate regulatory body is within 90 days of the end of the advisor's fiscal year. Roman numeral 2. Filing of the annual updating amendment to Form ADVs with the appropriate regulatory body is within 120 days of the end of the advisor's fiscal year. Roman numeral 3. Delivery of the investment advisor's brochure to the customer is due within 90 days of the end of the advisor's fiscal year. Roman numeral 4. Delivery of the investment advisor's brochure to the customer is due within 120 days of the end of the advisor's fiscal year. A4 only. B1 and 2. C1 and 4. D2, 3 and 4. The answer is C. The answer would be choices C. Some logic here might help. The investment advisor must get its paperwork into the state or SEC prior to the end of the 90-day period. Then the IA has another 30 days to get the information into the brochure to be sent to the clients. Learning Objective 6C indicate the unlawful representations concerning registrations. Unlawful representations concerning registrations. Misrepresentation is a prohibited practice. In extreme cases, it may be considered fraud, and that carries criminal implications. There are 2 areas covered: registration of the securities professional and registration of a security. Misrepresenting a securities professional's registration. Once you are registered, What can you say about that? Can you say the administrator has approved of you or your registration? Not at all. Representing that your registration implies any kind of approval of you or your qualifications is a prohibited practice. What you can state is that you are a registered agent of ABC broker-dealer, or you are a registered investment advisor representative of the XYZ investment advisor. Misrepresenting a securities registration. Similar to the above, it is prohibited to imply that registration of a security means that the administrator, or any regulatory body, has approved of the issue. In fact, on the front page or inside cover of every prospectus is a statement called the disclaimer, which states that the security has not been approved or disapproved, and any representation to the contrary is a criminal offense. Learning Objective 6D, recall the restrictions on performance guarantees. Performance guarantees. There is little that can be guaranteed in this industry. Guaranteed security. As mentioned in the beginning of this course, a guaranteed security is where a party other than the issuer guarantees the payment of principal and interest on a debt security or dividend on an equity security. The important thing about that guarantee is that there is no guarantee on the performance of the investment. That is, gains cannot be part of the guarantee. Guarantee against loss. Unfortunately, it is not uncommon in the industry for a securities professional to tell a client something to the effect of, if this stock doesn't earn X% within the next 3 months, I'll make up the difference, or I'm so sure you won't lose on this investment that I'll buy it back from you at your cost plus 10%. Both of these are considered performance guarantees and are prohibited actions. Perhaps the simplest statement regarding guarantees is found in the NASA Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors, where it lists guaranteeing a client that a specific result will be achieved, gain or no loss, with advice which will be rendered, as one of the prohibitions. Take note, although performance guarantees are prohibited, under certain circumstances, investment advisors can receive performance-based compensation. That means the advisory contract with the client can provide that investment return that is better than that of a selected index can result in a higher fee to the advisor. Of course, it must go both ways. If the performance of the account is below that of the index, the fee is reduced. Test topic alert. If justified, a broker-dealer, but not an associated person of the firm, may correct a bona fide error. This does not apply to an associated person of a member because of the concern that any such payment may conceal individual misconduct. Knowledge Check 6.1. Question 1. As called for on the NASA Model Fee Disclosure Template, which of the following is not required to be disclosed on a broker-dealer's fee chart? A. The commission schedule. B. The account maintenance fee. C. Charges to wire funds. D. Postage and mailing charges. The answer is A. Commissions, markups and markdowns, and advisory fees are not part of the NASA Fee Disclosure Template. Question 2. Required broker-dealer disclosures include all of the following except A. The firm's net profit for the year. B. The capacity in which the firm acted in a securities transaction. C. Conflicts of interest. D. Fees. The answer is A. Broker-dealers are not required to disclose their operating results, profits or losses, to their customers. It is not prohibited, but it is not required. The other choices are requirements. Question 3. A state-registered investment advisor must deliver a copy of its brochure to a new advisory client. A. No later than the time of signing the advisory agreement. B. At least 48 hours before entering the advisory agreement. C. No later than 48 hours after entering the advisory agreement. D. Within 120 days after the end of the advisor's fiscal year. The answer is A. New clients must receive a copy of the advisor's brochure no later than the entry of the advisory agreement. That occurs when it is signed. Under state law, the contract must be in writing. The 48-hour in advance rule says that brochure delivery after that time requires the IA to offer a penalty-free withdrawal from the contract if done within 5 days after the signing of the agreement. The 120-day requirement is for existing, not new clients. Question 4. Which of the following statements may be made by an issuer selling securities to the public that are registered with the administrator? A. The administrator has cleared this issue for sale to the public. B. The administrator has passed on the adequacy of the information provided in the prospectus. C. The administrator has approved the accuracy of the information contained in the prospectus. D. The administrator has affirmed the merits of the security as an investment. The answer is A. The administrator does not approve or disapprove of securities. Rather, the administrator reviews registrations for omission of material facts and clarity of information, and makes certain that all supporting documentation is included. If these requirements are met, the administrator clears or releases the security for sale to the public. Question 5. LMN Securities, a broker-dealer registered with the SEC in more than a dozen states, has just become a member firm of the New York Stock Exchange. It would be permitted for LMN to tell its customers that A. The membership in the NYSE is a testimony to the integrity of the firm. B. They are now members of the NYSE. C. They are now federal covered and will no longer have to register in those states where they do not maintain a place of business. D. This adds one more level of approval of the firm's business. The answer is B. When it comes to the registration of any securities professional, any statement relating to approval or something similar is prohibited. There is no such thing as a federal covered broker-dealer, and becoming a member of a national stock exchange has no impact on the state registration of a broker-dealer. Question 6. An agent with your firm is so confident that a stock will double within the next 2 months that he is offering his customers a guarantee that anything less than a 50% increase will be added to their account from his personal funds. Under the Uniform Securities Act, A. This is a dishonest and unethical practice and could lead to disciplinary action. B. This is a fair way to treat his customers. C. This is unfair because with a 100% predication, a 50% payout is unreasonable. D. If the agent does not back up his guarantee, he will be liable to potential incarceration. The answer is A. Guarantees such as this are prohibited in the securities industry. The administrator would likely investigate this, and if found guilty, it could result in a fine, suspension, or even revocation of the agent's registration. It is possible that the agent could be the subject of a civil action, monetary damages brought by customers, but this is not the kind of activity resulting in a prison sentence. Lesson 6.2. Customer Agreements. Learning Objective 6E identify the required elements of customer account agreements. Investment Advisory Contracts. NASA's Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors includes the following as one of the unethical business practices. Entering into, extending, or renewing any investment advisory contract, unless such contract is in writing and discloses, in substance, the services to be provided, the term of the contract, the advisory fee, the formula for computing the fee, the amount of prepaid fee to be returned in the event of contract termination or non-performance, whether the contract grants discretionary power to the advisor, and that no assignment of such contract shall be made by the investment advisor without the consent of the other party to the contract, the customer. Another prohibition found in that model rule is indicating in an advisory contract any condition, stipulation, or provisions binding any person to waive compliance with any provision of the Uniform Securities Act or of the Investment Advisors Act of 1940. Test Topic Alert. The topic of waivers sometimes comes up on the exam. What you have to know is that, other than the fees described in Learning Objective 6A, in all cases on the test, remember, this course is about the test world and not the real world. Waivers are not permitted. Performance-based compensation for investment advisors. The Uniform Securities Act also prohibits certain performance fee arrangements, contingent on capital gains or appreciation being part of the advisory contract. There is an exception, however, from the performance fee provisions for contracts with a qualified client defined as a natural person or company that immediately after entering into the contract has at least $1.1 million under the management of the investment advisor, or a natural person or company that the IA has reason to believe that immediately before entering into the contract has a net worth exclusive of the primary residence, in the case of individuals, assets held jointly with a spouse, but no one else can be used, in excess of $2.2 million. When computing the fee, both gains and losses must be considered. The fee cannot be based solely on gains. This fee computation contains realized as well as unrealized appreciation and depreciation. Think of it this way. If you bought a stock and then sold it this year for a profit of $1,000, that is a realized gain of $1,000. If there was a second stock you bought but still owned it, and as of the end of the year, it was down in value by $600, you have an unrealized loss of $600. The net increase in portfolio value is only $400. That is the basis for determining the advisor's performance fee. Please note, a fee based on the average amount of money under management over a particular period is not considered a performance fee. Also, it is within the administrator's powers to permit this type of fee to be part of the advisory contract with a client who does not meet the above requirements. In simple terms, if the administrator believes the client has the sophistication necessary to understand the risks, it is within her powers to grant an exception. Opening an account with a broker-dealer involves a certain amount of paperwork. How can one make suitable recommendations without having some knowledge of the customer's financial condition and objectives? In addition, there are federal laws requiring broker-dealers to obtain enough information about a client to minimize the possibility of money laundering or other illegal practices. We will examine some of these agreements. New Brokerage Account Agreement. Opening an account requires the completion of the new account agreement. This is basically a contract between the broker-dealer and the customer explaining the rights and obligations of both and the charges for the services that will be rendered. Information that must be obtained from the customer includes items such as: does the customer have the legal capacity to enter into agreements? That is the customer of full legal age in the state of jurisdiction, and does she have the capacity to enter into the agreement? Employment information. The Customer Identification Program, CIP, notice. In order to help the government fight the funding of terrorism and money laundering activities, broker-dealers are required by federal law, the USA Patriot Act of 2001, to obtain, verify, and recruit information that identifies each person who opens an account. That information includes the following 4 items: name, date of birth. Note that the new account form only requires the account holder be of legal age, while the CIP requires the actual date of birth. The actual residential or business street address, no mail receiving or P.O. boxes, and tax identification number. If a U.S. citizen, this is typically the Social Security number, citizenship or visa details, and financial information about the customer. Some clients will open margin accounts, options accounts, or both. In these cases, special requirements apply. Margin accounts. Margin accounts allow investors to leverage their investment dollars. Through margin accounts, investors can borrow money from brokerage firms by pledging the purchased stock as collateral. Opening a margin account involves signing 2 agreements, with an optional third. Those are the credit agreement that discloses the terms of the credit extended by the broker-dealer, including the method of interest computation in situations under which interest rates may change. The hypothecation agreement that stipulates that the broker-dealer may use the client's margin securities as collateral for the loan that it makes to the client. Furthermore, it gives permission to the broker-dealer to pledge, rehypothecate, customer margin securities as collateral. The firm rehypothecates customer securities to the bank, and the bank loans money to the broker-dealer on the basis of the loan value of these securities, and the optional loan consent form, which gives permission to the firm to loan customer margin securities to other customers or broker-dealers, usually for short sales. Take note, in simple terms, there are 2 loans taking place in a margin account. The loan from the BD to the client with the client's securities used as collateral, that is covered in the credit agreement, and the loan from a bank to the BD with the client's securities used as collateral for the BD loan. The authorization for the BD to use those securities is found in the hypothecation agreement. Test Topic Alert. NASA's Statement of Policy on Dishonest or Unethical Business Practices of Broker-Dealers and Agents states that it is prohibited to execute any transaction in a margin account without securing from the customer a properly executed, written margin account agreement promptly after the initial transaction in the account. Margin Account Risk Disclosure Document. Although NASA does not have one FINRA rules, which most states view as practices to be followed by broker-dealers under their jurisdiction, do have a risk disclosure requirement for margin accounts. As part of opening a margin account, the broker-dealer must provide customers with a risk disclosure document. This information must also be provided to margin customers on an annual basis. The document discusses the risks associated with margin trading, some of which are listed below. You can lose more funds than you deposit in the margin account. The firm can force the sale of securities or other assets in your account and do so without contacting you. You are not entitled to choose which securities can be sold if a call for additional funds is not met. You are not entitled to an extension of time to meet a margin call. The firm can increase its house maintenance margin requirements at any time and is not required to provide you advance written notice. Practice question. An investor opening a new margin account would be required to sign, Roman numeral 1, the new account form. Roman numeral 2, the hypothecation agreement. Roman numeral 3, the loan consent agreement. Roman numeral 4, the credit agreement. A2 and 3. B2 and 4. C2, 3 and 4. D1, 2, 3 and 4. The answer is B. The customer is not required to sign the new account agreement, regardless of the type of account. For a margin account, the customer's signature is required on the credit and hypothecation agreements. Giving consent to lend out securities held in the account is optional. Options accounts. NASA does not have a specific rule dealing with the opening of options accounts. So, just as we did with the margin account risk disclosure document, we will refer to FINRA's rules. Because trading options, puts and calls, generally involves a higher degree of risk than stocks, bonds, or mutual funds, a designated supervisory person with knowledge about options must approve the account opening. That person is generally a registered options principal (ROP). In addition, there is a special options disclosure document (OD) published by the Options Clearing Corporation (OC) that must be provided to any prospective options customer no later than with the approval of the account. In approving a customer's account for options trading, a broker-dealer or agent associated with the broker-dealer must exercise due diligence to ascertain the essential facts relative to the customer, his financial situation, and his investment objectives. One question asked on a new options account form that is not required on a normal brokerage account opening is investment experience and knowledge, e.g., number of years, size, frequency, and type of transactions for options, stocks and bonds, commodities, and other financial instruments. Based upon such information, the designated supervisory person shall specifically approve or disapprove in writing the customer's account for options trading. Although options are not marginable securities, they must be paid for in full. They may be purchased in a margin account with full payment made by the customer. The account approval will indicate them. Date the options disclosure document, OD, is furnished to the customer. Nature and types of transactions for which the account is approved, e.g., buying, covered writing, uncovered writing, spreading, discretionary transactions, name of the agent assigned to the account, name of the supervisor approving the account, date of approval, and dates of verification of currency of account information. Receipt of the options account agreement. Within 15 days after a customer's account has been approved for options trading, the broker-dealer must obtain from the customer a written agreement that the customer is aware of and agrees to be bound by FINRA rules applicable to the trading of option contracts, and that the customer has received a copy of the current ODD. Part of the agreement states that she is aware of and agrees to be bound by the rules of the Options Clearing Corporation. Basics of options. Although this exam does not delve deeply into product knowledge, knowing how options work is important for understanding the risks and suitability. An option is a two-party contract, meaning that there are two parties involved in the contract. One party has the right to exercise the contract to buy or sell the underlying security, and the other is obligated to fulfill the terms of the contract with a specified time period, usually a maximum of 9 months. Buyers risk losing what they pay for the contract if the option expires worthless. In that case, the seller of the option earns the amount paid by the buyer. Conversely, if the price of the stock that is the subject of the option moves in the direction hoped for by the option buyer, it can result in a significant profit for the buyer. To the extent the buyer wins, the seller loses. In fact, there are cases where the buyer of an option has an unlimited potential gain with the seller having a potentially unlimited loss. There are two types of options on stock, calls and puts. A call option gives the buyer the right, but not the obligation, to buy the stock from the person who granted the buyer that option, the seller, at a specified price, the exercise price. Call buyers are generally thought of as being bullish. Example: an investor pays $200 to purchase a call option on ABC stock with an exercise price of $50 per share. This investor believes the price of ABC will increase bullish. If the investor is correct and, let's say, ABC price rises to $60 per share, the investor purchases 100 shares at $50 per share, $5,000, by exercising the option, and then can sell the shares at the current market price and receive $6,000. That is a $1,000 gain less the $200 cost of the call option. For the seller to meet the obligation, sell 100 shares of ABC at $50 per share. It was necessary to buy 100 shares at the current market price of $60 per share, $6,000. because the seller receives the $50 per share exercise price. The loss is $1,000 less the $200 received when selling the option. The net result is a profit of $800 to the buyer of the call and a loss of $800 to the call seller. In essence, the buyer of the call had all of the benefit of owning the stock with a small cash outlay. That is, the buyer could have paid $5,000 initially to purchase 100 shares and then sold them when the market price reached $60 per share. There would have been a profit of $1,000 on an investment of $5,000 or a 20% return on investment, $1,000 divided by $5,000. Instead, the option buyer paid $200 and earned a net profit of $800. A return of $800 on an investment of $200 is quadrupling your money and shows the leverage potential when investing in options. Buying options is not without risk. In our example, if the stock had stayed at $50, the investor's option would have expired worthless. That means a loss of the $200 paid for the option 100% of the investment. Put options work in the reverse direction. A put buyer has the right to sell, put, the stock to the put option seller at the specified exercise price. Put buyers are generally thought of as being bearish. They profit when the price of the stock falls. The buyer of an XYZ80 put benefits if XYZ price falls to $70 per share because the stock can be purchased for $70 and sold, put, to the option seller at $80. That would generate a profit of $10 per share less the cost of the option. A put buyer has all of the benefits of a bearish investor who sells the stock short, bearish, but without the unlimited risk of short selling. Knowledge Check 6.2. Question 1. Which of the following customers of an investment advisor would meet the definition of a qualified client? A. An investor with $1.5 million in net worth and $700,000 under the management of the advisor. B. An investor with $2.5 million in net worth and $10,000 under the management of the advisor. C. An investor who has a net worth together, in the case of a natural person, with assets held jointly with a spouse, of $2.2 million. D. An accredited investor. The answer is B. There are two ways to be a qualified client. Either have a net worth together, in the case of a natural person, with assets held jointly with a spouse, of more than $2.2 million, or have at least $1.1 million under management with the investment advisor. The requirement to be an accredited investor is less than a qualified client and, as a federal term, is not likely to be a correct answer on the exam. Question 2. Which of the following is not required under the Customer Identification Program when opening a new account for an individual? A. Date of birth. B. Name of employer. C. Social Security number. D. Physical residential address. The answer is B. The name of the client's employer is part of the new account form, but is not one of the requirements of the CIP as are the other items. Question 3. A client has a cash account at his broker-dealer. Now, he wishes to open a margin account as well. Which of the following best describes the procedure the firm must follow? A. Oral instructions to open the account are sufficient because the customer relationship already exists. B. The customer must make the request in writing, either by postal mail, email, or by fax. C. The firm must obtain a properly executed written margin account agreement promptly after the initial transaction in the account. D. The customer must physically present himself at the agent's office and sign the appropriate papers. The answer is C. Opening a margin account is more involved than opening a cash account. There are some agreements requiring the customer's signature. The firm must obtain a properly executed written margin account agreement promptly after the initial transaction in the account. The presence of an existing cash account is meaningless here. Question 4. The purpose of the Customer Identification Program, CIP, is to A. Enable a broker-dealer to form a reasonable belief that it knows the true identity of each customer. B. Enable a broker-dealer to know how to contact a customer in the event of an emergency. C. Provide a method by which broker-dealers could assist customers laundering money. D. Provide broker-dealers with sufficient client information to make suitable recommendations. The answer is A. The CIP is part of the USA Patriot Act, and its primary concern is to make sure that broker-dealers and other financial institutions, such as banks, know exactly who the customer is. Money laundering is an illegal activity, and the CIP does not provide the kind of information necessary for making suitability judgments. Question 5. When an investor purchases a call option, the investor has A. All of the benefits of owning the stock when expecting the price of the stock to go down, bearish. B. All of the benefits of owning the stock when expecting the price of the stock to rise, bullish. C. None of the benefits of owning the stock when expecting the price of the stock to go down, bearish. D. None of the benefits of owning the stock when expecting the price of the stock to rise, bullish. The answer is B. Call buyers are optimistic about the future movement of a stock's price. If the price of the stock goes up, the owner of the call option benefits in the same manner as owning the stock. Technically, the cost of the call option offsets some of the profit, but we do not believe the exam will go that deep. Lesson 6.3, Correspondence in Advertising. Learning Objective 6F, describe the proper use of correspondence in advertising. It should be clear that disclosure and fairness are the primary themes underlying all communications with customers. Use of social media websites for business purposes should be treated no differently from any other business-related electronic communication. Firms must ensure they have sufficient systems, policies, and procedures to supervise, review, and retain business communications made using social media sites. In this final segment of this unit, we will address several of the specific methods used to communicate with both existing and prospective customer. Social media including electronic communications, emails, and text messages. Communication with customers has historically been through written correspondence, while the traditional way of reaching prospects has been through print, TV, and radio advertising. In the 21st century, however, snail mail has given way to email, texting, and the broker-dealer's website. Prospects are being reached through various social networks, as well as the Internet. At the time of this printing, NASA's primary concern with social media has been alerting investors to the risks. Although some of that may be tested, it is probable that the Series 63's focus will be on usage of social media by securities professionals. As has been done with other topics not directly addressed by NASA, we will rely on the policies adopted by other regulators. But first, let's look at some of NASA's comments regarding investor awareness. Investor concerns regarding social media. Social networking in the Internet age allows people to connect to one another more quickly and easily than ever before. Investment promoters increasingly are logging on to find investors in their money. The role of the securities professional is to help protect clients from falling prey to the many phony schemes found on social networks. While social networking helps connect people with others who share similar interests or views, con artists infiltrate these social networks looking for victims. By joining and actively participating in a social network or community, the con artist builds credibility and gains the trust of other members of the group. In online social networks, a con artist can establish this trust and credibility more quickly. The scammer has immediate access to potential victims through their online profiles, which may contain sensitive personal information, such as their dates or places of birth, phone numbers, home addresses, religious and political views, employment histories, and even personal photographs. The con artist takes advantage of how easily people share background and personal information online and uses it to make a skillful and highly targeted pitch. The scam can spread rapidly through a social network as the con artist gains access to the friends and colleagues of the initial target. Take note, social media generally takes two forms, static and interactive. Static content remains posted until changed by the person who established the account on the site. Generally, static content is accessible to all visitors to the site. Examples of static content typically available through social networking sites include company websites, profiles, backgrounds, or walls. Images and pre-recorded videos also fall into the category of static content. Interactive content, as the name implies, has input from both the creator and the viewer. Common examples include Facebook, Twitter, Instagram, and LinkedIn. Another case would be the comment section on the firm's blog or live webinars with a chat feature. Online red flags for investors. Promises of high returns with no risk. Many online scams promise unreasonably high short-term profits. Guarantees of returns around 2% a day, 14% a week, or 40% a month are too good to be true. Remember that risk and reward go hand in hand. Offshore operations. Many scams are headquartered offshore, making it more difficult for regulators to shut down the scam and recover investors' funds. E-currency sites. If investors have to open an e-currency account to transfer money, use caution. These sites may not be regulated, and con artists use them to cover up money trails. Recruit friends. Most cons will offer bonuses if investors recruit their friends into the scheme. Professional websites with little to no information. These days, anyone can put up a website. Scam sites may look professional, but they offer little to no information about the company's management, location, or details about the investment. No written information. Online scam promoters often fail to provide a prospectus or other form of written information detailing the risks of the investment and procedures to get the investor's money out. Testimonials from other group members. Scam artists frequently pay out high returns to early investors using money from later arrivals. This type of scam is a Ponzi scheme. Fraud aimed at groups of people who share similar interests is called affinity fraud. Regulatory concerns about social media. Both the SEC and FINRA have established policies, most of which are used as the basis for disciplinary actions, when the administrator's staff conducts an examination of broker-dealers and investment advisors located in his state. NASA has offered guidance to broker-dealers and registered personnel in their notices to members regarding the use of different technologies and devices for the delivery of business communications. As the technology, communications platforms, and devices are ever-changing, so will be the guidance, and NASA will continue to supply interpreted materials to assist in that respect. Currently, the use of email, instant messaging, chat rooms, blogs, bulletin boards, and websites, including social networking sites such as Facebook, LinkedIn, and Twitter, are all included within NASA's guidance. While the challenge is generally to determine which category of public communication any piece falls under to determine its supervisory and filing requirements, retail, correspondence, or institutional, NASA has said that it will always be the content delivered that ultimately determines this, and not the technology, platform, or device used to deliver it. In this light, NASA reminds broker-dealers that compliance responsibilities when communicating via the Internet or other electronic media are the same as in face-to-face discussions or in written communications with the public. Therefore, all existing rules and regulations applicable to communications with the public would also be applicable to communications delivered electronically by any technology or device if the content is business-related. In addition, registered representatives, agents, must be aware of internal firm policies and procedures that may restrict or prohibit the use of certain electronic communications, and in those instances, NASA directs that employees of the firm must abide by the firm's internal policies. Example: although social media has been around for some time, it has now caught the attention of the SEC, and every other regulator for that matter. You might ask, why should I be concerned with my emails or Facebook posts? Well, here are just a couple of examples of how and why the regulators react. The problem for regulated financial institutions is that inappropriate use of email and other social media can mean non-compliance with government and industry regulations, resulting in hefty fines, potential loss of business, and fraud. A few years ago, a major international bank lost nearly $4.9 billion in fraudulent trades by a rogue employee that used instant messaging to manage the transactions. On a smaller level, in early 2016, an agent was fined $15,000 and suspended from association with any broker-dealer for a period of 2 years for sending an unapproved email to prospective clients. During the same time period, a broker-dealer was fined $1.1 million, and one of its agents was fined $50,000 for failure to retain emails as required. So, this is serious business to the regulators. You need to know that agents are duty-bound to follow the rules and regulations surrounding electronic communications, even during their own time, if they are identifiable as a representative of the securities firm. Members of the marketing team might understand what is appropriate to post to Facebook or what process to follow to post, but without proper training, average agents may not. Their posts or photographs from weekend parties might not be suitable content. Review and supervision of electronic communications. When it comes to review and supervision, it is important to note that the terms electronic communications, email, and electronic correspondence may be used interchangeably and can include such forms of electronic communications as instant messaging and text messaging. Advertising. NASA considers it to be an unethical business practice to use any advertising or sales presentation in such a fashion as to be deceptive or misleading. An example of such practice would be a distribution of any non-factual data, any material or presentation based on conjecture, unfounded or unrealistic claims in any brochure, flyer, or display by words, pictures, or graphs, or anything otherwise designed to supplement, detract from, supersede or defeat the purpose or effect of any prospectus or disclosure. One way in which this violation occurs is when a broker-dealer or agent prepares a sales brochure for a new issue, but includes only the positive information from the prospectus. Leaving out risk factors and other potentially deal-killing information is prohibited. Somewhat related, and also prohibited, is highlighting or making any other marks on a prospectus to draw attention to key points. As stated in the previous unit, under the Uniform Securities Act, the administrator may by rule or order require the filing of advertisement and sales literature unless the security or transaction is exempted or is a federal covered security. Broker-dealer advertising. Included in advertising is a firm's website. In Unit 2, we describe the conditions related to determining if a broker-dealer was considered to have a place of business in the state and required to register or not. You should go back and review that material. Whether through the website or other social media, an important form of communications with the public is the making of recommendations. A logical question is, do recommendations made through social media come under the same suitability constraints as any other recommendation? The reply is just what you would expect. Of course they do. In reality, it is not always obvious when a particular communication constitutes a recommendation for purposes of the suitability rule. Because so much hinges on what is considered to be a recommendation, let's look further at some examples of what is and what is not a recommendation. In addition to when a broker-dealer acts merely as an order taker regarding a particular transaction, an unsolicited transaction, which we know is an exempt transaction, exempt from the registration and advertising filing requirements under the USA, the policy generally would view the following activities and communications as falling outside the definition of recommendation. A broker-dealer creates a website that is available to customers or groups of customers. The website has research pages or electronic libraries that contain research reports, which may include buy-sell recommendations from the author of the report, news quotes, and charts that customers can obtain or request. A broker-dealer has a search engine on its website that enables customers to sort through the data available about the performance of a broad range of stocks and mutual funds, company fundamentals, and industry sectors. The data is not limited to, and does not favor, securities in which the BD makes a market or has made a buy recommendation. Customers use and direct this tool on their own. Search results may display current news, quotes, and links to related sites. A broker-dealer provides research tools on its website that allow customers to screen through a wide universe of securities, e.g., all exchange-listed and NASDAQ securities, or an externally recognized group of securities, e.g., certain indexes, and to request lists of securities that meet broad, objective criteria, e.g., all companies in a certain sector with 25% annual earnings growth. The BD does not control the generation of the list in order to favor certain securities. For instance, the BD does not limit the universe of securities to those in which it makes a market or for which it has made a buy recommendation. A broker-dealer allows customers to subscribe to emails or other electronic communications that alert customers to news affecting the securities in the customer's portfolio or on the customer's watch list. The customer selects the scope of the information that the firm will send to him. On the other hand, the regulators generally would view the following communications as falling within the definition of recommendation. A broker-dealer sends a customer-specific electronic communication, e.g., an email or pop-up screen, to a targeted customer or targeted group of customers, encouraging the particular customer S to purchase a security. A broker-dealer sends its customers an email stating that customers should be invested in stocks from a particular sector, such as technology, and urges customers to purchase one or more stocks from a list with buy recommendations. A broker-dealer provides a portfolio analysis tool that allows a customer to indicate an investment goal and input personalized information, such as age, financial condition, and risk tolerance. The BD, in this instance, then sends the customer a list of specific securities the customer could buy or sell to meet the investment goal the customer has indicated. A broker-dealer uses data mining technology, the electronic collection of information on website users, to analyze a customer's financial or online activity, whether or not it is known by the customer, and then, based on those observations, sends or pushes specific investment suggestions that the customer purchase or sell a security. It is important to keep in mind that these examples are meant only to provide guidance, and are not an exhaustive list of communications that are or are not considered to be recommendations. The regulators recognize that many other types of electronic communications are not easily characterized. In addition, changes to the factual suppositions upon which these examples are based, or the existence of additional factors, could alter the determination of whether similar communications may or may not be viewed as recommendations. Broker-dealers, therefore, should analyze all relevant facts and circumstances to determine whether a communication is a recommendation, and they should take the necessary steps to fulfill their suitability obligations. Take note, shortly before the initial printing of this manual, SEC Regulation Best Interest, Reg BI, went into effect. Because this is a federal law, it is unlikely that it will be the subject of any questions on this exam. If that should not be the case, we will post the information to the exam tips and content updates. Investment advisor advertising. When it comes to investment advisors, the NASA model rule states that publishing, circulating, or distributing any advertisement which does not comply with the Investment Advisors Act of 1940 would be prohibited. An investment advisor should not publish, circulate, or distribute any advertisement that is inconsistent with federal rules governing the use of advertisements. Included in the prohibition are advertisements containing untrue statements of material fact or exaggerated claims. Using the initials RIA, registered investment advisor must be spelled out, that refer directly or indirectly to any testimonial of any kind, that refer to past specific recommendations of the investment advisor, unless certain conditions are met, such as including all recommendations, both winners and losers, for a period of at least the previous 12 months, that represent that a chart, formula, or other device being offered can, by itself, be used to determine which securities are to be bought or sold, or that contain a statement that any analysis, report, or service will be furnished for free when that is not the case. These prohibitions are fundamental and sound standards that all investment advisors should follow. An advertisement under state law is defined as a communication to more than one person. In addition, although the rules do not prohibit testimonials for broker-dealers and their agents, they are strictly forbidden for use by IA. One thing to look for on the exam deals with investment advisors who advertise a charting or similar system. They must indicate that there are limitations and difficulties inherent in using such programs. Take note, update for the SEC Investment Advisor Marketing Rule. In July 2021, NASA announced that information pertaining to the new SEC Investment Advisor Marketing Rule is expected to be added to the Series 63 examination before the end of the year. Please check the content updates on your dashboard for the exact date on which the new rule takes effect, and be aware that our Q Bank will be updated. The SEC adopted amendments to the Investment Advisors Act addressing IA advertisements and payments to solicitors. Here are some key points that might be tested. The definition of advertisement now includes third-party information if the advisor has either endorsed or approved the information after publication or involved itself in the preparation of the information. See adoption and entanglement below. Communications to investors in a private fund. And extemporaneous, live, written communications such as texts or electronic chats. Advertisement does not include extemporaneous, live, oral communications and information contained in a statutory or regulatory notice or filing, e.g., Form Ad. On the other hand, prepared material, such as scripts or slides to be used in a presentation, are likely going to be considered advertisements. The marketing rule permits the use of testimonials, statements from clients about their experience with the IA and endorsements, statements by persons that are not clients, in advertisement if the advisor satisfies the following disclosures. Advertisements must clearly and prominently disclose whether the person giving the testimonial or endorsement, the promoter, is a client and whether the promoter is compensated. Please note the like feature on an investment advisor's social media site could be deemed to be a testimonial if it is an explicit or implicit statement of a client's experience with the advisor. Solicitors may be considered promoters for purpose of the rule. Advisors also must enter into a written agreement with promoters, except where the promoter is an affiliate of the advisor or the promoter receives de minimis compensation, i.e., $1,000 or less, or the equivalent value in non-cash compensation, during the preceding 12 months. The marketing rule allows the inclusion of performance information in an advertisement if certain conditions are met. Specifically, the marketing rule prohibits including in any advertisement gross performance unless the ad also includes net after fees performance, any performance results, unless they are provided for specific time periods, the most recent 1, 5, and 10-year periods to the extent applicable. Cherry picking, by showing only the best performing portfolios. Hypothetical performance, unless the advisor adopts and implements policies and procedures reasonably designed to ensure that the performance is relevant to the intended audience. And predecessor performance, unless there is appropriate similarity with regard to the personnel and accounts at the predecessor advisor and the personnel and accounts at the advertising advisor. As exam feedback comes in from students, we will post the information on the Content Updates page of your dashboard. Issues related to agents. While much of the supervisory burden revolves around broker-dealer use of various social media tools, the nitty-gritty, day-to-day work relates to their agents. Some things to be aware of include the following. In addition to computers in the office, personal devices, such as smartphones and tablets, used to communicate with clients in a social media setting are covered by the rules. Depending on the nature of the media, prior approval by a supervisory person may or may not be required. For example, an unscripted participation in an interactive electronic forum, such as Twitter, comes within the definition of a retail communication that does not require prior supervisory approval. On the other hand, a LinkedIn page would probably require pre-approval. Look out for the red flags. Certain activities, such as linking to third-party sites or receiving data feeds from outside sources, could contain information that NASA considers objectionable. It is not the device or technology that determines if a piece delivered by a broker-dealer or any agent is subject to approval and record-keeping. Rather, it should always be the content that determines if a piece delivered by an agent is subject to approval and record-keeping. It is suggested that Twitter posts are easy to monitor, but sites such as Facebook are not, given what they've termed entanglement issues, i.e. the firm or its personnel is involved with the preparation of a third-party post, and the challenges they pose. Essentially, who is responsible for links to a third-party site, and who is responsible for third-party postings to an agent's Facebook page. Specifically regarding Twitter, posts do not need supervisory pre-approval except for an agent's initial tweet. LinkedIn is considered different from Facebook, as it is more of a business networking site than a social site. With that, it is believed that information limited to your current position, past positions, and job responsibilities allow the site to be left unmonitored, as the firm would have no responsibility regarding that content for any individual. However, if testimonials are used on the site, Joe is the best stockbroker in the world, or I've made a ton of money because of Joe's recommendations, or if recommendations are posted on the site, then that would make it a business site that the firm is now responsible for. To avoid problems, it is generally suggested that investment advisors and their representatives select No for the I want to be endorsed feature under the Skills and Expertise section on their LinkedIn profile. Test topic alert. There are two specific social media terms that could appear on your exam. Those are entanglement and adoption. If the firm or an associated person has paid for or been involved in the preparation of the content, that is deemed to be entanglement. If the firm or associated person explicitly or implicitly endorsed or approved the content, it is deemed to be adoption. Supervisory actions to be taken by the broker-dealer. Prior to allowing associated persons to use social media for business purposes, a firm's policies and procedures must provide for personnel training and education relating to the parameters of permitted use. Both supervisory personnel and agents need to understand the difference between interactive and static content, between business and non-business communications, and whether the communication is a retail communication requiring pre-approval. A firm should consider requiring training in the use of social media prior to permitting use. At a minimum, a firm that permits use of social media sites must hold annual training as part of its continuing education obligations. Any such training will reinforce personnel understanding of the firm's policies and procedures as applied to this continuously evolving technology and, in turn, limit the firm's compliance risks. One of the unintended consequences of the growth of social media has been exposure to privacy issues. The firm's social media policies should include relevant privacy issues. We will cover those in Unit 8 when we discuss cybersecurity and data protection. To summarize, because the technology behind social media continues to advance at such a rapid pace, potential damage to both the firm and employee exist. To mitigate these, it is suggested that firm policies should be committed to writing and communicated firm-wide, be written in a clear and concise manner so as to eliminate confusion, define the responsibilities of all concerned parties, from registered representatives, agents, to principals, to minimize confusion and maximize expectations. And clearly describe the monitoring tools to be used by the firm. Because social media technology continues to evolve, the potential for reputational and financial loss from any employee or firm mistake is difficult to quantify. Prior to venturing into any form of social media, firm policies should 1. Be firmly established, 2. Be precise, 3. Clearly define the employee's responsibilities, and 4. Explain how they are to be monitored on each electronic platform utilized by the firm. Until the law catches up with technology, a useful way to reduce and manage unforeseeable social media risk is to create a work environment that fosters a strong culture of compliance. Knowledge Check 6.3, Question 1. The regulatory bodies are concerned about agents using social media to communicate with clients when they are using their Roman numeral 1. Office desktop computers. Roman numeral 2. Personal tablets. Roman numeral 3. Smartphones. Roman numeral 4. Personal laptops from home. A. 1 and 2. B. 1 and 4. C. 2, 3, and 4. D. 1, 2, 3, and 4. The answer is D. Any of these items may be used on social media, regardless of whether they are owned personally or by the employer. Question 2. One of your clients approaches you to get your evaluation of an investment opportunity that was received through a Facebook post sent by a friend. The investment promises a monthly return in excess of 1% and claims that it is registered with an offshore regulatory body. You should explain to your client that A. These are reasonable expectations based on the investment and the location of the issuer. B. Your firm does not sell that security, and as a result, you cannot make any comments about the issue. C. It is important to check with the friend to find out more about the deal. D. These are red flags and are a clear warning to stay away from this investment. The answer is D. Unreasonably high returns and not being registered in the U.S. are 2 items on the list of red flag warnings to investors published by NASA. Question 3. The regulatory bodies consider which of the following social media sites to be predominantly used for business rather than personal communications. A. Facebook. B. Instagram. C. LinkedIn. D. Twitter. The answer is C. LinkedIn is most commonly viewed as a tool for business rather than personal communication. Question 4. The marketing director of Antifraud Securities, Inc., a broker-dealer registered in states A, B, and C, notices an article in a major trade journal that shows ASI in a favorable light. Out of the 500 brokerage firms covered in the article, Antifraud Securities, Inc. had the 3rd fewest customer complaints over the past year. If the marketing director were to post that on ASI website, it would be A. Adoption, B. Appropriation, C. Entanglement, D. Plagiarism. The answer is A. When a securities professional uses material created by an unrelated third party on social media, it has been adopted. If the firm or one of its associated persons had a hand in the preparation or funding of the material, it is entanglement. Question 5. Which of the following is not a factor when a communication to be distributed to the public is either being reviewed or approved by the broker-dealer? A. Whether statements of benefits are balanced with statements of potential risks. B. The nature of the audience to which the communication is intended to be distributed. C. Whether the piece will be distributed in written form or on the firm's website. D. Whether the communication is targeting existing customers or prospective ones. The answer is C. The format is not what counts. It is the content that matters.
Unit 7. Ethical Practices and Obligations. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 7A recognize fraudulent activity as defined in the Uniform Securities Act. Learning Objective 7B identify the important ethical considerations when providing brokerage services. Learning Objective 7C identify the important ethical considerations and fiduciary responsibilities when providing advisory services. Learning Objective 7D identify trading and compensation restrictions placed on investment advisors. Learning Objective 7E recall the potential conflicts of interest. Learning Objective 7F identify the requirements when selling securities on the premises of financial institutions. Introduction. The Uniform Securities Act was drafted for two primary reasons: to eliminate conflicts in state securities legislation and make state securities laws uniform, and to protect the public from unethical securities practices and fraud. Understanding ethical practices and securities professionals' obligations to follow them is the subject of this unit. This unit addresses what constitutes unethical and prohibited business practices, as defined in the Statement of Policy on Dishonest or Unethical Business Practices of Broker-Dealers and Agents issued by NASA, the North American Securities Administrators Association, as well as what are considered fraudulent practices under securities laws. The questions about investment advisors will relate to the NASA Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors. Fraudulent, dishonest, and unethical practices are very heavily tested topics. They make up 25% of the exam. You must know what these practices are and be able to apply the principles that guide ethical behavior to specific situations presented in the exam. The Series 63 exam will include 12 questions on the material presented in this unit. Lesson 7.1, the Antifraud Provisions of the Uniform Securities Act. Learning Objective 7A recognize fraudulent activity as defined in the Uniform Securities Act. Fraudulent activity may occur when conducting securities sales or when providing investment advice. In general, fraud means the deliberate or willful attempt to deceive someone for profit or gain. As mentioned in previous units, if it is a security, exempt or not, it is covered under the USA Antifraud provisions. However, these provisions apply only to securities. Therefore, if the inappropriate activity occurs during the offer or sale or rendering of advice relating to something that is not a security, these antifraud provisions do not apply. Fraudulent practices. Although there is a legal difference between a fraudulent practice and one that is unethical or prohibited, it is highly unlikely that you will have to know that for the exam. About the only significant testable concern is that you can go to jail for committing fraud, a criminal offense, while the punishment for engaging in a practice that is prohibited or unethical is generally limited to a fine, suspension, or revocation. Most of the exam will deal with practices that are unethical, but let's point out what the Uniform Securities Act considers fraud. State securities laws modeled on the USA address fraud by making it unlawful for any person, when engaged in the offer, sale, or purchase of any security, directly or indirectly to employ any device, scheme, or artifice to defraud, make any untrue statement of a material fact, or omit to state a material fact necessary to make a statement not misleading, or engage in any act, practice, or course of business that operates as a fraud or deceit on a person. Test topic alert. The law defines material as information used by a prospective purchaser to make an informed investment decision. Omitting a material fact or misstatement of such would be considered fraudulent behavior. Take note, as long as it involves a security, there are no exceptions to the anti-fraud provisions of state securities laws. They pertain to any person or transaction, whether the person or transaction is registered, exempt, or federal covered. Prevention of fraud is one of the few areas of securities law over which the states have full authority to act. The following is a list of the fraudulent acts most likely to be tested on your exam. Misleading or untrue statements. The willful act of telling a lie or making a misleading statement in connection with the offer or sale of a security is considered fraudulent activity. The following are some examples of acting in a fraudulent manner. Inaccurate market quotations. Telling a client a stock is up when the reverse is true is obviously an improper action. However, it would not be considered fraud if the inaccuracy resulted from a malfunction of the quote machine or an unintended clerical error. To be considered fraud, the action must be deliberate. Misstatements of an issuer's earnings or projected earnings or dividends. telling a client that earnings are up, or that the dividend will be increased when that is not the case is a fraudulent practice. However, it would not be fraud if you were quoting a published news release that was incorrect. Inaccurate statements regarding the amount of commissions, markup, or markdown. There are circumstances, such as a thinly traded security, where the amount of commission or markup may be higher than normal. That is permissible as long as it is disclosed properly in advance of the trade. However, telling a client that it costs him nothing to trade with your firm because you never charge a commission and not informing him that all trades are done on a principal basis with a markup or markdown is fraud. Test topic alert. It is important to understand that, other than in the above circumstance of a thinly traded security where commissions may be higher than normal, a broker-dealer is not obligated to disclose the amount of commission on any offer to sell before the transaction. However, commissions are always required to be disclosed on the trade confirmation. Test topic alert. You might see a question where you have to know that it could be considered fraudulent activity for an agent or IR to use social media, i.e., posting a tweet, to make a false announcement about a company in order to affect the stock price, stating or implying that the agent has inside information when that is not the case, as we will see shortly. The use of material non-public inside, MNPI, information is a fraudulent practice. But what about the agent who attempts to boost her credibility to clients by implying that what she is about to tell them is inside information, and once released, will have a major impact on the stock? Because it isn't true, she isn't acting on inside information, but she is still guilty of making untrue statements. Telling a customer that a security will be listed on an exchange without concrete information concerning its listing status, making any statement relating to a change in marketplace for the security is only permitted if, in fact, you have knowledge that such change has been announced. Informing a client that the registration of a security with the SEC or with the state securities administrator means that the security has been approved by these regulators. Registration never implies approval. Misrepresenting the status of customer accounts. This behavior is fraudulent. Many people are not motivated to pay strict attention to their monthly account statements, making it relatively easy for an unscrupulous agent to fraudulently claim increasing values in the account when the opposite is true. Doing so would be a fraudulent action. Promising a customer services without any intent to perform them or without being properly qualified to perform them. You say, "Yes, I can," to your client, even if you know you cannot deliver. For instance, the client asks you to analyze his bond portfolio to determine the average duration. Even though you do not know how to do that, you agree to do so. Under the USA, you have committed fraud. Representing to customers that the administrator approves of the broker-dealer's or agent's abilities. This is another case of using the word approve improperly. A broker-dealer or agent is registered, not approved. Test topic alert. Merely learning the terms is not enough to get you through the exam. On the exam, you must be able to identify situations in which the above violations occur, be able to apply the concepts of fraud and unethical behavior to scenarios that are likely to occur in everyday business. Example, here is a case when an agent made multiple statements that were improper. An agent contacts a client with the news that the largest holding in her portfolio has been approved for listing on the NYSE and will begin trading on that market in 1 week. The effect of the listing should be a noticeable appreciation in the stock's price. While on the topic, the agent exaggerates the company's earnings by $1 per share to make the client more receptive to the suggestion that she increase the size of her position. A final statement is made that the broker-dealer will be saving her money by not charging any commission on the trade because they already have the stock in inventory. If you were to see a question like this on your exam, what would you find to be wrong with this agent's actions? There is nothing wrong with telling a client that a stock has been approved for listing on the NYSE when that is true, but it is misleading to imply that the listing will have an impact on the stock's market price. Furthermore, there is never a time when earnings can be misstated. That is fraudulent behavior. Finally, implying that the purchase will be free of transaction costs is a problem because sales out of inventory carry a markup rather than a commission. Failure to state material facts. The USA does not require an agent to provide all information about an investment, but only information that is material to making an informed investment decision. However, the agent must not fail to mention material information that could affect the price of the security. In addition, the agent may not state facts that in and of themselves are true, but, as a result of deliberately omitting other facts, render the recommendation misleading under the circumstances. It is the agent's responsibility to determine what is material. Test topic alert. Full disclosure also applies when filling out an order to purchase or sell securities, referred to as a trade ticket or order ticket. Each order ticket must disclose the account ID, a description of the security, including the number of shares if a stock and total par value if a bond, the terms and conditions of the order, market or limit, the time of order entry and execution, the execution price, and the identity of the agent who accepted the order or is responsible for the account. We do not need the client's name or address on the order ticket. Using inside information. Making recommendations on the basis of material inside information about an issuer or its securities is prohibited. Should an agent come into possession of inside information, the agent must report the possession of the information to a supervisor or compliance officer. Take note, as defined in securities law, material non-public inside information, MNPI, is any information about a company that has not been communicated to the general public and that would likely affect the value of a security. Generally, but not exclusively, this information comes from officers or other insiders of the issuer who have access to financial or other relevant records. Your firm's internally generated research report on a company could also be considered MNPI if it was likely that release of the report would impact the market price of the stock. Even if you acquire the information accidentally, you cannot use it until it becomes public. Test topic alert. The exam may ask you to identify who is guilty of insider trading violations, a corporate officer of the issuer who divulges material inside information to a friend, but no transaction takes place, or an agent who executes a trade for a client who is acting on inside information. Simply giving someone inside information, although imprudent, is not a violation of the law. Only when the information is used for trading does a violation occur. In this question, the agent is in violation for accepting an order on the basis of material non-public information that results in a trade. Example, using inside information. Because the potential rewards are so great, this is one of the most commonly violated rules by both investors and securities professionals. Some go to extreme lengths to try to hide the activity in an effort to make it difficult to uncover. As an example of the type of returns that can be made, Mr. H, a convenience store employee, has a sister whose boyfriend worked for a company that was about to be bought out by another company. The boyfriend mentioned that to the sister who told her brother. The day before the announcement was made public, Mr. H took his life savings of $8,000 and invested in that company. The next day, after the announcement and the jump in price, he sold and reaped a profit of over $295,000, almost 37 times his investment in one trading day. Yes, he was caught, which is how we know the story, and had to return his profits and then some interest. Another case involved getting access to a law firm's computer. The law firm specialized in mergers and acquisitions, and those with access were able to learn of upcoming takeover bids being made at prices significantly higher than the current trading price. To avoid being noticed, the trades were placed through the account of one of the participants' mother who was based in China. Total penalties in this case were almost $6 million plus interest of about $125,000. In our first example, Mr. H wasn't looking for the information, but when it came his way, he used it. In the second example, the perpetrators hacked into the computers with malice aforethought. Practice question. Which of the following employees of a publicly traded company would most likely have access to MNPI? A. VP of Human Resources. B. Receptionist. C. Chief Financial Officer, CFO. D. VP of Marketing. The answer is C, although any of these employees could obtain access to MNPI, because the CFO is the individual who sees the financial numbers. First, it is part of the job to have access to earnings numbers before anyone else. Market manipulation. Market manipulation is affecting any transaction in or inducing the purchase or sale of any security by means of any manipulative, deceptive, or fraudulent device, practice, plan, program, design, or contrivance. Securities legislation is designed to uphold the integrity of markets and transactions in securities. However, market integrity is violated when transactions misrepresent actual securities prices or market activity. The most common forms of market manipulation are matched orders and wash trades. Matched orders occur when market participants agree to buy and sell securities among themselves to create the appearance of activity or trading in a security. Increased volume in a security can induce unsuspecting investors to purchase the security, thereby bidding up the price. As the price rises, participants who initiated the matched orders sell their securities at a profit. A wash trade is an attempt to manipulate a security's price by creating an apparent interest in the security that really does not exist. This is done by an investor buying in one brokerage account and simultaneously selling through another. No beneficial change in ownership has occurred because the buyer and seller are the same person, but to the marketplace, it appears that volume or price is increasing. Take note. Arbitrage is the simultaneous buying and selling of the same security in different markets to take advantage of different prices. It is not a form of market manipulation and is legal. Simultaneously buying a security in one market and selling it in another forces prices to converge and therefore provides uniform prices for the general public. Test topic alert. Although matched orders and wash trades are the two most common examples of market manipulation on the exam, there are other ways in which broker-dealers and their agents can deceive clients through unethical business practices, such as disseminating false trading information, front-running, and withholding shares of an IPO, explained in the next lesson. Knowledge Check 7.1. Question 1. If a person who is not a registered securities professional makes a false statement of material fact in connection with the sale of a security, that person A. has violated the antifraud provisions of the Uniform Securities Act. B. is not covered by the Uniform Securities Act. C. has not violated the Uniform Securities Act if the sale was made to broker-dealer. D. could be arrested by the administrator. The answer is A. The Uniform Securities Act makes it illegal for any person to commit a fraudulent act in connection with the sale or offer for sale of a security, not just agents and broker-dealers. The administrator does not have the power to arrest anyone. He may bring the case to the attention of the Attorney General of the state, who can issue a warrant for the arrest. Question 2. Which of the following statements regarding the anti-fraud provisions of the Uniform Securities Act is true? A. No securities are exempt from the anti-fraud provisions of the Act. B. Exempt securities are not subject to the anti-fraud provisions of the Uniform Securities Act. C. The only securities exempt from the provisions are those issued by national governments or political subdivisions of countries that maintain diplomatic relations with the United States. D. The only securities exempt from the provisions are those that are properly registered under blue sky laws. The answer is A. Neither exempt nor non-exempt securities or registered securities are ever exempt from the USA anti-fraud provisions. Question 3. An agent of a broker-dealer registered in this state would be exempt from the antifraud provisions of the Uniform Securities Act if committing fraud in the sale of A. Whole life insurance, B. An exempt security, C. A non-exempt security, D. An exempt security in an exempt transaction. The answer is A. The anti-fraud statutes of the USA apply only to securities exempt or not. Whole life insurance is not a security. However, the sale would likely be subject to the anti-fraud provisions of the State Insurance Code. Question 4. A federal credit union is issuing participation units in this state. Which of the following statements relating to the Uniform Securities Act is true? A. The issue is subject to the anti-fraud provisions of the Act. B. Any advertisement for the issue must be filed with the administrator. C. Registration may be done by qualification. D. This is a federal covered security. The answer is A. Even though interests in a federal credit union are exempt securities, the exemption does not apply to the anti-fraud provisions of the Act. As exempt securities, the issuer does not file advertisements or register. The federal and federal credit union does not mean the issue is a federal covered security. Lesson 7.2. Ethical Behavior of Broker-Dealers and Their Agents. Learning Objective 7b, identify the important ethical considerations when providing brokerage services. Dishonest or unethical business practices of broker-dealers and agents. In 1983, NASA released a Statement of Policy on Dishonest or Unethical Practices of Broker-Dealers and Agents, SOP, enumerating a large number of business practices that, when engaged in by broker-dealers or agents, they deemed dishonest or unethical. Subsequently, they have issued several model rules that have expanded the list. Most students report seeing a large number of questions on their Series 63 exam that are drawn from the following material, especially those relating uniquely to agents. In most cases, the listed prohibition is logical common sense: don't lie, don't cheat, and don't steal. However, due to the nature of this exam and its legal interpretations, particularly for those of you without a securities or law background, further explanations will be supplied. The premise of the policy is that all broker-dealers and agents should observe high standards of commercial honor and just and equitable principles of trade in the conduct of their business. Acts and practices, including but not limited to those enumerated below, are considered contrary to such standards and may constitute grounds for denial, suspension, or revocation of registration, or such other action authorized by the Uniform Securities Act. As mentioned previously, NASA does not have a separate principal registration as does FINRA. The highest-ranking supervisory individual in the broker-dealer takes the Series 63, just like the newest trainee. That is why the course covers material that seems outside the job description of a sales agent. We are going to begin this list with those practices limited to broker-dealers. Then we'll list those applying to both BDs and agents. The final listing will be those for agents only. The majority of the test questions on this topic will come from the second and third list. Unethical practices solely related to broker-dealers. Delivery delays. Engaging in a pattern of unreasonable and unjustifiable delays in the delivery of securities purchased by any of its customers or in the payment upon request of free credit balances reflecting completed transactions of any of its customers. A free credit balance is just like a credit balance on your charge card. It is your money and must be sent to you upon request. In the event that the client requests a certificate for the security purchased, it would be considered an unethical business practice for the firm to delay delivering it to the client. Commingling of customer and firm assets. Failing to segregate customers' free securities or securities held in safekeeping. Customers' free securities are those which have no lien against them, unlike those which have been pledged in a margin account, just like you might have a lien against your car. These free securities that are held in a customer's name must not be commingled, mixed, with securities of the firm. Example: if a firm has 100,000 shares of ABC common stock in its own proprietary account and its clients separately own an additional 100,000 shares, the firm may not place customer shares in the firm's proprietary account. Mixing shares together could jeopardize the security of client securities in the event of default. Improper hypothecation: hypothecating a customer's securities without having a lien thereon, unless the broker-dealer secures from the customer the signed hypothecation agreement promptly after the initial transaction. There are strict rules to be followed, the details of which will not be tested. Unreasonable servicing fees: charging unreasonable and inequitable fees for services performed, including miscellaneous services such as collection of monies due for principal, dividends or interest, exchange or transfer of securities, appraisals, safekeeping, custody of securities, and other services related to its securities business. NASA recognizes that not all broker-dealers offer the same level of services, and that those who offer a large array of services to their clients may charge more without it being considered an unethical business practice. As discussed in the previous unit, these fees must be disclosed. Dishonoring quotes: offering to buy from or sell to any person any security at a stated price, unless such broker-dealer is prepared to purchase or sell, as the case may be, at such price and under such conditions as are stated at the time of such offer to buy or sell. In other words, if a broker-dealer quotes a stock at $20.60 to $20.75, it had better be ready to sell at least the minimum trading unit, usually 100 shares, to a client at $20.75 per share, its ask or offering price, or buy from a client at $20.60, its bid price. Withholding shares of a public offering: failing to make a bona fide public offering of all of the securities allotted to a broker-dealer for distribution, whether acquired as an underwriter, a selling group member, or from a member participating in the distribution as an underwriter or selling group member. If the firm is fortunate to be part of the underwriting of one of these IPO that rockets in price because the issue is oversubscribed, they had better be sure to allocate the shares to clients in an equitable manner and not keep any for themselves. Agreeing to waivers: waiving compliance with the rules. The Uniform Securities Act makes it clear that any condition, stipulation, or provision binding any person acquiring any security or receiving any investment advice to waive compliance with any provision of the Act or any rule or order hereunder is void. For exam purposes, if you are given a question where clients agree to waive their rights to sue, the agreement is null and void. Unethical practices related to broker-dealers and agents: unreasonable commissions or markups, entering into a transaction with or for a customer at a price not reasonably related to the current market price of the security, or receiving an unreasonable commission or profit. There is one way that a broker-dealer might make a very large profit, and it would not be considered unreasonable. When acting in a dealer or principal capacity, broker-dealers sell out of inventory. What would be the situation if a firm bought some securities for their inventory and several months later the value of those securities had doubled or tripled? What would be a fair price to charge customers? The rules make it clear that quotes are always based on the current market, so, in this case, the broker-dealer would make a substantial profit. By the way, this goes both ways. If the firm had stock in inventory that decreased greatly in value, the firm would not be able to pass on any of the loss to clients. Any sales would take place based on the current depressed market prices. Higher than normal commissions. In some cases, a particular transaction may involve more expense to the broker-dealers, particularly in a thinly traded security. Those are securities with little trading activity that could justify a charge that is higher than normal. Acting ethically, this higher charge must be disclosed to clients in advance of the trade. If not, a violation of the ethics canon has occurred. Churning. inducing trading in a customer's account that is excessive in size or frequency in view of the financial resources, objectives, and character of the account. A key here is the word excessive. By definition, anytime something is excessive, it is too much. The regulators understand that different clients have different needs and ability to take risks, so what is excessive for the 80-year-old pensioner is probably not going to be so for the 40-year-old partner in a major law firm. Churning seems to appear on the exam with high frequency. Unsuitable recommendations. Recommending to a customer the purchase, sale, or exchange of any security without grounds to believe that such transaction or recommendation is suitable for the customer, based upon reasonable inquiry concerning the customer's investment objectives, financial situation and needs, and any other relevant information known by the broker-dealer or agent. Agents must always have reasonable grounds for making recommendations to clients. Before making recommendations, the agent must inquire into the client's financial status, investment objectives, and ability to assume financial risk. What about the client who refuses to give any financial information or discuss objectives? In that case, all the agent can do is accept unsolicited orders because there is no basis for making any recommendation. The following practices violate the suitability requirements under the USA, as well as the rules of fair practice that regulatory agencies have developed. A securities professional may not recommend securities transactions without regard to the customer's financial situation, needs, or investment objectives. Induce transactions solely to generate commissions, churning, defined as transactions in customer accounts that are excessive in size or frequency in relation to the client's financial resources, objectives, or the character of the account. Recommend a security without reasonable grounds. Fail to sufficiently describe the important facts and risks concerning a transaction or security, and make blanket recommendations. Take note. What would be considered a blanket recommendation? It will almost always be unsuitable if the same security is recommended to the majority of your clients. How could all of them have the same needs? Some are looking for income, some for growth, and some for safety, and no one security can provide all three. Take note. What do you do when you think you've made a totally appropriate recommendation to your client, but your client is not happy with it? Upon reflection, you realize the client's problem is a lack of understanding of both the recommendation and the marketplace. What should you do? Most would agree that the first step would be to attempt to impart some education to the client in an effort to make your recommendation clearer. However, as with all customer issues, the customer is the one who has to make the final decision. Free lunch seminars. Although not specifically included in the NASA Statement of Policy, recent rules regarding unfair business practices, especially with regard to seniors, may be included on your exam. A common instance is the so-called free lunch seminar. These seminars are widely offered by financial services firms seeking to sell financial products, and they often include a free meal for attendees. Even though many of these seminars are promoted as being educational workshops accompanied by the statement, "Nothing will be sold at this meeting," the seminars are clearly intended to result in the attendees opening new accounts with the sponsoring firm. The goal is the sale of investment products, if not at the seminar itself, then in follow-up contacts with the attendees. If not clearly presented, NASA will consider both the sponsoring firm and those agents involved in the delivery of the seminar to be committing an unethical or prohibited business practice. Unauthorized transactions. Executing a transaction on behalf of a customer without authorization to do so. Unless discretionary authorization, see following, has been received. Broker-dealers and their agents may never enter an order for a client on their own volition, even when it is in the best interest of the client. You may be asked a question where a spouse of a client or other person with a strong personal relationship contacts the agent with transaction instructions, allegedly on behalf of the client. Unless there is a written third-party trading authorization on file, no activity can take place. Somewhat related to this activity is deliberately failing to follow a customer's instructions. In this case, the client is given the terms of the order, and if the agent decides to purchase more or less than ordered, or in any other way change the nature of the order, it is a prohibited practice. Third-party trading. Placing an order to purchase or sell a security for the account of a client upon instruction of a third party without first having obtained a written third-party trading authorization from the client. It is sound business practice for a broker-dealer or an agent not to place an order for the account of a customer on instruction of a third party without first knowing that the third party has obtained authority from the customer for the order. For example, it would be important for an agent to know that a lawyer had power of attorney over an estate whose account the agent was managing prior to placing any order on instruction of the lawyer. Placing orders under such circumstances could result in substantial civil liability, besides being an unethical practice. Exercising discretion. Exercising any discretionary power in effecting a transaction for a customer's account without first obtaining written discretionary authority from the customer, unless the discretionary power relates solely to the time or price for the executing of orders. We will go into more detail on discretionary accounts at Learning Objective 8A Margin Documents. Executing any transaction in a margin account without securing from the customer a properly executed written margin account agreement promptly after the initial transaction in the account. Timely prospectus delivery. Failing to furnish to a customer purchasing securities in an offering no later than the due date of confirmation of the transaction, either a final prospectus or a preliminary prospectus. Here is further detail from the Uniform Securities Act that might answer a question on the exam. The administrator may require that a prospectus for a security registered under qualification be sent or given to each person to whom an offer is made prior to the sale of the security rather than no later than the due date of the confirmation. Guaranteeing against loss. Guaranteeing a customer against loss in any securities account of such customer carried by the broker-dealer or in any securities transaction effected by the broker-dealer with or for such customer. This was covered at Learning Objective 6D, but it doesn't hurt to see it again. Securities professionals may not guarantee a certain performance, nor may they guarantee against a loss by providing funds to the account. One common example of this on the exam is when an agent is so sure that a stock's price will go up, he offers to buy it back from the client at a price higher than the original sale price. Test topic alert. The term guaranteed under the USA means guaranteed as to payment of principal, interest, or dividends. It is allowable to refer to a guaranteed security when an entity other than the issuer is making the guarantee. However, the regulatory agencies of the securities industry prohibit securities professionals from guaranteeing the performance returns of an investment or portfolio. Disseminating false trading information, publishing or circulating, or causing to be published or circulated any notice, circular, advertisement, newspaper article, investment service, or communication of any kind which purports to report any transaction as a purchase or sale of any security, unless such broker-dealer believes that such transaction was a bona fide purchase or sale of such security, or which purports to quote the bid price or asked price for any security, unless such broker-dealer believes that such quotation represents a bona fide bid for or offer of such security. This would be considered a form of market manipulation. Deceptive advertising practices. Using any advertising or sales presentation in such a fashion as to be deceptive or misleading. An example of such practice would be a distribution of any non-factual data, material, or presentation based on conjecture, unfounded or unrealistic claims or assertions in any brochure, flyer, or display by words, pictures, or graphs, or anything otherwise designed to supplement, detract from, supersede, or defeat the purpose or effect of any prospectus or disclosure. A common test example is the use of a sales brochure accompanying a prospectus that omits certain material information. The brochure is easier to read than the prospectus, and the investor can be misled. Failing to disclose conflicts of interest. Failing to disclose that the broker-dealer is controlled by, controlling, affiliated with, or under common control with the issuer of any security before entering into any contract with or for a customer for the purchase or sale of such security. If such disclosure is not made in writing, it must be supplemented by the giving or sending of written disclosure at or before the completion of the transaction. One of the most common examples of a conflict of interest that must be disclosed is when the agent is offering a proprietary product, such as a house fund, a mutual fund where the underwriter or advisor is affiliated with the broker-dealer, or a limited partnership offering, DPP, where the sponsor is an affiliate of the broker-dealer. At Learning Objective 7E, there are more examples of potential conflicts of interest. Responding to complaints, failure or refusal to furnish a customer, upon reasonable request, information to which he is entitled, or to respond to a formal written request or complaint. When a written complaint is received by the firm and only written complaints are recognized, action must be taken. The complainant, customer, would be notified that the complaint had been received and an entry would be made in the firm's complaint file. If an agent were the subject of the complaint, the agent would be notified, but would not be given a copy of the complaint. Agents do not have record-keeping requirements. If the complaint is received by the agent rather than the firm, the agent must report the complaint to the appropriate supervisor. If the complaint is sent by email, that is considered in writing. Reporting errors. In order to keep from generating complaints, any trade or other operational error, once discovered, must be reported by the agent to the appropriate supervisory person. Front-running. Engaging in front-running. Front-running is the unethical business practice of a broker-dealer or one of its agents, placing a personal order ahead of a previously received customer order. It occurs most frequently when the firm has received an institutional order of sufficient size to move the market, generally referred to as a block order. By running in front of the order, the firm or representative can profit on that movement. Example: in the industry, the term generally used is front-running of block transactions. FINRA, in their Rule 5270, defines front-running of blocks as no broker-dealer or associated person of that broker-dealer shall cause to be executed an order to buy or sell a security when such person causing such order to be executed has material, non-public market information concerning an imminent block transaction in that security prior to the time information concerning the block transaction has been made publicly available or has otherwise become stale or obsolete. Because of the size of block transactions, generally a minimum of 10,000 shares, their execution can potentially cause large movements in the market price of the stock. Getting in ahead of that jump, or out ahead of the drop if a block sale, can lead to earning profits in an unethical and prohibited manner. For example, Paula, an agent with a large broker-dealer, has just received an order to purchase 20,000 shares of SDU common stock. In essence, Paula has information that the market does not know yet, and based on the average daily trading volume of SDU, knows that this order will cause a jump in SDU market price. Paula purchases 1,000 shares for her own account and then enters the block order. The execution of that large trade now causes SDU to trade $0.50 per share higher than when Paula bought hers. She immediately sells her shares and secures a profit of about $500 using this unethical business practice. Rumors. Spreading rumors about a security to affect the security's price. Any agent hearing a rumor must report it to the appropriate supervisor. Broker-dealers must ensure that rumors they become aware of are not spread or used in any way, particularly not as the basis for recommendations. Accurate records. backdating records for tax or other purposes. All records and documents must reflect their actual dates. Although there can be tax or other benefits to clients when their trade confirmations are backdated, it is an unethical business practice to do so. Lending and borrowing to or from customers. Engaging in the practice of lending to or borrowing money or securities from a customer. Securities professionals may not borrow money or securities from a client unless the client is a broker-dealer, an affiliate of the professional or a financial institution engaged in the business of loaning money. Securities professionals may not loan money to clients unless the firm is a broker-dealer or financial institution engaged in the business of loaning funds or the client is an affiliate. Test topic alert. One of the more confusing areas relates to borrowing money from or lending money to clients. Part of the reason for the confusion is that FINRA rules. Most students taking the Series 63 exam have taken a FINRA test, permit borrowing, lending to clients under certain conditions that are more liberal than those of NASA. This exam deals solely with the NASA policy. The first point to emphasize is that this prohibition only applies when the other side is a client. Securities professionals may borrow or lend as much as they want to those who are not clients, but once there is a client relationship, the NASA policy takes effect. So, which clients can you borrow from? A bank or other financial institution in the business of making loans, e.g., credit union. A broker-dealer in a margin account. A fellow employee of your firm or one affiliated with it. Which clients can't you borrow from? The employee at the lending institution who processes or approves your loan. The agent at the broker-dealer who services your margin account. A mortgage broker only arranges the loan. A family member, unless employed by the same or an affiliated firm. Practice question. Lending arrangements between registered agents and their customers are permitted if the customer A. is a member of the representative's immediate family. B. is the mortgage broker who arranged for the mortgage on your home. C. was your roommate in college and remains your best friend. D. works at the desk next to yours. The answer is D. The correct choice is a fellow employee of your firm. You can borrow from or lend to another employee of your firm. You can also borrow from clients who are in the money lending business. Remember, mortgage brokers don't lend the money. They put together the lender and the home buyer. If you'd like to borrow from an immediate family member, unless that individual works for the same or an affiliated firm, the only way to do that is to terminate the client relationship. Test topic alert. As a former president of the United States once said, "Let me make one thing perfectly clear. When it comes to borrowing or lending money, you cannot borrow from any client, including your mother, unless that client is a lending institution, such as a bank or credit union. Likewise, as an agent, you can never lend money to any client unless the client has some kind of affiliation with your firm. If your broker-dealer handles margin accounts, then, of course, money can be loaned to clients by the BD, but not by the agent. Don't take this personally. Just get the questions right on the exam. Unethical business practices involving investment company sales. In 1997, NASA adopted the NASA Statement of Policy titled Dishonest or Unethical Business Practices by Broker-Dealers and Agents in Connection with Investment Company Shares. Several of those items are currently being tested. Under this policy, any broker-dealer or agent who engages in one or more of the following practices shall be deemed to have engaged in dishonest or unethical practices in the securities business, as enumerated in the Uniform Securities Act, and such conduct may constitute grounds for denial, suspension, or revocation of registration, or such other action authorized by statute. Sales load communications. In connection with the solicitation of investment company shares, stating or implying to a customer that the shares are sold without a commission, are no load, or have no sales charge if there is associated with the purchase of the shares. Any front-end load. any contingent deferred sales load, CDSC, or a Rule 12b-1 fee or a service fee if such fees in total exceed 0.25% of average net fund assets per year. Breakpoints. In connection with the solicitation of investment company shares, failing to disclose to any customer any relevant sales charge discount on the purchase of shares in dollar amounts at or above a breakpoint, or letter of intent feature, if available, which will reduce the sales charges. Unfair comparisons. It is considered an unethical business practice to compare or in any way imply that money market mutual funds are similar to savings accounts at insured banks. Although generally quite safe, money market funds do not have FDIC insurance, and there is no guarantee that their principal will not fluctuate. Selling dividends. In connection with the solicitation of investment company shares, stating or implying to a customer that the purchase of such shares shortly before an ex-dividend date is advantageous to such customer unless there are specific, clearly described tax or other advantages to the customer, or a distribution of long-term capital gains by an investment company is part of the income yield from an investment in such shares. Share classes. Recommending to a customer the purchase of a specific class of investment company shares in connection with a multi-class sales charge or fee arrangement without reasonable grounds to believe that the sales charge or fee arrangement associated with such class of shares is suitable and appropriate based on the customer's investment objectives, financial situation and other securities holdings, and the associated transaction or other fees. Switching funds. Recommending to a customer the liquidation or redemption of investment company shares for the purpose of purchasing shares in a different investment company having similar investment objectives and policies, without reasonable grounds to believe that such recommendation is suitable and appropriate based on the customer's investment objectives, financial situation and other securities holdings, and any associated transaction charges or other fees. Unethical business practices solely related to agents. Selling away. Effecting securities transactions not recorded on the regular books or records of the broker-dealer that the agent represents, unless the transactions are authorized in writing by the broker-dealer prior to execution of the transaction. These are sometimes referred to as private securities transactions, not to be confused with a private placement. Example: the NASA policy on selling away is very simple. Agents wishing to sell a security without the transaction going through their broker-dealer can only do so if the transaction is authorized in writing by the BD prior to the trade being executed. How do violations occur? Certainly there are cases where the agent deliberately flaunts the rule, but in many instances it happens from ignorance of the rule. One of the most common examples on the exam is when the agent is approached by a friend who is raising money for a new enterprise and suggests that the agent might have some clients for whom this would be an appropriate investment. If the agent gets written authorization from the employing broker-dealer, this would be permitted, but if not, a violation has occurred. Many times the problem arises because the agent does not understand that the product being offered is a security. For example, agents are increasingly targeted by issuers, promoters, and marketers to sell short-term promissory notes to their customers. Although, in almost all instances, these notes are securities, promoters of these products are marketing them to registered persons as non-securities products that do not have to be sold through a broker-dealer by a registered person. In a significant number of cases, agents have sold these notes to their customers away from their firms and without prior firm approval as required. When in doubt, ask your supervisor. Here is how that might happen in real life and on the exam as well. Practice question. While at your Tuesday night bowling league, one of the team members introduces you to a friend of hers who is also in the financial business. This individual invites you out to lunch and describes a potential investment for your clients. The product is a promissory note that the issuer's lawyers insist is not a security, and you will be compensated nicely for any sales you make. You should A. Thank your bowling partner for making this great introduction. B. Start contacting clients for whom you believe this promissory note is a suitable investment. C. Buy some of the notes yourself first before recommending them to clients. D. Check with your supervisor to be sure you would not be violating the selling away rules. The answer is D. Maybe these promissory notes really aren't securities, but if they are and you offer them to clients without the consent of your firm, you are in violation. Furthermore, if they are securities and are not registered, you could be in big trouble. That is why you need to check with your supervisor is the correct answer. Test topic alert. The exam may refer to this as a trade made off the books of the broker-dealer. Just remember that it is considered a prohibited practice any time an agent effects securities transactions not recorded on the regular books or records of the broker-dealer the agent represents, unless the transactions are authorized in writing by the broker-dealer before execution of the transaction. Fictitious accounts. Establishing or maintaining an account containing fictitious information in order to execute transactions that would otherwise be prohibited. Examples of this kind of conduct sometimes given on the exam are beefing up a client's net worth to enable him to engage in margin or options trading, or making him appear to have more investment experience than is true. Sharing in accounts. Sharing directly or indirectly in profits or losses in the account of any customer without the written authorization of the customer and the broker-dealer that the agent represents. Agents cannot share in the profits or losses of client accounts unless the client and the broker-dealer supply prior written approval. The NASA policy differs from that of FINRA. Unlike the FINRA rule, it is unnecessary for the agent to make a financial contribution to the account. Test topic alert. Unlike agents, broker-dealers, investment advisors, and investment advisor representatives are never permitted to share in the profits or losses in their clients' accounts. Splitting commissions. Dividing or otherwise splitting the agent's commissions, profits, or other compensation from the purchase or sale of securities with any person not also registered as an agent for the same broker-dealer or for a broker-dealer under direct or indirect common control. Remember, your manager is always registered as an agent with your broker-dealer. It is not necessary to disclose to an agent's client that he is splitting commissions with another agent unless it increases the transaction cost to the client. Exploitation of vulnerable adults. Something that has not been tested as the date of printing is the NASA model legislation or regulation to protect vulnerable adults from financial exploitation. For those of you who have taken a FINRA exam, the rule is almost identical. For purposes of this rule, an eligible adult means a person 6 to 5 years of age or older, or a person subject to the state's Adult Protective Services statutes, generally anyone mentally or physically disabled age 18 or older. Should this appear in the future on a Series 63 exam, we expect the following information to be tested. A broker-dealer or investment advisor may delay a disbursement from an account of an eligible adult or an account on which an eligible adult is a beneficiary if the broker-dealer, investment advisor, or qualified individual reasonably believes, after initiating an internal review of the requested disbursement and the suspected financial exploitation, that the requested disbursement may result in financial exploitation of an eligible adult, and the broker-dealer or investment advisor, immediately but in no event more than 2 business days after the requested disbursement, provides written notification of the delay and the reason for the delay to all parties authorized to transact business on the account, unless any such party is reasonably believed to have engaged in suspected or attempted financial exploitation of the eligible adult, immediately but in no event more than 2 business days after the requested disbursement, notifies the relevant state agencies, and continues its internal review of the suspected or attempted financial exploitation of the eligible adult as necessary and reports the investigation's results to the agencies within 7 business days after the requested disbursement. Any delay of a disbursement as authorized by this section will expire upon the sooner of a determination by the broker-dealer or investment advisor that the disbursement will not result in financial exploitation of the eligible adult, or 15 business days after the date on which the broker-dealer or investment advisor first delayed disbursement of the funds, unless either of the agencies requests that the broker-dealer or investment advisor extend the delay, in which case the delay shall expire no more than 25 business days after the date on which the broker-dealer or investment advisor first delayed disbursement of the funds, unless sooner terminated by either of the agencies or an order of a court of competent jurisdiction. A court of competent jurisdiction may enter an order extending the delay of the disbursement of funds or may order other protective relief based on the petition of the administrator, Adult Protective Services, the broker-dealer or investment advisor that initiated the delay under this rule, or other interested party. Knowledge Check 7.2. Question 1. Your customer called to check on her account value at 9:00 a.m. You were unavailable at the time. It is now 2:00 p.m. and you are able to call her back. Between 9:00 a.m. and 2:00 p.m., her account value dropped from $11,500 to $10,000. What should you say to her? A. At the time you called, your account had a value of $10,000. B. Your account value cannot be determined until the market closes. C. Your account is valued at $10,000 at this time. T. Your account was down to $9,700 earlier today, but is now up to $10,000. The answer is C. You must always tell the truth. All of the other choices are clearly a misrepresentation of account status. Question 2. All of the following are prohibited practices under the Uniform Securities Act except A. Borrowing money or securities from the account of a former banker with express written permission. B. Failing to identify a customer's financial objectives. C. Selling unregistered non-exempt securities to a closed-end investment company. D. Supplying funds to a client's account only when or if it declines below a previously agreed-upon level. The answer is C. It is permissible to sell unregistered, non-exempt securities to an institutional buyer, such as an investment company, because that would be an exempt transaction. Borrowing money or securities from other than a bank or broker-dealer in the business of lending, failing to identify a customer's financial objectives, and guaranteeing a customer's account against losses are all prohibited practices. Question 3. A customer is upset with her agent for not servicing her account properly and sends him a complaint letter about his actions. Under the Uniform Securities Act, the agent should A. Call the customer, apologize, and attempt to correct the problem. B. Tell the customer he is willing to make rescission. C. Do nothing. D. Bring the customer complaint to his employer immediately. The answer is D. Failure to bring customers' written complaints to the attention of the agent's broker-dealer is prohibited. Question 4. In which of the following cases is an agent not considered to have acted in a prohibited or unethical manner? A. The agent borrows money from his wealthy client's accounts with their written consent. B. The agent solicits orders for non-exempt, unregistered securities from institutional clients. C. The agent buys and sells securities in accounts to generate a high level of commissions. D. The agent alters market quotations to induce a client to invest in an attractive growth stock. The answer is B. Transactions with institutions are exempt. Even a non-exempt security is excused from registering with the state when the transaction is exempt. An agent can only borrow money from a client who is in the money-lending business or an affiliate of the broker-dealer. Trading an account for the purpose of generating commissions is the prohibited action known as churning, and it would never be permitted to alter market quotations. Question 5. A broker-dealer informs a client that it does not intend to abide by all the provisions of the Uniform Securities Act because that limits the firm's ability to generate profits in the client's account. The client willingly signs a waiver that specifically prohibits her from entering a suit against the firm. The client's signature is properly witnessed and notarized. How would the administrator view this agreement? A. Because the client signed the agreement, a suit against the firm will have no legal standing. B. The client will only be able to sue in the case of fraud. C. Clients cannot waive their legal rights. D. This waiver is only effective if a copy is filed and registered with the administrator. The answer is C. There is no case where a waiver of rights is acceptable on the exam. Question 6. Under the NASA Statement of Policy on Dishonest or Unethical Business Practices of Broker-Dealers and Agents, it would be considered a dishonest or unethical practice for an agent to A. Have a history of repeatedly delaying the delivery of securities to his customers. B. Fail to maintain the required net capital. C. Have retail customers who live in the state but fail to register with the administrator. D. Fail to inform customers that past performance is no guarantee of future results. The answer is D. Stating or implying in any way that past performance is a predictor of future results is an unethical business practice. Failing to let customers know that is against the policy. It is broker-dealers who are prohibited from delaying delivery of securities to customers. Delivering securities is a function that is beyond the responsibility of agents. The only possible financial obligation of an agent is a surety bond when exercising discretion. Net capital is solely for broker-dealers. If an agent has even one retail client who lives in a state, registration in that state is required. Unlike investment advisor representatives, there is no de minimis exception. However, that is not a dishonest or unethical business practice. It is a violation of the Uniform Securities Act. Question 7. Under the NASA Statement of Policy on Dishonest or Unethical Business Practices of Broker-Dealers and Agents, an agent could not A. Purchase a security for her own account after recommending it to several of her customers. B. Lend money to a customer with written consent of the customer and the employing broker-dealer. C. Borrow money from her father who is not in the lending business and is not a customer of the broker-dealer. D. Post on her Facebook page that she passed the Series 63 examination with the help of the Kaplan course. The answer is B. The NASA policy on lending money to customers essentially prohibits an agent from ever engaging in the practice. Loans to customer can only be made by those in the money lending business, and that could only be the broker-dealer lending money for margin accounts, never an agent. However, there are no restrictions on lending or borrowing if the transaction is with a non-customer, such as the father in our question. It is not uncommon for agents to put their money where their mouth is and purchase securities recommended to customers. The problem is when the agent purchases first and then touts the stock. We would be pleased if you post to your social media accounts that Kaplan's course helped you reach success on the exam. There is nothing prohibited about that. Lesson 7.3 Ethical Behavior of Investment Advisors and Their Representatives. Learning Objective 7C, identify the important ethical considerations and fiduciary responsibilities when providing advisory services. Unethical business practices of investment advisors. The fraudulent and prohibited practices described in the previous section relate to the sale of securities and apply primarily to broker-dealers and agents. The Uniform Securities Act also prohibits fraudulent and unethical activities by persons providing investment advice. The USA makes it unlawful for any person who receives compensation directly or indirectly, for advising another person, whether through analyses or reports, on the value of securities to use any device, scheme, or artifice to defraud the other person. Additionally, that person may not engage in any act, practice, or course of business that operates or would operate as fraud or deceit upon the other person or engage in dishonest or unethical practices as the administrator may define by rule. We will review a few of the practices deemed unethical for those giving investment advice. The source of these is the NASA Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors. You will notice some overlap with the unethical practices previously covered for broker-dealers and agents. Suitability of recommendations. Recommending to a client to whom investment advice is provided the purchase, sale, or exchange of any security without reasonable grounds to believe that the recommendation is suitable for the client, on the basis of information furnished by the client after reasonable inquiry concerning the client's investment objectives, financial situation and needs, and any other information known by the investment advisor, is an unethical business practice. Because investment advisors have a fiduciary responsibility to their clients, even more than a broker-dealer or agent, an investment advisor, or IR, has a fundamental obligation to analyze a client's financial situation and needs prior to making any recommendation to the client. The fiduciary relationship means that the client's interest must always come first. By failing to make reasonable inquiry or by failing to make recommendations that are in line with the financial situation, investment objectives, and character of a client's account, an investment advisor has not met its fiduciary responsibility. We will come back to this topic in just a bit. Misrepresenting qualifications. It is unethical to misrepresent to any advisory client or prospective advisory client the qualifications of the investment advisor or any employee of the investment advisor, or to misrepresent the nature of the advisory services being offered or fees to be charged for such service, or to omit to state a material fact regarding qualifications, services, or fees. When an investment advisor offers its services to a prospective client, or when providing services to an existing client, the qualifications of the investment advisor or any employee of the investment advisor and the nature of the advisory services and the fees to be charged must be disclosed in such a way as to not mislead. Overstating the qualifications of the investment advisor or disclosing inaccurately the nature of the advisory services to be provided or fees to be charged are not ethical ways to either acquire or retain clients. Example: an investment advisor representative cannot claim to possess an advanced designation, such as Certified Financial Planner, CFPR, or Chartered Financial Analyst, CFAR, unless the individual has the designation. Unreasonable advisory fees. Investment advisors cannot charge a client an unreasonable advisory fee. This rule is intended to prohibit an investment advisor from charging an excessively high advisory fee. Unreasonable, as used in this rule, means unreasonable in relation to fees charged by other advisors for similar services. Although no two advisory services are exactly alike, comparisons can be drawn. In those instances where an advisory fee is out of line with fees charged by other advisors providing essentially the same services, an investment advisor should justify the charge. It would be very difficult for a client to compare various advisory services to evaluate those services and the fees charged. This rule will allow state administrators to research the competitiveness of an advisor's services and fees to make a determination as to whether the fees being charged are unreasonably high. Unauthorized disclosures. Disclosing the identity, affairs, or investments of any client unless required by law to do so, or unless consented to by the client, is an unethical business practice. An investment advisory firm has a responsibility to ensure that all information collected from a client be kept confidential. The only exception to the rule should be in instances where the client authorized the release of such information, or when the investment advisory firm is required by law to disclose such information. Take note, if the account is a joint one, such as with a spouse, the advisor does not need consent to discuss account matters with either party. Improper custody. Another example of improper behavior is taking any action, directly or indirectly, with respect to those securities or funds in which any client has any beneficial interest, where the investment advisor has custody or possession of such securities or funds when the advisor's action is subject to and does not comply with the requirements of the NASA Model Rule on Custody. We will cover custody in full detail at Learning Objective 8A, Other Unethical Business Practices. Just as with broker-dealers and agents, investment advisors and their representatives are prohibited from engaging in unethical business practices, which include the following: engaging in excessive trading, churning. There are many situations where an investment advisor may receive commissions or be affiliated with a person that receives commissions from the securities transactions that are placed by the investment advisor. This creates a potential reward for increased securities trading, which is not allowed. The definition of excessive trading is the same as in Learning Objective 7B. Placing an order to purchase or sell a security for the account of a client without authority to do so. Placing an order to purchase or sell a security for the account of a client upon instruction of a third party without first having obtained a written third-party trading authorization from the client. Borrowing money from or lending money to clients unless meeting the same conditions applying to broker-dealers and agents, affiliate or in the money lending business. Guaranteeing a client that a specific result will be achieved, gain or no loss, with advice that will be rendered, using testimonials and advertisements. This does not apply to broker-dealers and agents. See the Take Note at Learning Objective 6F regarding the SEC's new rule on advertising by IA. Sharing in the profits and losses in a customer's account. Unlike agents, where this may be done with the consent of the customer and the employing broker-dealer, this type of sharing is not permitted for investment advisors and their representatives. Please note that this is not the same as performance-based compensation discussed at Learning Objective 6E, Fiduciary Responsibility of Investment Advisors. Unlike broker-dealers and their agents, investment advisors and their IARs have a fiduciary responsibility to their customers that obligates these advisors and their representatives to put their clients' interests ahead of their own. That is the primary reason why advisors need their clients' consent when acting as agents or principals in trades with them, covered in the next LO. As fiduciaries, investment advisors must identify and address all material conflicts of interest by eliminating or disclosing such conflicts. Clients rely on the advice of their advisors and must feel confident that those advisors are working in the client's best interests. If the advisor also engages in non-securities-related activities, such as selling auto insurance or real estate, these represent potential conflicts of interest, time taken away from watching the market, and must be disclosed. Take note, the SEC's Regulation Best Interest, Reg BI, places a best interest obligation on broker-dealers and their agents, but it is not a full fiduciary responsibility, as is the case with investment advisors and their representatives. Take note, what about the client who refuses to give any financial information or discuss objectives? In that case, the investment advisor will probably refuse to do business with the person. This is different from the same scenario with an agent. An agent's only job is to effect securities transactions, while that of the IA or IAR is to give advice. It's part of that fiduciary responsibility. How can you possibly give advice if you have no idea what would be appropriate for the client? Test topic alert. It is possible you might have a test question where the investment advisor, or IAR, recommends the same security to most or all of its customers. This would generally be prohibited because it is highly unlikely that the same security would be suitable for all clients. This practice could also be referred to as blanket recommendations. Uniform Prudent Investors Act of 1994, UPIA, because the role of a fiduciary is spelled out in state laws dealing with trustees, we need to look at the UPIA to observe its effects on investment advisory firms. Beginning with the dynamic growth of the stock markets in the late 1960s, the investment practices of fiduciaries experienced significant change. As a result, the Uniform Prudent Investor Act, UPIA, was passed in 1994 as an attempt to update trust investment laws in recognition of those many changes. One of the major influences on this legislation was the growing acceptance of modern portfolio theory. The basic standards for anyone, not just an investment advisor who has a fiduciary role, are found in this act, which has been adopted by almost all states. Under the UPIA, fiduciaries are required to use skill and caution when making investment decisions with other people's money. The UPIA makes 5 fundamental alterations in the former criteria for prudent investing. Those changes are as follows. The standard of prudence is applied to any investment as part of the total portfolio, rather than to individual investments. In this context, the term portfolio means all of the trust's or estate's assets. It is the total return of the portfolio that is measured, not the return of any of the individual assets. The trade-off in all investments between risk and return is identified as the fiduciary's primary consideration. All categorical restrictions on types of investments have been removed. The trustee can invest in anything that plays an appropriate role in achieving the risk/return objectives of the trust and that meets the other requirements of prudent investing. The well-accepted requirement that fiduciaries diversify their investments has been integrated into the definition of prudent investing. The much-criticized former rule forbidding the trustee to delegate investment functions has been reversed. Delegation is now permitted, subject to safeguards. With greater numbers of trustees delegating investment decisions to investment advisors, NASA has determined that you must know how the UPIA affects their role. Here are some thoughts that will help you on the exam. A trustee must invest and manage trust assets as a prudent investor would by considering the purposes, terms, distribution requirements, and other circumstances of the trust. In satisfying this standard, the trustee must exercise reasonable care, skill, and caution. A trustee's investment and management decisions about individual assets must be evaluated not in isolation, but in the context of the total portfolio and as a part of an overall investment strategy with risk and return objectives that are reasonably suited to the trust. A higher standard applies to the trustee, who is an expert, a prudent expert, because he is assumed to have special skills. Judging if a trustee has acted with prudence is based upon conduct and not the performance of the portfolio. The responsibility of following the terms of the trust cannot be delegated to investment advisors or other third parties. What conduct by a trustee demonstrates prudence? The following 5-step process encompasses all of the requirements of the UPIA. Analyze current position. Design optimal investment portfolio structure. Formalize investment policy. Implement investment policy. Monitor and supervise. Learning Objective 7D, identify trading and compensation restrictions placed on investment advisors. Acting in a principal or agency capacity. As mentioned many times, the primary role of an investment advisor is giving investment advice for compensation. That compensation most often is fees based on the assets under management, but can also include commissions under certain conditions. We are going to look at 2 of those here. Disclosure of capacity by investment advisors. It is unlikely that the Series 63 exam will cover this, but let's take a few lines to make sure we have it, just in case. As stated in Unit 3, the business of an investment advisor is giving advice. That is why they get compensated. They're not in the business of executing securities transactions. That is the role of the broker-dealer. However, on rare occasions, an investment advisor might buy from or sell to an advisory client in the capacity of a principal, or the advisor might put together a buyer and seller acting in the capacity of an agent. This would be permitted with the following two requirements. The client receives full written disclosure as to the capacity in which the advisor proposes to act. Client consent is obtained, can be oral or written. Both of these must be done prior to completion of the transaction. This is unlike a broker-dealer who, when acting as a principal in a trade with a customer or as the customer's agent, need only indicate the capacity on the trade confirmation. Consent is not required. Agency cross-transactions. In an agency cross-transaction, the investment advisor, or IR acting on behalf of the firm, acts as a broker-dealer in an agency capacity for both its advisory client and the party on the other side of the trade. The USA will permit an investment advisor to engage in these transactions, provided the advisor obtains prior written consent for these types of transactions from the client that discloses the following. The investment advisor will be receiving commissions from both sides of the trade. There is a potential conflict of interest because of the division of loyalties to both sides. On at least an annual basis, the investment advisor furnishes a statement or summary of the account identifying the total number of such transactions and the total amount of all remuneration from these transactions. The disclosure document conspicuously indicates that this arrangement may be terminated at any time. No transaction is effected in which the same investment advisor or an investment advisor and any person controlled by or under common control with that investment advisor recommended the transaction to both any seller and any purchaser. These requirements do not relieve advisors of their duties to obtain best execution and best price for any transaction. In addition to the prior consent, at or before the completion of each agency cross-transaction, the client must be sent a written trade confirmation that includes a statement of the nature of the transaction, the date and, if requested, the time of the transaction, and the source and amount of any remuneration to be received by the IA or IR in connection with the transaction. Example: an advisor has a client who is conservative and another who generally looks for more aggressive positions. The conservative client calls and expresses concerns about the volatility of First Tech Internet Services, Inc., stating that he thinks this may be the best time to exit his position. The advisor agrees and mentions that she has a risk-taking client for whom First Tech is suitable and she'd like to cross the security between the two clients, charging a small commission to each of them. With the permission of both parties, this is not a violation. Test topic alert. In an agency cross-transaction, the advisor may not recommend the transaction to both parties of the trade. As you can see in the previous example, the conservative client initiated the discussion about the sale, and the advisor recommended the transaction only to one side, the aggressive client. Take note. In the case of agency cross-transactions, permission to engage in them must be obtained in writing prior to the first transaction. In essence, the client is giving blanket authority to engage in this activity. In the case of acting as a principal or agent, as described previously, no blanket authorization is permitted and oral or written consent must be obtained prior to the completion of the transaction. In addition, when acting in such capacity, such person is required to be registered as a broker-dealer in this state unless excluded from the definition. Section 28E, Safe Harbor and Soft Dollar Compensation. Research is the foundation of the money management industry. Providing research is one important, long-standing service of the brokerage business. Soft dollar arrangements have developed as a link between the brokerage industry's supply of research and the money management industry's demand for research. What does that mean and how does it work? To find the answers, we must review the provisions of Section 28E of the Securities Exchange Act of 1934. Broker-dealers typically provide a bundle of services, including research and execution of transactions. The research provided can be either proprietary, created and provided by the broker-dealer, including tangible research products, as well as access to analysts and traders, or third-party, created by a third party, but provided by the broker-dealer. Because commission dollars pay for the entire bundle of services, the practice of allocating certain amounts of these dollars to pay for the research component has come to be called soft dollars. The SEC has defined soft dollar practices as arrangements under which products or services, other than execution of securities transactions, are obtained by an investment advisor from or through a broker-dealer in exchange for the direction by the advisor of client brokerage transactions to the broker-dealer, frequently referred to as directed transactions on the exam. Under traditional fiduciary principles, a fiduciary cannot use assets entrusted by clients to benefit itself. As the SEC has recognized, when an advisor uses client commissions to buy research from a broker-dealer, it receives a benefit because it is relieved from the need to produce or pay for the research itself. In addition, when transactions involving soft dollars involve the advisor receiving executions at inferior prices, advisors using soft dollars face a conflict of interest between their need to obtain research and their client's interest in paying the lowest commission rate available and obtaining the best possible execution. Congress created a safe harbor under Section 28E of the Securities Exchange Act of 1934 to protect advisors from claims that they had breached their fiduciary duties by causing clients to pay more than the lowest available commission rates in exchange for research and execution. Because of the conflict of interest that exists when an investment advisor receives research, products, or other services as a result of allocating brokerage on behalf of clients, the SEC requires advisors to disclose soft dollar arrangements to their clients. Section 28E provides that a person who exercises investment discretion with respect to an account will not be deemed to have acted unlawfully or to have breached a fiduciary duty solely by reason of his having caused the account to pay more than the lowest available commission if such person determines in good faith that the amount of the commission is reasonable in relation to the value of the brokerage and research services provided. In adopting Section 28E, Congress acknowledged the important service broker-dealers provide by producing and distributing investment research to money managers. Section 28E defines when a person is deemed to be providing brokerage and research services and states that a person provides brokerage and research services insofar as he furnishes advice directly or through publications or writing about the value of securities, the advisability of investing in, purchasing, or selling securities, or the availability of purchasers or sellers of securities, furnishes analyses and reports concerning issuers, industries, securities, economic factors and trends, portfolio strategy and performance of accounts, or effects securities transactions and performs functions incidental thereto, such as clearance, settlement, and custody. Test Topic Alert. What this all comes down to is recalling what is and what is not included in the safe harbor. Here are some of the items that, if received as soft dollar compensation, would likely fall under Section 28E as safe harbor. Research reports analyzing the performance of a particular company or stock. Financial newsletters and trade journals could be eligible research if they relate with appropriate specificity. Quantitative analytical software, seminars or conferences with appropriate content, effecting and clearing securities trades. The following would be likely to fall out of the safe harbor, not be allowable: telephone lines, office furniture, including computer hardware, travel expenses associated with attending seminars, rent, any software that does not relate directly to analysis of securities, payment for training courses for this exam, internet service, IR as an agent. The securities laws do not prohibit a registered investment advisor representative from being an employee of a registered broker-dealer. However, there would be a duty on the part of both the broker-dealer and the soliciting advisors to inform advisory clients of their ability to seek execution of transactions with broker-dealers other than those who have employed the advisors. Knowledge Check 7.3. Question 1. Under the Uniform Prudent Investor Act, a trustee can delegate all of the following except A. The administration of a trust or estate in accordance with the terms of the trust. B. The selection of different managers for different asset classes. C. The decisions as to what specific securities to be acquired. D. The style in which the portfolio is managed. The answer is A. The UPL expanded the ability of fiduciaries, such as trustees, to delegate certain investment functions. However, following the terms of the trust is their responsibility and cannot be delegated to a third party. Question 2. Under state laws, an advertising restriction applying to investment advisors that does not apply to broker-dealers is A. A prohibition on using testimonials. B. A prohibition on using social media. C. The requirement to deliver a brochure before using an advertisement. D. The requirement to emphasize that past performance is not indicative of future results. The answer is A. Broker-dealers may use testimonials, while investment advisors cannot. Both can use social media, although IA need to be careful to avoid testimonials. Both must emphasize that past performance does not assure future results. It would not be practical for an investment advisor to include its brochure in an advertisement. The brochure must be delivered to any new or prospective customer, but not in an advertisement. As has been noted, the SEC now permits certain investment advisor testimonials. However, until NASA passes a model rule allowing them, they are prohibited on the Series 63 exam. Question 3. Investment advisors and their representatives have an obligation to place their clients' needs ahead of their own. This is legally known as A. Avoiding conflicts of interest. B. Making full disclosure. C. Fiduciary responsibility. D. Playing fair. The answer is C. The obligation of investment advisors and IARs to place clients' interests ahead of their own is known as acting in a fiduciary capacity. Question 4. In addition to the prior consent of the parties, at or before the completion of each agency cross-transaction, the clients must be sent a written trade confirmation that includes all of the following except A. A statement of the nature of the transaction. B. The name of the other party with whom the transaction was crossed. C. The date, and if requested, the time of the transaction. D. The source and amount of any remuneration to be received by the IA or IAR in connection with the transaction. The answer is B. The NASA rule does not require furnishing the identity of the other party to the agency cross-transaction. Question 5. Which of the following would not be included in the safe harbor provisions of Section 28E of the Securities Exchange Act of 1934? A. Proprietary research. B. Third-party research. C. Rent. D. Seminar registration fees. The answer is C. Section 28E provides a safe harbor for those expenses paid with soft dollars that offer a direct research benefit. Rent is not included in the list of acceptable items coming under that safe harbor. Question 6. When an investment advisor with discretion over a client's account directs trade executions to a specific broker-dealer and uses the commission dollars generated to acquire software that analyzes technical market trends, it is known as A. Hard dollar compensation. B. Indirect compensation. C. Investment discretion. D. Soft dollar compensation. The answer is D. Soft dollar compensation is when an investment advisor derives an economic benefit from the use of a client's commission dollars. Software of the type mentioned here is allowable under the safe harbor provisions of Section 28E of the Securities Exchange Act of 1934. It is true that this is indirect compensation and that this is a discretionary account, but the answer that best matches the question is soft dollar. Many times on the exam, you'll have to select the best of the choices given. Lesson 7.4, Conflicts of Interest. Learning Objective 7E, recall the potential conflicts of interest. At Learning Objective 6A, we described the meaning of a conflict of interest. Now let us examine some of the most common examples for broker-dealers followed by those for investment advisors. Broker-dealer conflicts of interest. Broker-dealer conflicts of interest include offering a proprietary product, such as a house fund, a mutual fund where the underwriter or advisor is affiliated with the broker-dealer. The commission payout on these products is generally higher, presenting a potential conflict of interest. Offering a limited partnership offering, DPP, where the sponsor is an affiliate of the broker-dealer. Failing to disclose that the firm is affiliated with the issuer of a recommended security or recently was the underwriter of the issuer's securities. Program sponsors, such as investment companies or insurance companies, providing incentives or rewards to agents for selling the sponsor's products. A securities professional having a financial interest in any security being recommended. A broker-dealer going public and placing shares of its own stock into discretionary accounts, and a broker-dealer publishing a favorable research report after underwriting the issuer's stock offering. This is just a sample. The key point is, if there is any doubt about the transparency of the recommendation or transaction, be sure to make full disclosure. Take note. One way to mitigate the potential conflict of interest regarding varying compensation for different products is an agnostic or neutral compensation grid. Compensation grid refers to the compensation schedule many firms use to pay agents. Typically, the more commission revenue the agent generates, the larger the percentage of that revenue the representative may keep. These agnostic grids typically pay a flat percentage of the revenue an agent generates, regardless of product recommended. Test topic alert. Suppose you were selling shares of a company where your sister was a control person. Do you think you'd have to disclose that potential conflict to your clients? Yes. Investment advisor conflicts of interest. The NASA Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors details examples of potential conflicts of interest for investment advisors. Investment advisors are required to disclose to clients in writing, before any advice is rendered, any material conflict of interest relating to the advisor or any of its employees that could reasonably be expected to impair the rendering of unbiased and objective advice, including compensation arrangements connected with advisory services to clients, which are in addition to compensation from such clients for such services, and charging a client an advisory fee for rendering advice when a commission for executing securities transactions pursuant to such advice will be received by the advisor or its employees. This rule is designed to require disclosure of all material conflicts of interest relating to the advisor or any of its employees that could affect the advice that is rendered. The two examples cited in the rule pertain to compensation arrangements that benefit the advisor and that are connected with advisory services being provided. However, full disclosure of all other material conflicts of interest, such as affiliations between the investment advisor and product suppliers, are also required to be made under the rule. In a famous Supreme Court case, SEC v. Capital Gains Research Bureau, Inc., 375 U.S. 180, 1963, the court stated that investors must be permitted to evaluate overlapping motivations through appropriate disclosure in deciding whether an advisor is serving two masters or only one, especially if one of the masters happens to be economic self-interest. Take note. The most complete list of investment advisor disclosures is found in SEC Release IA 1092. State regulators have incorporated these into their enforcement practices. An investment advisor must not affect transactions in which he has a personal interest in a manner that could result in preferring his own interest to that of his advisory clients. An investment advisor who structures his personal securities transactions to trade on the market impact caused by his recommendations to clients must disclose this practice to clients. An investment advisor generally also must disclose if his personal securities transactions are inconsistent with the advice given to clients. And an investment advisor must disclose compensation received from the issuer of a security being recommended. Learning Objective 7F identify the requirements when selling securities on the premises of financial institutions. Sales of securities at financial institutions. The 1990s saw a proliferation of broker-dealer services being offered on the premises of financial institutions, particularly banks. In response to the potential for confusion as well as conflicts of interest, NASA prepared model rules for sales of securities at financial institutions. Here are the key points for you to know. No broker-dealer shall conduct broker-dealer services on the premises of a financial institution where retail deposits from ordinary customers like you and me are taken unless the broker-dealer complies initially and continuously with the following requirements. Setting. Wherever practical, broker-dealer services should be conducted in a physical location distinct from the area in which the financial institution's retail deposits are taken. In situations where there is insufficient space to allow separate areas, the broker-dealer has a heightened responsibility to distinguish its services from those of the financial institution. The broker-dealer's name should be clearly displayed in the area in which the broker-dealer conducts its services. Customer disclosure and written acknowledgement at or prior to the time that a customer's securities brokerage account is opened by a broker-dealer on the premises of a financial institution where retail deposits are taken. The broker-dealer must disclose orally and in writing that the securities products purchased or sold in a transaction with the broker-dealer are not insured by the Federal Deposit Insurance Corporation, FDIC, are not deposits or other obligations of the financial institution, and are not guaranteed by the financial institution, and are subject to investment risks, including possible loss of the principal invested, and make reasonable efforts to obtain from each customer, during the account opening process, a written acknowledgement of the disclosures. Communications with the public. The following logo format disclosures may be used by a broker-dealer in advertisements and sales literature, including material published or designed for use in radio or television broadcasts, automated teller machine, ATM, screens, billboards, signs, posters, and brochures to comply with the requirements, provided that such disclosures are displayed in a conspicuous manner. Not FDIC insured. No bank guarantee. May lose value. As long as the omission of the disclosures would not cause the advertisement or sales literature to be misleading in light of the context in which the material is presented, such disclosures are not required with respect to messages contained in radio broadcasts of 30 seconds or less. Electronic signs, including billboard-type signs that are electronic, time, and temperature signs and ticker tape signs, but excluding messages contained in such media as television, online computer services, or ATM, and signs, such as banners and posters, when used only as location indicators. SIPC coverage. Although most people are familiar with FDIC insurance and the role it plays insuring client accounts at banks, insurance from the Securities Investors Protection Corporation, SIPC, is less well known. SIPC provides protection to clients of broker-dealers in the event the BD enters bankruptcy proceedings. SIPC, not the administrator, appoints a trustee whose job is to return assets owned by clients but held at the BD. SIPC does not protect against a decline in the value of the client's portfolio. As with FDIC, there are limits to the coverage, but those will not be tested. One testable item is that all firms that are members of SIPC must place a sign in each office location indicating that the broker-dealer is a SIPC member. Furthermore, all advertising by a member must include the SIPC logo or a statement of SIPC membership. Currency Transaction Reports, CTRs. The Bank Secrecy Act requires every financial institution to file a Currency Transaction Report, CTR, on FIN-CEN Form 112 for each cash transaction that exceeds $10,000. Cash includes travelers' checks and postal money orders. This requirement applies to cash transactions used to pay off loans, the electronic transfer of funds, or the purchase of certificates of deposit, stock, bonds, mutual funds, or other investments. Knowledge Check 7.4. Question 1. State securities regulators are concerned about disclosures of conflicts of interest. Which of the following is a potential conflict of interest that must be disclosed by a broker-dealer? A majority of the voting stock in the broker-dealer is held by the CEO. B. The broker-dealer has been in business less than 5 years. C. The broker-dealer is registered in only 4 states. D. The stock that is the subject of the recommendation was the subject of an IPO managed by the broker-dealer. The answer is D. One relatively common potential conflict of interest occurs when a broker-dealer is part of the underwriting of an issuer's securities. There is no problem recommending that security, assuming it is suitable for the investor, but the potential conflict of interest must be disclosed. The ownership control of the BD is only a concern when securities of the owner are the subject of the recommendation. The CEO, as an individual, does not issue securities. The length of time in operation or the number of states doesn't lead to any kind of conflict of interest. Question 2. All of the following activities of an investment advisor are prohibited under the Uniform Securities Act except A. Engaging in a practice not expressly forbidden by the Act, but defined as unethical by courts, self-regulatory organizations, such as FINRA, or both. B. Deliberately omitting a material fact when soliciting a client. C. Disclosing potential conflicts of interest. D. Selling recommended securities to a client from one's own account without disclosing this fact to the client. The answer is C. Potential conflicts of interest must be disclosed to clients. The USA gives the administrator and self-regulatory organizations the power to define certain practices as unethical with the same force as those spelled out in the Act. Omitting a material fact is specifically prohibited under the Act. Investment advisors must always disclose the capacity in which they acted in a transaction with advisory clients. Question 3. The Seeking Alpha Growth Fund directs a sizable portion of its portfolio executions to your broker-dealer. If the firm has this fund on its highly recommended list, this would be A. Allowed without restriction. P. Allowed only when the investment company uses more than one broker-dealer to sell its shares. C. A conflict of interest that would have to be disclosed. D. Prohibited only if selling shares and executions for the portfolio by the member takes place on the same business day. The answer is C. Recommending shares of a fund when the broker-dealer is aware that a policy exists to direct brokerage to them is an obvious conflict of interest and would have to be disclosed. Once again, there is no violation as long a disclosure is made. Question 4. Functioning responsibly as an agent requires disclosure of any potential conflicts of interest that could arise from a securities recommendation. Examples of potential conflicts of interest that must be disclosed to clients would include all of the following except A. Recommending shares of a pharmaceutical company that manufactures a drug that the agent takes for control of high blood pressure. B. Recommending a purchase of a mutual fund whose underwriter is affiliated with the agent's broker-dealer. C. Recommending shares of a corporation where an immediate family member of the agent is a control person. D. Recommending a variable annuity where the insurance company is offering a trip to Australia for any agent meeting a specified sales volume. The answer is A. There is no conflict in recommending a stock where the agent uses a product sold by the company unless we can see some direct or indirect benefit to the agent if the client purchases the stock. Question 5. Broker-dealers operating on the premises of a financial institution must disclose, orally and in writing, that the securities products purchased or sold in a transaction with the broker-dealer Roman numeral 1, are not insured by the Federal Deposit Insurance Corporation, FDIC. Roman numeral 2, are not deposits or other obligations of the financial institution and are not guaranteed by the financial institution. Roman numeral 3, are insured by the Securities Investor Protection Corporation, SIPC. Roman numeral 4, are subject to investment risks, including possible loss of the principal invested. A to P and G. B. Fine P and roll. C.I. Hein to and Vunui. D.I. The answer is D. When operating on the premises of a financial institution, such as a bank, it is imperative that broker-dealers make a distinction between investment products and bank products. SIPC does not insure the value of securities products. It insures assets of customers that are held in the possession of a broker-dealer that goes bankrupt. Question 6. The regulators are concerned when a broker-dealer operates on the premises of a financial institution. However, the rules only apply when which of the following activities takes place on those premises. A. Personal loans are made. B. Retail deposits are taken. C. Mortgage loan applications are accepted. D. Safe deposit boxes are available. The answer is B, because of the potential for misunderstanding the difference between bank retail products, savings accounts, CDs, money market checking accounts, and brokerage accounts. The rules on BDs operating on the premises of a financial institution apply only when that location accepts retail deposits. In most cases, these other activities will take place, but it is the accepting of retail deposits that triggers the on-the-premises rule. Unit 8. Customer Protection. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Learning Objective 8A recognize how investment advisors and broker-dealers protect customer funds and securities. Learning Objective 8B recognize that securities professionals must practice good cybersecurity, privacy, and data protection. Introduction. Broker-dealers frequently have custody of customer assets, funds, and or securities. Without proper controls, the opportunities for illegal activity, such as forgery, theft, or embezzlement, is possible. The same is true for investment advisors, although custody is much less common among them. Hardly a day goes by without news of a hacking attempt that has compromised the security of a company, its clients, or both. There are steps that can be taken by securities professionals to reduce the potential for loss to the firm and its clients. Another area of protection involves discretionary accounts. The ability of the firm to control the buying and selling of the assets in a customer's accounts presents an opportunity for significant financial loss to the customer. The Series 63 exam will include 3 questions on the material presented in this unit. Lesson 8.1, Customer Funds and Securities. Learning Objective 8A recognize how investment advisors and broker-dealers protect customer funds and securities. Custody rules for broker-dealers and investment advisors. Custody is the term used to describe a broker-dealer or an investment advisor maintaining possession of a customer's money and or securities. It is common for broker-dealers to have custody, but that is not the case for investment advisors. Many states prohibit investment advisors from keeping custody. The others require the investment advisor to notify the administrator if it intends to do so. An investment advisor is also considered to have custody if the customer has authorized it to receive and disperse funds and securities from his bank account. Broker-dealer custody of customer funds and securities. Because almost all broker-dealers are also registered with the SEC, if the question deals with a state-only registered BD, the point will be made clear: NASA accepts the SEC rule on custody as fulfilling a BD responsibility. Broker-dealers must comply with the SEC's broker-dealer financial responsibility rules, including, as applicable, custodial requirements under Rule 15C 3-3 under the Securities Exchange Act of 1934, the Exchange Act. That section is known as the Customer Protection Rule. The purpose of the Customer Protection Rule is to safeguard customer securities and funds held by a broker-dealer, to prevent investor loss or harm in the event of a broker-dealer's failure, and to enhance the SEC's ability to monitor and prevent unsound business practices. Put simply, the Customer Protection Rule requires broker-dealers to safeguard customer assets and to keep customer assets separate from the firm's assets, no commingling, thus increasing the likelihood that customers' securities and cash can be returned to them in the event of the broker-dealer's failure. Investment advisor custody of customer funds and securities. In instances where a state-registered investment advisor has custody or possession of clients' funds or securities, it must comply with the NASA Model Rule on Custody. The rule is designed to ensure the safekeeping of those securities and funds. The rules under the Act specifically provide that securities of clients be segregated and properly marked, the funds of the clients be deposited in separate bank accounts, the investment advisor notify each client as to the place and manner in which such funds and securities are being maintained, an itemized list of all securities and funds in the advisor's possession be sent to the client not less frequently than every 3 months, and all such funds and securities must be verified annually by actual examination by an independent CPA on a surprise basis. The exam may refer to that requirement as an annual audit. The rule establishes very conservative measures to safeguard each client's funds and securities held by an investment advisor. Under the NASA Model Rule on Custody, it is unlawful for an investment advisor to have custody of client funds and securities if the administrator in the state prohibits, by rule, investment advisors from having custody. In absence of a rule, an advisor fails to notify the administrator on Form ADV that it has custody. The investment advisor fails to supply clients, no less frequently than quarterly, with a statement of account activity and the location and value of their assets held in custody. In general, investment advisors will use a qualified custodian to maintain customer funds and securities. Qualified custodian means either a bank or savings association that has deposits insured by the Federal Deposit Insurance Corporation, FDIC, or a broker-dealer holding the client assets in customer accounts who is registered in this jurisdiction and with the SEC. The client funds and securities held by the qualified custodian must be verified at least once during each calendar year by an independent certified public accountant at a time that is chosen by the independent certified public accountant without prior notice or announcement to the investment advisor, and that is irregular from year to year. This is generally referred to as a surprise audit. If the investment advisor itself maintains client funds or securities pursuant to this rule as a qualified custodian in connection with advisory services the investment advisor provides to clients, the independent certified public accountant the investment advisor retains to perform the independent verification must be registered with the Public Company Accounting Oversight Board in accordance with its rules. Take note, there is one major benefit to an investment advisor using a qualified custodian. Because the custodian is sending the quarterly reports to the client, that administrative burden is lifted from the investment advisor. Test topic alert. If an investment advisor wishes to maintain custody of customer funds or securities, and state law does not prohibit doing so, the advisor must give written notice to the administrator. This notice is given by indicating such on the Form ADV. Do not choose the answer on the exam that states, "Must obtain permission from the administrator." All that is required is notification on the original or amended Form ADV. Definition of custody by investment advisors. Custody means holding, directly or indirectly, client funds or securities, or having any authority to obtain possession of them. The investment advisor has custody if a related person, any person, directly or indirectly, controlling or controlled by the investment advisor, and any person that is under common control with the investment advisor, holds, directly or indirectly, client funds or securities, or has any authority to obtain possession of them, in connection with advisory services the investment advisor provides to clients. Addressing the investment advisor, custody includes possession of client funds or securities, unless received inadvertently, and returned to the sender within 3 business days of receiving them. Any arrangement, including a general power of attorney, under which you are authorized or permitted to withdraw client funds or securities maintained with a custodian upon your instruction to the custodian. Any capacity, such as general partner of a limited partnership, managing member of a limited liability company, or a comparable position for another type of pooled investment vehicle, or trustee of a trust, that gives you or your supervised person legal ownership of or access to client funds or securities, and possession of client funds or securities by a broker-dealer affiliated with the investment advisor. Custody does not include receipt of checks drawn by clients and made payable to unrelated third parties if forwarded to the third party within 3 business days of receipt, and having investment discretion over the client's account. Custody is the physical possession or control of funds and securities. Many advisors do not have custody because their client funds and securities are maintained at a bank or brokerage house. The advisor makes investment decisions under an advisory contract even though the client's funds and securities are placed in a custodial account at a commercial bank. Most administrators will require advisors who maintain custody to provide a surety bond or meet certain net worth standards. Test topic alert. Most investment advisors do not take custody and therefore are unable to accept direct delivery of customer securities or funds except under the limited conditions described in this section. However, broker-dealers are not constrained by this rule. They are only required to provide receipts any time they accept customer assets. Test topic alert. If a broker-dealer affiliated with an investment advisor maintains custody of the investment advisor's customers' funds, NASA says that investment advisor is considered to be maintaining custody. That means all of the custody rules, beginning with notifying the administrator, apply. Discretionary account rules for broker-dealers and investment advisors. Discretionary accounts. A discretionary account is one where the customer grants the power to a broker-dealer or investment advisor to make buy and sell decisions in the account without the need to have prior contact with the customer. A securities professional exercises discretion when determining any one or all of the following in a customer's account: asset, security; action, buy or sell; amount, how many shares. There is one exception to the rule. Merely authorizing a securities professional to determine the best price or time to trade a security is not considered to be discretion, particularly for purposes of the financial requirements, such as bonding or, in the case of an investment advisor, minimum net worth. Before a broker-dealer or agent can exercise discretion, a written discretionary authorization permitting such discretion must be received by the firm, and the account must be approved by a designated supervisor. The rule for investment advisors is slightly different. In the case of an advisory client, Oral authorization may be relied upon for the first 10 business days after the initial discretionary trade in the account. After that time, however, without a written authorization, no further discretion may be exercised. Because of the potential risk of churning the account, excessive trading to generate commissions, these accounts require frequent review of the account's activity. Test topic alert. Whether a broker-dealer or an investment advisor, all discretionary orders must be reviewed and approved by a designated supervisory person on the day of the trade. Approval prior to the trade is not required. Test topic alert. Determining the price or the time for entry of a customer order is not discretion and does not need written authorization. Example: discretionary trading authorization. What exactly does it mean when a securities professional can exercise discretion in a client's account? Simply, that person can make decisions regarding securities trading in the client's account without prior consultation with the client. As long as the securities professional can select the specific security, the asset, or whether to buy or sell, the action, or the size of the order, the amount, the person has discretionary authority. In most cases, the party using discretion selects all three of these. Other than an exception applying to investment advisors, written discretionary authority from the client must be in hand prior to exercise of discretion. Practice question. All of the following client orders would require discretionary authorization except: A. Buy me 100 shares of a stock with a dividend of at least 4%. B. I need a tax write-off, so sell something out of my portfolio to generate a capital loss. C. I'm going to need some cash, so sell something I own. D. Please buy 300 shares of XYZ stock for me when you think the price is right. The answer is D. Buy 300 shares of XYZ stock for me is correct because the client has specified the name of the asset, the action, and the amount. All the client is asking is that the agent determine the right price. Determining price or time is not considered the exercise of discretion. Knowledge Check 8.1. Question 1. According to the Uniform Securities Act, an investment advisor may have custody of a customer's funds and securities if A. It has received the permission of the administrator. B. It has received permission from the SEC. C. It does not share in the capital gains of the account. D. The administrator has been informed of the custody. The answer is D. As long as retaining custody of funds is not prohibited, an investment advisor may have custody of a customer's account after providing notice to the administrator. Question 2. An investment advisor registered in state decides it wishes to maintain custody of customer assets. As long as the securities laws of state do not prohibit custody, the investment advisor would have to promptly notify A. the administrator by filing an amended Form ADV that it is going to maintain custody. B. the SEC on Form ADV that it is going to maintain custody. C. the administrator in a letter that it is going to maintain custody. D. the administrator electronically, email, that it is going to maintain custody. The answer is A. The notification to the administrator as a state-registered IA. The SEC has nothing to do with this. Must be made promptly by amending the Form ADV. Question 3. A customer of an investment advisor inadvertently mails some stock certificates to the firm's office. The firm does not maintain custody of customer assets. If the certificates were received on a Monday, NASA rules would require that the certificates be A. returned no later than Tuesday. B. returned no later than Thursday. C. returned the same day. D. forwarded to the broker-dealer promptly. The answer is B. NASA's custody rules require that an investment advisor who does not maintain custody must return certificates that are mistakenly sent within 3 business days. When it comes to checks, it depends on how the check is drawn. If made out to the investment advisor, it must be returned within 3 business days. If the check is made out to a third party, usually the executing broker-dealer, it must be forwarded to that third party. In all cases, the time limit is 3 business days after receipt. Question 4. Under the NASA Model Rule on Custody Requirements for Investment Advisors, if an investment advisor has custody of customer funds and securities, how often must the advisor send the customer a statement of account activity? A. Within 3 business days after any transaction. B. Monthly. C. Quarterly. D. Annually. The answer is C. An investment advisor in possession of customer assets must send a statement to the customer every 3 months, quarterly. The statement must list the customer's securities and all account transactions since the last statement date. At least once per calendar year, an independent CPA must verify by actual examination the customer assets held in custody. Question 5. Certain types of accounts require special documentation. In which of the following cases must the required documentation be received prior to any account activity? A. Discretionary account with a broker-dealer. B. Discretionary account with an investment advisor. C. Margin account. D. Options account. The answer is A. No trading may take place in a discretionary account with a broker-dealer before receipt of the signed authorization form. In the case of an investment advisor, required receipt of the written authorization form is no later than 10 business days after the initial trade. For that initial period, oral authorization is permitted. For margin accounts, the documentation must be received promptly after the initial trade, and in options accounts, the customer agreement must be received within 15 days after the account opening. Lesson 8.2, Cybersecurity and Data Protection. Learning Objective 8B, recognize that securities professionals must practice good cybersecurity, privacy, and data protection. Cybersecurity points to be addressed. In September 2014, NASA released results of a pilot survey designed to better understand the cybersecurity practices of state-registered investment advisors. Based on that survey, in setting up a cybersecurity program, NASA suggests addressing the following points. Cyber preparedness. Has the firm addressed which cybersecurity threats and vulnerabilities may impact its business? Cybersecurity compliance program. Does the firm have written policies, procedures, or training programs in place regarding safeguarding client information? Cybersecurity and social media. Does the firm have written policies, procedures, or training programs in place relating to the use of social media for business purposes, e.g., LinkedIn, Twitter, Facebook? Cyber insurance. Does the firm maintain insurance coverage for cybersecurity? Cyber expertise. Has the firm engaged an outside consultant to provide cybersecurity services for your firm? Cyber confidentiality. Does the firm have confidentiality agreements with any third-party service providers with access to the firm's information technology systems? Cyber incident. Has the firm ever experienced a cybersecurity incident where, directly or indirectly, theft, loss, unauthorized exposure, use of, or access to customer information occurred? If so, has the firm taken steps to close any gaps in its cybersecurity infrastructure? Cyber disposal. Does the firm have a procedure for the disposal of electronic data storage devices? Cyber continuation. What are the plans for your firm's continued operation during a cyber event or cybersecurity incident? Cyber losses. Are there plans for treating the loss of electronic devices, e.g., loss of a laptop containing personal and confidential client information? Cybersecurity safeguards. Does the firm use safeguards, such as encryption and antivirus or anti-malware programs? Does the firm contact clients via email or other electronic messaging? And if so, does the firm use secure email or any procedures to authenticate client instructions received via email or electronic messaging to work against the possibility of a client being impersonated? Safeguarding client information. Broker-dealers have a great deal of information about their clients that would be highly valuable to persons with evil intentions. Our primary concern here is with identity theft, which may be used to falsify client requests for funds and or securities. In order to combat identity theft, securities professionals must be aware of the red flags. Take note. Identity theft means a fraud committed or attempted using the identifying information of another person without authority. Red flag means a pattern, practice, or specific activity that indicates the possible existence of identity theft. The regulators are concerned when broker-dealers or other financial professionals maintain what are referred to as covered accounts. The term covered account is defined as an account that a financial institution offers or maintains, primarily for personal, family, or household purposes, that involves or is designed to permit multiple payments or transactions, not a business account. It is felt that there is much less identity theft risk there, and any other account that the financial institution offers or maintains for which there is a reasonably foreseeable risk to customers or to the safety and soundness of the financial institution from identity theft, including financial, operational, compliance, reputation, or litigation risks. Take note. The definition includes a margin account as an example of a covered account. Also included is a brokerage account with a broker-dealer or an account maintained by a mutual fund or its agent that permits wire transfers or other payments to third parties. Investment advisors who have the ability to direct transfers or payments from accounts belonging to individuals to third parties upon the individual's instructions, or who act as agents on behalf of the individuals, are susceptible to the same types of risks of fraud as other financial institutions. SEC Regulation SID deals with identity theft protection duties of financial institutions. Although not normally included in the definition, when an investment advisor has the previously enumerated powers, for purposes of the regulation, it is a financial institution. Individuals who hold accounts with these investment advisors bear the same types of risks of identity theft and loss of assets as customers holding accounts with other financial institutions. If such an advisor does not have a program in place to verify investors' identities and detect identity theft red flags, another individual may deceive the advisor by posing as an investor. It is required that each financial institution that offers or maintains one or more covered accounts must develop and implement a written program designed to detect, prevent, and mitigate identity theft in connection with the opening of a covered account or any existing covered account. These provisions also require that each program be appropriate to the size and complexity of the financial institution and the nature and scope of its activities. The program must include reasonable policies and procedures to identify relevant red flags for the covered accounts that the financial institution offers or maintains and incorporate those red flags into its program, detect red flags that have been incorporated into the program of the financial institution, respond appropriately to any red flags that are detected to prevent and mitigate identity theft, and ensure the program, including the red flags determined to be relevant, is updated periodically to reflect changes in risks to customers and to the safety and soundness of the financial institution or creditor from identity theft. Identity theft red flags. Following is a list of some of the most common warnings that firms should include in their identity theft programs as is appropriate to the nature of the firm's business. Alerts, notifications, or other warnings received from consumer reporting agencies or service providers, such as fraud detection services or a notice of credit freeze in response to a request for a consumer report. Presentation of suspicious documents, such as documents that appear to have been altered or forged. The photograph or physical description on the identification is not consistent with the appearance of the applicant or customer presenting the identification. Presentation of suspicious personal identifying information, such as a suspicious address change, unusual use of or other suspicious activity related to a covered account, notice from customers, victims of identity theft, law enforcement authorities, or other persons regarding possible identity theft in connection with covered accounts held by the financial institution. Personal identifying information provided by the customer is not consistent with other personal identifying information provided by the customer, e.g., there is a lack of correlation between the SSN range and date of birth. Personal identifying information provided is of a type commonly associated with fraudulent activity, as indicated by internal or third-party sources used by the financial institution. For example, the address on an application is fictitious, a mail drop, or a prison, or the phone number is invalid or is associated with a pager or answering service. For financial institutions that use challenge questions, what is the name of your first pet, etc., the person opening the covered account or the customer cannot provide authenticating information beyond that which generally would be available from a wallet or consumer report, and mail sent to the customer is returned repeatedly as undeliverable, although transactions continue to be conducted in connection with the customer's covered account. Please note, this is not meant to be an exhaustive list. Your firm will make you aware of its program and the specific red flags they are addressing. The exam is more concerned about concept than an actual list, although you should be able to recognize obvious patterns of misuse in an account. Practice question. A great concern to broker-dealers is the theft of the identity of a client. To reduce the possibility of a client's assets being improperly taken, most firms would consider all of these to be a red flag except A. Almost 1 year since your last contact with your client, you receive a phone call requesting that funds be wired to an offshore account. B. A client regularly visits your office to pick up a check representing the proceeds of recently settled transactions. C. When running a credit report on a new client's applications, there is a discrepancy between the home address listed on the report and the one on the new account form. D. The photograph on the identification documents provided does not resemble the individual opening the account. The answer is B. There is nothing wrong with a client picking up a check for the proceeds of a securities transaction, even if done on a regular basis. Some folks do not trust the mail. Each of the other choices should raise a red flag as being something needing further investigation. Methods for protecting the firm and its customers. What are the methods of authentication used by customers or employees to access electronic data storage devices, which allow access to client communications, client information, or both? Single-factor authentication, e.g., ID/password. Dual-factor authentication, e.g., key fobs, secure ID. Adaptive factor authentication, e.g., challenge questions. Biometric authentication, e.g., fingerprint scan. Antivirus software installed on electronic devices used to access client information. Some questions to ask regarding the security methods used include the following. How often are updates downloaded to antivirus software? Does your firm utilize encryption on its files or devices? Does your firm utilize online or remote backup of electronic files? Does your firm allow remote access to servers or workstations via a virtual private network, VPN, or similar technology? Does your firm use free cloud services such as iCloud, Dropbox, or Google Drive to store personal and confidential client information? Does your firm utilize your firm's website to use or access client information data? Does your firm's website include a client portal? What controls are in effect for third-party vendors to ensure they protect your customers' information? Does your firm require protection of customer information held by vendors after the relationship with that vendor has ended? As you can see from the many questions posed, protecting data is not a simple issue. Although the decision as to what will be used and how it will be used is that of the firm, agents must be aware of the tools being employed and how they work. That is why so much emphasis is placed on initial and continual training. Privacy, Regulation SP. Regulation SP, mandated by the Gramm-Leach-Bliley Act, requires that firms take identity theft seriously and have adequate safeguards in the form of privacy policies to protect non-public personal information from unauthorized access or use. Member firms must provide an initial privacy notice to new customers when an account is opened and must provide an annual privacy notice to all customers. Regulation SP permits firms to disclose non-public personal information to unaffiliated third parties unless the customer has elected to opt out of the disclosure. Examples of non-public personal information include a customer's Social Security number, account balances, transaction history, the fact that the individual was at one time a customer, and any information collected through a consumer reporting agency or an Internet cookie. Furthermore, the regulation requires that the customer be given 30 days to opt out before disclosure of non-public personal information may be made. Take note. An Internet cookie is created with a view that allows the member firm to collect information about the customer and is an example that illustrates one of the many ways that any financial institution may obtain information about a consumer in connection with providing a financial product or service to that specific consumer. If the information is not specific, it is known as blind data or aggregate information that contains no personal identifiers. It is not deemed to be personally identifiable information and therefore not subject to Regulation SP requirements. Regulation SP distinguishes between a consumer and a customer. A consumer is an individual who obtains a financial product or service from a firm and has no further contact with the firm. A customer is an individual who has an ongoing relationship with a firm. Consumers are given an initial privacy notice only, while customers must be given both an initial and annual privacy notice. Only individuals, not businesses or institutions, are covered by the regulation. Regulation SP also requires members to adopt policies and procedures that provide adequate safeguards of confidential customer information and records. Not a month goes by without a headline of a major break in security at a large company. Technological advancements, such as public access Wi-Fi, present many confidentiality issues for firms. Among the many security concerns is that data are broadcast out into the airwaves, making interception easier. Wireless connections present an attractive mechanism for hackers to tap into the user's workstation to gain access to the corporate network. Before permitting employees to access customer information remotely, members must implement and update appropriate measures to secure customer information. These measures may need to go far beyond a firewall and off-the-shelf defensive software to stay ahead of criminals who want to access your systems. Take note. Reasonable opt-out methods available to members include providing a reply form with the opt-out notice, an electronic means to opt out if the customer has agreed to the electronic delivery of information, and a toll-free number that customers may call. The SEC has stated that members are not providing a reasonable means to opt out if the only method to do so is by writing a letter to the member. Knowledge Check 8.2. Question 1. Protection of customer confidential information is an obligation of the Roman numeral 1. Agent servicing the customer's account. Roman numeral 2. Broker-dealer maintaining the account. Roman numeral 3. Customer. Roman numeral 4. Investment advisor in an advisory account. A. INP. B. Hamanfui. C. Funuvui. D. I. Funju. Funuvui. The answer is D. Although any securities professional handling a customer account is obligated to follow all necessary procedures to protect client data, customers themselves also bear a responsibility. Customers ignoring the cybersecurity safeguards put not only their own data at risk, but also that of other customers by potentially opening the door to hackers. Question 2. A broker-dealer's cybersecurity procedures should address all of the following except A. The music played while customers are placed on hold. B. Office desktop computers. C. Agents' personal smartphones used on occasion to communicate with clients. D. Remote access to servers or workstations via a virtual private network, VPN. The answer is A. It is hard to imagine how the music on hold would present a security risk. All of the others clearly offer potential for loss. Question 3. Potential cybersecurity threats can come from Roman numeral 1. Agents using social media to communicate with customers. Roman numeral 2. Weak passwords. Roman numeral 3. Allowing employees to take office laptop computers home. Roman numeral 4. Infrequent updating of antivirus software. A1 and 2. B1 and 3. C2, 3 and 4. D1, 2, 3 and 4. The answer is D. Cybersecurity threats can come from almost anywhere that digital media is used. Question 4. The regulators are concerned when broker-dealers or other financial professionals maintain what are referred to as covered accounts. Which of the following customers would not be included in the definition of a covered account? A. An individual margin account. B. A corporate cash account. C. A checking account. D. An IRA. The answer is B. Business accounts are excluded from the definition of a covered account because those are much less likely to be the subject of identity theft. Any form of individual deposit account, one where the individual deposits funds, would be a covered account. Question 5. Under Regulation SP, if an investment advisor sends a customer an initial privacy notice that contains an opt-out provision, the firm may not disclose non-public, personal information about that customer for how many days from the mailing? A10, B15, C20, D30. The answer is D. An investment advisor or broker-dealer must give a customer 30 days to implement any opt-out provision in the privacy notice.